And we are recording.
Okay, let's call this meeting to order at 4:05 p.m. Please call the roll.
Member Hensy?
Present.
Member Hensy present. Member Yankee?
Present.
Member Yankee present. Member Highland?
Present.
Member Highland present. Member Schmidt?
Present.
Member Schmidt present. Member LaHood?
Present.
Member LaHood present. Member Wong?
Present.
Member Wong present. Chair Wolf?
Present.
Chair Wolf present. We have a quorum.
Great.
Shall I read the preamble?
Yes, please.
Remote access to information and participation. In accordance with Governor Newsom's Executive Order number N3320, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London and Breed's proclamation declaring a local emergency issued on February 25, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health Officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process.
Okay. And meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. Okay, let's go for agenda changes. We have a couple of agenda pertaining items. The first one is there was an item that was left off of this meeting that needed to be dealt with regarding the release of information based upon a request. A sunshine request to the full task force, its members, and the chair and the administrator, and I believe also legal counsel. Upon some thought around this, we had decided to put it on today's agenda. That for some reason didn't make it onto the agenda. We're going to need to have a special meeting because we had already asked the requester for an extension of time till this meeting. It's been a couple of weeks now, and this issue needs to be dealt with, and we have to deal with it by taking some action. So the soonest we can meet next would be Monday. It'll be a one-item special meeting. And I'm wondering if we could get a quorum on Monday, either late afternoon or early evening for this. It shouldn't take more than an hour, if that.
Chair Wolf,
Yes.
I am available from 4 to 6, but I have another meeting starting at 6.
Okay.
And I'm not available till 5 on Monday.
You're not available, or you are available?
I'm not available until 5.
Till 5. Okay.
I'm not available until about 6:30.
Okay, so it's not going to work on Monday. What about Tuesday?
I think. Are we talking about the same time frame?
No, pick a different time.
Well, I'll say for me, it's pretty much about, I get home usually about 6:30. So
Okay.
I don't know if that works for anyone else.
That's
I'm
fine.
available.
If that's,
I'm
go ahead.
available Tuesday and Thursday next week.
Thursday?
Tuesday and Thursday, anytime from 4 o'clock on.
Okay. Jen, Dean, Chris?
How about Tuesday, 6:30?
That works for me too.
That also works for me.
Okay, so
Tuesday.
Tuesday at 6:30.
This is now scheduled for Tuesday at 6:30.
Correct.
Do we have everybody's agreement?
I think
Yes,
so.
yeah,
Yes.
just took a straw poll for quorum. So I'm now calling for that meeting, and we'll get an agenda out tomorrow for that. Okay, great. The second item we have on this is we're having multiple items on the agenda today for more than two, as per our policy from the same requester. We're going to need a approval from the task force to waive the rule, the complaint procedure rules to allow this.
This is Lila. I make a motion to waive the complaint procedure rules and to allow us to hear more than two items from one person at today's meeting.
I'll second.
Moved by member LaHood, second by member Hensy. Any discussion? Seeing none, let's open it for public comment. Any public comment? Any public comment? You can unmute yourself by pressing *6. Any public comment? Last call for public comment. Seeing no public comment, please call the roll.
Member LaHood?
Aye.
Member LaHood, aye. Member Hensy?
Pardon me, I wasn't ready. Aye.
All right. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to have the same complainant have more than two cases on the agenda has passed.
I found my gavel. It was a gift. Okay, that motion passes. Thank you very much. Now, for the rest of the agenda, is there any changes or adjustments to the agenda at this time? Go ahead.
I was going to say, we have to discuss file number 19121, which was requested by the respondent to be heard early because he has a meeting he has to go to.
Okay,
So we
great.
need to
Thank you
discuss
for
that.
reminding me of that. Yeah, thank you for reminding me of that. Are both the parties here?
For 19121,
Yes.
the petitioner is here.
Okay, is the respondent here?
Yeah, Sergeant Youngblood from the Police Commission is here.
Okay, great. So the request is to move item 19121 to the top of our agenda, making that item number 4. And then moving the rest down one number.
And is this because of the police commission meeting?
Correct.
Yes, it,
Okay. Then I'll move to make that. I'll move to make that change.
Okay. Is there a second?
I'll second.
Moved by member Hensy, second by Vice Chair Yankee. Any discussion? Okay. Any public comment? Calling for public comment. Please press *6 to unmute yourself. Last call for public comment. Okay, seeing no public comment,
Shall I call that item?
I'm trying to decide whether this is a substantive or a kind of simply procedural. Mark, I'll ask you. Is this substantive or procedural? Can we take it by...
I think you're fine.
Okay, so let's... all those in favor say aye.
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 All those opposed? Okay, so the motion passes. Okay, so we'll take that item first. All right, so let's move to any other changes for the agenda. The only additional thing I will be calling for a recess at about 6 o'clock for about 10 minutes. Just give everybody ability to stretch and have a potty break. And if we exceed 2 hours thereafter, we'll call for another 10-minute break every 2 hours. Okay. Okay, let's move to item number 2.
Item number 2, approval of the minutes of the Sunshine Ordinance Task Force December 2nd, 2020 meeting. I already noticed an error, which I am happy to point out to the task force. I'm sure you've all seen it.
Can you point it out?
Oh,
Can you
all right, I
point
will.
it out? Yeah.
Yeah,
For the record.
early in the public comments, I put in Mr. Hillier's name and forgot to add what it was he said. I have notes on that. I just realized it, and I will take care of that tomorrow. So that's the only thing I saw on the minutes.
Any other changes or adjustments to the minutes? Nope. Okay, so let's get a motion on the floor, and then we'll get public comment for any additional changes.
Sure, I'll move to approve the minutes.
I'll second.
Can we
So,
do
moved
that as
by-
amended? Approve as amended so that we can make the correction.
Approve as amended, yes.
Approve as amended unless we hear some other ones from the public. So moved by Vice Chair Yankee, second by Member Wong. Now let's open it for public comment. Any public comment,
Yes, public
please?
comment.
Okay, go ahead.
Hang on.
Start the clock.
Yeah. Hang on. Go ahead, sir.
Good evening. This is Anonymous. It's a correction to the same item that the clerk pointed out. So on item 2, it's Anonymous stated the annual supervisor records report is false. I believe what I stated is I stated that I made a comment in the November meeting minutes that the annual supervisor records report is false, and that comment was not reflected in those minutes, and that needs to be corrected both in that minute and in this minute where I commented that the previous comments were wrong. Thank you.
Public comment on the minutes. Okay, seeing no further public comment. Will the maker and the seconder accept that further adjustment?
Absolutely.
Yes.
Okay. Cheryl, please add that to the list.
Yeah, I've already written in my
Items
notes.
corrected. Thank you. Okay, let's call a roll.
Member Yankee?
Aye.
Member Yankee, aye. Member Wong?
Aye.
Member Wong, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to accept the minutes as amended with corrections has passed.
You can add me too, Cheryl. Aye. Dean
Didn't I
Smith.
call your name?
No.
Oh,
That's all right.
I apologize.
No problem.
Okay, let's call the public comment will come at 5 o'clock. So let's start with item number 4.
The new item number 4. Item now number 4, not number 9, file number 19121, complaint filed by Anonymous against the Police Commission for allegedly violating Administrative Code Section 6721B, K, 26 and 27, failing to respond to a public records request in a timely and or complete manner, failing to comply with the California Public Records Act, failing to keep withholding to a minimum, failing to key redactions by footnote or other clear reference to justification, and failing to cite legal justification for withholding.
Okay. All right. CAC Chair LaHood, anything to report or summarize for us?
Yeah, we found jurisdiction. One of the key issues in this case is justifying justifying withholdings and redactions item by item is the key part of this case.
Okay, great. All right, so let's get our process rolling here. Cheryl, you ready with the clock?
Yes, I am.
Okay, great. So we have both parties here. We're going to hear from the petitioner first. Anonymous, are you ready?
Yes, I am. Let me know when I may begin, please.
You may begin, sir.
Thank you very much. Good evening, task force members. This is case 19121, Anonymous versus the Police Commission. It's still at item number 9's attachment, so if you could go to page 6 of the PDF or footer page P1682. Unfortunately, it looks like my actual presentation that I made more recently hasn't been included. It's an older version, so I'll just have to make some corrections here. So in September of 2019, I made an immediate disclosure request to each commissioner and the secretary of the Police Commission for certain records regarding Jeff Adachi and Brian Carmody. And they gave a timely non-IDR statement on September 11th. Then from September 18th to October 4th, they gave rolling responses. That's all from a timeliness perspective just fine. At the time, they withheld documents. They did not justify their withholdings in writing as required by 6727, and their redactions did not have any footnotes or other clear references to justifications as required by 67.26. On November 9th, I filed this complaint and a supervisor of records petition. On December 3rd, the commission admitted to the task force that approximately 40 of the alleged, I think there were 50 redactions that I alleged were not exempt, were in fact wrong, and they corrected some of them. I'm going to try to keep this short because I don't think there's much in dispute in this case. You can see the request excerpt at the bottom here, but if you could go to the next page. I mean, as the compliance chair said, the issue is here, they did not justify their redactions in writing, nor did they provide a footnote or other clear reference. After the complaint, they did do so for some of their redactions. I think they told you at the committee, initial committee hearing that at the time they weren't trained properly. They have gone through retraining that where now they do this after my complaint. And so if you look at the bottom here, what they do is, as required by law, every redaction has a number to an index, but that's a later request. That wasn't this request. And so their training seems to have been correct now after they were retrained. But I just wanted to point something out here that's very interesting. 6726 says during the exemption review process, you have to go through and log why you're redacting each redaction. And that's really important, and this request is proof of that. Of the 50 withholdings I challenged, 40 were admitted to be incorrect by the commission. And I believe this is what happens when city agencies don't go through and make sure they have a lawful justification for their redactions. And when you're forced to think about why you're making a particular redaction, you're less likely to be either sloppy or malicious in trying to hide information from the public. If you go to the next page, yeah, see the rest of my presentation is cut off here. The issue here is this is not a metadata complaint. The police commission produces the metadata just fine. The issue here is that they also produced what you have held against the police department are not actually, they're not copies of the emails I requested, right? So if I request a particular email between two persons, and they take the body of that email, forward it to somebody else, and then produce a copy of that email, that's not a copy of the original record. And that's because when doing that process, you will modify some parts of the email. And so I believe those are the only two things still at issue in this. I will ask, I guess the rest of this is cut off somewhere. I will ask that you find a violation of 6726 for both non-minimum withholding, because as they've admitted, some of the information was now non-exempt, and also a violation of 6726 for not keying all redactions by a footnote or other clear reference to justification, 6727 for not providing a written justification for withholding, and I believe the way you worded the police department is 6721B for not providing a copy of the original records. I don't think the rest of my presentation is in here, so I'll leave it at that. I don't think there's a lot complicated in this complaint. Thank you.
I'd just like to interrupt for one quick moment. This is Victor Young. I just want to let the members of the public and participants know I'm going to mute all the lines in order to get rid of the background noise. When it is your turn to speak, you can press *6 to unmute your line. We're just trying to clean up the line so everything is clear. Thank you very much.
Thank you, Victor. Sorry. Any persons or witnesses to provide any facts or evidence on behalf of the complainant petitioner? Okay, hearing none. Respondent, you have 5 minutes.
You ready? Go ahead.
Please give me one quick moment. I may have muted them, and they may need some time to press *6 to unmute themselves. So if you are the petitioner, please press *6 to unmute.
Okay. I think I'm unmuted. Can you hear me?
Are you the respondent, sir?
Yeah.
Okay. Okay, I'm ready whenever he is.
I'm ready. I really have nothing more to add to
Hang on.
that I... Oh.
I want to give you time. You've got 5 minutes, sir. Go ahead.
I really have nothing to add other than what I've already said.
Okay. That sounds like the end of the testimony. Are there any persons or witnesses providing any facts or evidence on behalf of the respondent? Okay, hearing none. Members, this is the time for questions and clarifications about what's been presented and the testimony. We'll get to deliberations about arriving to a conclusion after rebuttals. I have a question for the petitioner. You mentioned something about about the log. Did they provide a log for this request, or are you saying that they didn't?
They provided no log when their request was complete, and even after I filed the complaint, they only logged the ones I challenged instead of all of the redactions, which is required by 6726. But that is true. There is no log in this particular request.
Okay, thank you.
Chair, I have a question for the respondent.
Go ahead, Member LaHood.
Yes, just to verify, we heard from the petitioner that with additional training that your department is handling things differently and in his estimation well in terms of logging and justification. I'm curious about the point regarding copies of original documents. Have you changed what is your current procedure for providing copies rather than forwarding emails?
So when we get emails, when we get requests for emails, however the email is, or I should say, however the request is worded is how it is forwarded to the police commissioners. So if it says that they want metadata, they don't want it forwarded, that verbiage is sent to the commissioners, and then they are responsible for providing myself the responsive document. However that they send them to me is how I present them. So if they forward it to me, that's what I get. I have no way to go to their computers and create these for them. I have to rely on the police commissioners to give me the responsive documents however they are worded. So I do follow up with them on how they can send it to me and try to walk them through it, but however I get them is pretty much how I have to present them.
Thank you. I appreciate that clarification.
Sure.
Any other questions or clarifications? Okay, let's move. Are we ready for rebuttals? Okay, hearing no objection, let's move to rebuttals. Respondent, you have 3 minutes for rebuttals.
Hang on a second. Go ahead, respondent. Respondent?
Sergeant Youngblood? You lose him?
Yes, I'm sorry. Can you repeat one more time?
We're ready for rebuttals.
All right, let me stop
I
the
have
clock
no
and
rebuttal.
start it. Let me stop the clock. Sergeant Youngblood, are you ready?
I'm ready.
Okay. Go ahead, sir.
I have no rebuttal.
Okay, thank you. Moving to the petitioner. Do you have any rebuttals?
Thank you very much. I'll keep it very short. I'm not asking you to find a violation against Sergeant Youngblood. Personally, I think he, on his own, does a pretty good job, so I understand that the commissioners themselves may not know what they're doing, but at the end of the day, it's about the police commission as a legal entity, regarding, maybe once they, and the police commission has in the past, been responsive to once you issue an order of determination, then they look at it seriously, and then they might try to figure out how to properly comply with these requests. So I will, I'll just ask you to please find a violation of the police commission as an entity, no individual respondent, for a violation of 6726 for failure to keep withholding to a minimum, 6726 again for failing to key redactions by footnote or other clear reference to justification, 6727 for failing to provide written justification for withholding, and 67.21b for failing to provide a copy of the original record. And then order the police commission to comply under 67.21e and refer the matter to compliance. Thank you very much.
Okay, members, time for deliberating and arriving to some conclusion.
Let me just throw out the one part of what the request is that I'm having some question in my mind about is the originals of emails, because in the context where the the person who is collecting everything has to go to commissioners and ask them for whatever can be received from them, and they give what they believe is responsive. I'm not sure if there's any evidence that originals could have been produced. Other than that, I'd vote for a motion to grant the petition with regard to the first, I think, 3 out of 4 items.
Okay, you're going to have to be a little more specific about what those 3 or 4 items are, and to which code sections, or is that what you're referring to?
No, I think anonymous, the petitioner, he asked for 4 types of violation in sequence, and I am just, all I'm questioning is the last one, which is about copies or copies of originals of emails, and that's the only one that I have any issue with. But everything else, I just want to say I'm fine with what he wants.
Okay.
Chair Wolf?
Yeah, Member LaHood.
So one thing I'd like to note in this situation, and I don't know if we would want to include this in our order of determination, but it does seem as though the respondent made an effort afterward. They've changed their procedures, and I think it might be worth noting that we are finding violation, but we would like to recognize that a change in procedure, we would like to recognize that they've changed their procedures to avoid this happening in the future. I do think the not providing copy of original records is worth noting. I think this becomes another training issue because there are ways to make copies of emails within different email clients. I guess the problem is, and I understand this, but not everyone is necessarily, I guess I don't know if they are required to use the exact email system. The instructions might be different depending on that, but clearly there are ways to do it. It does become another layer of training, but it's not, given everything that's come up recently regarding metadata, it's not a non-issue. And I do have the list of citations. I don't know if you want me to read those or if we're still discussing things.
You're still just discussing. And I have to recognize that Member Schmidt made a motion. No, you didn't make it. You're thinking about it.
I didn't make a motion.
Okay.
I was just discussion.
Okay, great. So, Member LaHood, if you want to do that, you can. Otherwise.
So I could make a motion to find a violation of 6726 for not keeping withholding to a minimum. Also 6726 for not keying all the redactions. 6727 for not including written justification of all withholding. And then 6727B for not providing copies of original records. I would also like for us to include in our language, if you think it's appropriate, for the order of determination, recognizing that the department has changed its procedures to avoid these issues happening in the future. I don't know if that's appropriate or not. I think it would be good to include because while it identifies problems, it also identifies the finding of solutions, which I think is something we want to encourage.
Well, I guess the question is, it's really more about chronology.
Yeah.
If we were to, at the time that the request was made, was there evidence that a correction had been made, for other things? I mean, I would just be a little cautious about that, and it probably be better in a more recent case where that is actually happening to make that notation. But I agree with your sentiment on it, and I'm just not sure if I guess you can just state as reported by by the petitioner. You could
both the petitioner and the respondent, right? As recorded.
If you want to note that for the quote unquote for the record,
yeah.
I think that might be okay. I'm just thinking out loud here a little bit about, what may be the appropriate place to make that recognition.
Yeah, and if not in the order of determination, we are discussing it here, in this public meeting, and I think there's value in that.
Okay, great. You can make a second motion if you want to make that an independent notation.
Why don't we just go with the
flexible.
first motion and then listen to what other task force members have to say?
Okay, so we have a motion on the floor from Member LaHood to find in violation of 6726 for not withholding to a minimum and for not keying the redactions, 6727 for not providing written justification for the withholding, and 6721B for not providing a copy of the original document.
Is it 21B or E is an egg?
B is in boy.
Okay,
Bravo.
Okay.
Is there a second to this motion?
I'd be happy to second that motion.
Okay, it's moved by Member LaHood, second by Member Schmidt. Is there any further discussion from members on the motion to find these violations? Okay, seeing none, let's move to public comment. We'll take public comment from all except the parties and any of the witnesses. Please unmute yourself by pressing *6, and I'll hand it over to Cheryl to run it.
Do we have a speaker? Do we have a speaker for public comment?
Any public comment?
Motion?
Okay, seeing no public comment, are we ready for a vote? Please call the roll.
Second. Member LaHood?
Aye.
Member LaHood, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Hensy? Member Hensy?
You're mute.
Aye. Sorry.
Great. It's all right. Member Hensy, aye. Member Highland? Member Highland? Okay, Member Highland is not responding. Chair Wolf?
Aye.
Chair Wolf, aye. Okay, I just want to make sure I got this motion correct. 6721B for not providing original records. 6726 for a violation of withholding being kept to a minimum. And 27 for not including written justification for withholding. Is that correct?
No, for 6726, it's for not keeping withholding to a minimum and not providing keyed redactions. Key for the redactions.
And not providing. Okay.
And Member Highland votes aye, by the way.
Okay, great. Okay, great, you're here. All right,
And then
great.
Call me. I don't think that you called me.
I think I did. Chair
No.
Wolf?
Aye.
Okay,
Item passes.
correct.
Okay. All right, well, that was done pretty early. Let's see, what about the next one? And thank you, parties. So let's go to what now is item number 5 for 19058. Let's roll with that. and then we'll take general public comment after.
Are we ready?
Yeah.
Are we ready? Okay. Item number 5, file number 19058, complaint filed by Robert M. Smith against the Fine Arts Museums in San Francisco for violating Administrative Code Section 6725 by failing to respond to an immediate disclosure request in a timely and/or complete manner. The preamble is a task force found that the Fine Arts Museums violated Sunshine Ordinance Code Section 6725 by failing to respond to an immediate disclosure request in a timely and complete manner. The SOTF continued the matter and requested that the SOTF city attorney provide advice regarding the relationship between the corporation and foundation of the Fine Arts Museum.
Okay, thank you. So this is a continued item, and at long last, our request to the our legal counsel to provide some insight, investigation, and advice with regards to the relationship between these three entities of this case is finally arrived. So I'm going to hand it over to DCA Price Wolf to lead discussion, I guess. Is that okay?
Sure. Yeah. I'm happy to answer any questions. I didn't really have much to present today other than sending the memo. Happy to answer any questions you might have about it. I was asked to, look at the relationship between COFAM, FAMSF, and the foundation, and within the context of the outstanding complaints that Mr. Smith has. So sort of just described, what I could uncover about the history of the organizations and what I could uncover about how they're funded, and made some conclusions based on that, and whether which of the entities would be considered a public entity subject to the Brown Act and the Sunshine Ordinance. And the conclusion there was that FAMSF is a policy body subject to both the Brown Act and the Sunshine Ordinance, which I don't think there's too much of a dispute about. And then also based on analysis of case law and the statute, just my advice is that COFAM and the foundation are not policy bodies under the Brown Act and the Sunshine Ordinance, so it wouldn't be subject to those laws. I can answer any specific questions that you might have. It's a big, lengthy memo, so I'm not going to go into the details of it.
Anybody? So I've got a couple of questions. One is, COFAM and the foundation are they contracted by FAMSF?
I think some of these questions are best asked to the party when because they're going to give you the actual answer based on the facts. I can tell you what my own Google research found, and my Google research found is that there's a MOU between entities. There's no contract that I could find, but that doesn't mean it doesn't exist. But I only found an MOU.
Well, the reason why we're doing this is because the answers that we were getting from FAMSF were not satisfactory to be able to reveal what the actual relationship of COFAM and the foundation is. Both of those provide direct services to the museums by contract. MOU is a contract in the eyes of the city. And because they actually provide on-site direct services for some. I think one was for docent and the other was for fundraising, I believe. It could be, maybe it's been a while, but I believe that's the case. The question then becomes is what is their relationship to the city? And at that point, are they then subject to sunshine under 12L, or are they subject to sunshine as a contractor, which would be could be different sections of the ordinance?
Right. So the memo goes through that, and it does talk about, from what I was able to uncover with the finances, it looks like both COFAM and FAM and the foundation are subject under 12L. Because the way it concluded that was 12L requires there to be this agreement as well as at least $250,000 of funding from the city. And it looks like the funding of COFAM and the foundation are so commingled by this one financial disclosure that I cited, by an audit that was conducted of FAM, the foundation, and COFAM. They seem to admit that, you know, the money is pretty much commingled between the entities. So I think it's fair to say that this, and I think the city gives over, that was like close to, gosh, I'm blanking right now, 16 million, I think, to the entities. So that's why I concluded it was subject under 12L.
Sure, Wolf.
Yeah, member.
So, DCA Pricewolf, just to simplify an obviously not simple situation. So, COFAM and FAM-F are both subject to 12L, but COFAM is covered by the Brown Act because of the overlap between the FAM-SF and COFAM boards. So anytime COFAM is meeting, FAM-SF is essentially meeting. And so they have to comply with the same, with the Brown Act in the same way.
So I'd say that's like 90% there of what I was conveying. That's yes, and then here's the small caveat. It's not that they're, as an entity, going to always be considered subject to the Brown Act, but that meeting, the actual meeting where there is overlap, that's subject to public meeting laws, right? So like it has to be noticed, an agenda, and it goes through all that. It doesn't mean all of a sudden, because there's overlap at that meeting, everything else that they do is going to be subject to the Sunshine Ordinance and Brown Act. Do you get the distinction I'm making? It's kind of nuanced, but I think it's pretty important.
Full board meetings of COFAM are subject to the Brown Act because of the overlap with FAM-SM.
Precisely.
Okay, go ahead, Mr. Schmidt. Go ahead.
Yeah, a couple questions, and I appreciate the pretty comprehensive memo, DCA. I guess my questions go to, I want to see if the scope of your memo included or didn't include or wasn't intended to include a couple of, say, sub-issues. And they're two very close sub-issues. And I'm pointing at the CPRA as opposed to the Brown Act. Did you feel that there was a question about whether the foundation and COFAM had obligations under the CPRA, whether that was an issue that you were looking into? And the related issue would be, did you consider that whether FAM itself had any obligations under the CPRA to make an effort of any kind to effectuate the production of documents by those two other entities, COFAM, the foundation?
So I'll take your first question first. You know, if there's a particular section of the CPRA that you're curious about, like we can talk about that. But like on a on a threshold level whether the CPRA applies. I don't have my notes on that in front of me. I think it was the same sort of threshold question as the Brown Act, whether it's like a policy body or, and I know the Sunshine Ordinance has a slightly different, I'm sorry, whether it's a legislative body or a policy body under the Sunshine Ordinance. So for that purpose, I felt that there was no need to really delve into the CPRA. The Brown Act, I felt, didn't apply to COFAM and the foundation, and neither would the CPRA as entities. So to your second question, let me see if I can repeat it, understand it. Just correct me if I'm wrong.
I'm sorry, I'm sorry to interrupt, but
no, please.
Just because that first question, you just said that you felt like it doesn't apply because they're not legislative bodies, policy bodies. Which of those was it? If that's the reason why you thought CPRA has no, or you either you weren't looking into it or you decided that CPR doesn't apply because they don't qualify as that kind of body.
Yeah, it's the latter. I'll have to pull up my notes specifically, but I remember making like there was significant overlap with how the Brown Act identified whether it's going to be an applicable body and how the CPRA identified it.
Okay. Thank you.
I didn't. I mean, as you can see, I didn't really fully go into that.
Okay. Then go ahead with the second similar issue, CPRA again.
So let me see if I get this straight. So you're asking is what are the obligations of FAM SF when a public record request is made to FAM SF with respect to the documents that COFAM might have and the foundation might have? Is that what you're asking?
Yeah, I'm asking if you know the answer to that.
Sure.
I'm asking you about that, and maybe that's not something that you felt was in the scope of what was requested. So it's sort of somewhat the same question in two ways.
Yeah, so let me answer that in two ways. The first way is to say, look, there are three separate entities. So AMSF is this policy body that's subject to the public records laws, and COFAM and the foundation are both private nonprofits. So in this instance, there were multiple Sunshine requests made to FAM-SF. Now, to the extent that FAM-SF just normally has these documents in their file cabinets or drawers or however they keep their documents, they're in possession of them. And if they're responsive, I'd say they have an obligation to turn them over, just as if you had, in your drawer documents that are responsive, even though they might be on letterhead of another agency or something, you're in possession and control of them and you turn them over. So to that extent, yes, but I don't think FAM-SF has an obligation to then turn to COFAM and say, give me all the documents you have, right? They're three separate entities. So in other words, you can't backdoor a request to COFAM by asking FAM-SF for all of the things.
So it's a sort of possession. What you're saying is you think it's a possession and control standard.
Correct.
Okay. That's all I have for now. Thank you.
Sure.
So I have to, I have to kind of go back to 12L here, because that's exactly what 12L requires. That if the contracting agency to a nonprofit organization, that they actually are the kind of the arbiter of what documents get released or not. All documents that are pertaining to the contract are public documents. because they have a contract with the city. And the word contract, and I'll read it, contract, this is under 12L.3 definitions under C. Contract, quote unquote, shall mean an agreement, however titled, comma, including without limitation a memorandum of understanding, close parenthesis, to grant or otherwise provide funds to a nonprofit organization, including funds from another governmental agency administered through the city or any city commission, city board, city agency, or city department for such organization's operation, organizations as in plural, possessive, organization's operation, new or existing programs, events, performances, capital improvements, or for goods or services provided by or through such organization to all or any portion of the public. Contract shall not include, subparagraph 1, an agreement to provide goods to the city pursuant to bids or requests for proposals where the city is the end user of the goods, or subparagraph 2, an agreement to provide services or benefits to city employees and or their family members, dependents, or other designated beneficiaries. Under that definition, this MOU is in fact a contract.
Yeah, absolutely. Yeah, I agree.
12L.
That's why I said 12L applies.
Oh, 12L does apply. Okay, great. So under 12L then, with regards to public access to records, it doesn't mean that the agency actually has the records that the contractor, or this in this case, COFAM or the foundation, has possession of. They are required to provide certain records up front that are always publicly available, but anything that is asked for that is not currently provided, it's up to the agency to be the go-between for that. And if the requester is not satisfied with the agency's response, then they're able to come to us for review, as in 12L.5B, or actually all of 12L.5. Do you agree with that?
You lost me a little bit. I'm not sure what point you're trying to make.
Okay, so the point I'm trying to make is the issue here is that the petitioner, Mr. Smith, was requesting documents and information from these entities, okay? And the entities had denied, they withheld that information, saying that they're private nonprofits, that they don't have to provide it. And so as the case proceeded, it was found that there was this MOU, or these MOUs, and that in fact they should. It wasn't clear though as to what relationship they had with the city. So that's why we made the inquiry, because we could not find it just by our own means. So that's why we requested you or your office to help, kind of weed this out, which you have, very well. The question now becomes, under what rules does COFAM and the foundation have to comply with? Do they comply with the terms of the Section 67, or to the terms of Section 12L?
Yeah, and my opinion is 12L.
Okay, great. So let me stop there. Let me turn to the members. Members, What are your thoughts about all this at this point? So we can move on this. And if you have any other deeper questions for folks that weren't part of this case beforehand, Member Schmidt and Member Wong, then please feel free to ask questions. Go ahead, Member Vice Chair Yankee.
Yeah, I did a question. Maybe you could talk a little bit more about. I think you mentioned somewhere in the memo about the sharing of the email system, and if it sounds like if the nonprofits are utilizing the email system of the entity that is subject to the Sunshine Ordinance, then those records obviously going through that system would also be. Is that correct?
I don't know. I didn't look into the like server where emails are kept, and whether if CoFam used the same server as FAMSF, if that would suddenly make them FAMSF records. Is that sort of what you're suggesting?
Yeah, I'm just curious. So at what point would it trigger if they're doing some type of sharing of email systems? At what point, if those records are somehow touching that shared system, would that then make that a disclosable record under the Sunshine Ordinance, separate from 12L?
That's a tough one. I mean, I don't think it would suddenly turn CoFam into a policy body or legislative body, but I think what you're getting at is, would those records suddenly become FAMSF's records, right? Such that
let's say I'm a trustee. Yeah, I would say so. Let's say I'm a trustee of CoFam, and I'm using my email, and I send an email out and it has a bunch of attachments to it, but my email address as a CoFam trustee is actually administered by FAMSF. Wouldn't that make any of those emails that I send out and the records attached within disclosable?
I mean, I'd sort of just be shooting from the hip and telling you my gut response, which is, just the same as you and I chatted. Like, I don't want to give you the opinion of the city attorney on that. You know what I mean? I haven't really looked into that.
I gotta get that.
So I see the challenge in your question, that nuance there. I don't know. Like, my initial take is that wouldn't necessarily turn it into a FAMSF document. But I just honestly don't have enough comfort level on how servers work, to the extent things normally just multiple entities exist on one server. You know what I mean? I just don't know how normal that is or abnormal. And I think it's a very good question. I just don't have a great answer. Sorry.
Yeah, for some reason, I want to recall that there was some discussion about shared emails, servers or systems or something like that back when we originally heard some of these cases.
Yeah, I vaguely recall something too when I was looking through the records.
Yeah. That's all I have.
Okay.
Schmidt?
Yeah, Dean Schmidt again. I'll just go back a little bit to Chair Wolf's line of inquiry. It seems like there's not much question that 12L applies, and then 12L means that there are certain public disclosures, but you in your memo called it limited public disclosure, and so the 12L limited public disclosure, it seems to me that that's not the same as subjecting someone to the Sunshine Act. Would you agree with that, DCA Wolf?
Absolutely.
Okay.
Yeah, it's limited by, if you look at 12L, it kind of lays out certain types of financial records that they have to produce as a matter of course. It's pretty specific on the types of records. I think there's 2 or 3 categories there. So I think that's a spot-on summary, that it is not the same thing.
It's basically contract and finances, right? That's the essence.
Hey!
Okay.
Hey!
Thank you. That's all.
Okay,
David, stop.
Can you please mute yourself? We need everybody to mute themselves except for the parties here at this point. Thank you. I have a couple of more questions, if you don't mind. Based on, I didn't quite find it, and maybe I missed it in your memo, and maybe you have the answer or not. What is the actual kind of relationship with regards to the meetings of CoFam? what is the relationship of the Fine Arts Museum of San Francisco City Agency? What is their position on that COFAM board? Are they representing the city, or are they kind of an independent trustee? And then what then is with regards to public representation? Does FAMSF have to COFAM at that point? And is those meetings of COFAM specific to the work that that COFAM is being contracted for?
So there's a lot to kind of unpack there. I think, let me pull up my memo while I'm talking to you. I don't think there's like a specific, so there's requirements that, members of FAMSF sit on COFAM's board of trustees. That's in the actual bylaws. So I don't know if that's a little bit what you're getting at. So that's why there's significant overlap. If you look at the very last page of the memo, I tried to put together a little appendix and color coded the overlap. See if you could figure it out. Like, so one color, is for all the overlap between COFAM and FAMSF. Another color is overlap between the foundation and FAMSF. I'm sorry, and COFAM. And then there's a third color where there's like a few members that are overlap of all three.
Well, but hold on a second. Let's just be clear. The Fine Arts Museums of San Francisco Board of Trustees is an actual city body, enterprise agency, or actual commission or board of some. Right. So they're absolutely subject to sunshine, not 12L.
That's right.
Okay. Okay. Then I had that backwards. Okay. So then let me ask, going back to the conundrum as to whether certain resources like shared servers and email services and what have you, whether those are available. The question then for me is, under the contract or the MOU or the requirements for performing those duties, did FAMSF provide resources to the contractor in order to perform those services for the city and the public? As opposed to, doesn't matter what the kind of circumstances are, the fact that the city has provided those resources for the contractor in order for them to perform those services, it continues to have the connect. It continues to keep things in the public sphere because they're still part of the city's kind of public government system, which is public. So and then if things need to be withheld, then you have the rules of sunshine to provide those provisions. Do you follow where I'm going with this?
Sorry, Bruce, not totally. I mean,
okay, so,
like, where's that?
So
what's your question? What do you?
So I guess that was kind of my question. I didn't articulate it well. So I guess the question is if COFAM and or the foundation have MOUs which are contracts to provide services or perform services for the city and the public. Okay, and FAMSF, the city agency or department, has either provided or required them to use specific city resources, which may include email services or file servers or any other kind of physical resources or virtual resources, then everything on those resources is public and subject to sunshine. No matter who has possession of it, they are a custodian. Is that not correct?
No, I think that's a bridge too far, actually. That's not how I read the case law or the statutes, that merely that a city department gives a nonprofit or some other entity a resource, then everything that's connected to that resource becomes a public record. I feel like that's what you're saying. I don't read the law that way.
Isn't the resource owned by the city, by the taxpayers?
I just don't see that as the dispositive question. If something is owned by the city, then everything connected to it is going to be a public record. That's not the test to whether something is going to be sunshineable.
That's very confusing to me. I don't understand that answer.
Okay.
I just don't. I can't understand that anything that is not in the possession, any records that are in possession of the city on any of the city's property or resources is subject to sunshine unless there's a withholding provision.
I mean, how about this? Instead of talking in theoreticals about resources and where this resource is located, can you ground your question into something that's present in this case? Because I just think it's more helpful to talk about a concrete issue in this case than like theoretically, locations of resources.
Okay, so
feel like
let me break out the list of items that the requester had asked for, and some of it was financial records and others. I mean, if you go to your starting on page 1 of your memo, okay. All documents relating to any fashion to invitations to and applications by Robert Smith. The actual petitioner is asking for for documents relating to him over the past 10 years to be a docent at the museums. I don't know whether it's COFAM or the foundation that manages the docent program. Okay. If let's say I think it's COFAM that provides the services for the docent and manages the docent program as contracted by the city, then any of those records with regards to invitations and applications to be a docent would be a public record.
I guess I don't necessarily agree with that. So this request was made to FAM-SF. And to the extent that FAM-SF has responsive documents here, yes, they would have to comply, period. This request, if it's made up to COFAM, COFAM would have to follow the rules listed in 12L. And if this is a type of document listed under 12L that's disclosable, then I'd agree with you. But I don't think 12L requires the disclosure of these types of documents from COFAM. If FAM-SF happened to have all of these documents because COFAM gave it to them one day, just here's a box of documents we don't need anymore, then sure, FAM-SF has them in its possession and it would turn them over. But I don't think as a matter of course, simply because there's a relationship between COFAM and FAM-SF, that automatically every document of COFAM that is responsive here would have to be turned over.
Well, okay, so let's go back to the what the original request was. So that's on page as far as the packet is concerned, it's on page 17 of the packet. That would be PDF page 7, but stamped in the footer page 17. And it was sent by Mr. Smith on June 5th, 2019. It was IDR for to the Fine Arts Museum in San Francisco, so the city department. And in the last sentence, it says this request includes all documents herein described in the possession of and or under the custody and or control of COFAM, the Corporation of Fine Arts Museums, and FAMSF, the Fine Arts Museums, the FAMF, Fine Arts Museum Foundation. Okay, so the response from FAMSF was that it was unresponsive that COFAM and FAM have those records. And then the question pursued from that as to whether COFAM is completely independent. COFAM and FAMF are completely independent of the city, or are they contractually tied to the city, and thus the documents that they have are disclosable, are public and disclosable. That's my question.
I guess it's the same. I have the same answer. That doesn't matter. Sure, they made a request here, but COFAM would be responsible only to the extent that 12L says allows or requires them to turn over those types of documents.
And I see your hand, Member Highland. Just one last point from me. In 12L, it states in the last sentence of 12L.5A, notwithstanding the foregoing, which is the standard packet of financial information. Oh, wait a minute, that was what I was looking for. Oh, it's above that. A member of the public may request additional financial information other than what's described above pursuant to 12L5B, which is the dispute resolution section. However, the provision of such additional financial information by a nonprofit organization shall be voluntary and not compulsory. Okay. Now, under the dispute resolution, they can ask the city department, the agency, the contracting agency, for that information. And if they don't, if they're not happy with that information, they may bring I guess a complaint to the Sunshine Task Force for an advisory opinion that the task force is authorized for. So that's what we're here for today. So we're just trying to, I guess we're just trying to figure out what is applicable for this or not. Okay, I'm going to stop there. Member Highland, go ahead.
Yeah, I just wanted to go back to something that Member Yankee said about the servers. I do remember that from prior conversations. But just want to establish first of all that, and this is for DCA Mark Price. Well, if we're accepting that 12L is applicable here, what's the threshold? What's the litmus test of what they have to turn over? You mentioned you were going down the road of hard copies in cabinets or whatnot. I'd like to see that go to emails. So first of all, would you accept that emails between FAMSF and the two other entities are in the public domain? That's my first question. I'll wait for you to answer that.
Sure. Sorry, I'm trying to turn my video on so this feels a little better.
Yeah,
Can you guys see me yet?
I see you now. Yeah.
I see you. Yeah.
Sorry, guys. So I think that was brought up, I don't know which of the many times we talked about this, but I'm pretty sure FAMSF acknowledged that all the emails that they that FAM-SF folks had with other entities that are responsive would be disclosable under Sunshine, and that I think they said they did turn them over, but yeah, I think so, because that's FAM-SFs, right? But to the extent that FAM-SF, like to the extent they're email, I don't know, that they're requesting from a co-FAM member, very good. Oh, from a co-FAM member to Joe Smith, like those aren't necessarily disclosable under Sunshine. Does that make sense? Like, I think what you're saying is, to what extent would FAM-SF's emails be disclosable under the Sunshine, and to the extent that they're public records, I'd say, yeah, all of those emails, if they're responsive, would be disclosable as long, yeah.
Okay. So based on that, the next thing I wanted to point out is I seem to remember that, it is the FAM-SF email server that they created CoFam to handle some of the business of the museums, and they put CoFam on that server. I think right there, any, defenses of, sorry, Ryder, it's not going to work. I think I'm going to go mute here. Hold on.
I'll just add in that my family became a cliche COVID family, and we just got a puppy too, so I empathize. Yeah, that's why I was the first half of the meeting. I was outside to keep him okay, and I was shivering, so I need to come back inside. Anyway.
Well, you'll hear me do that
I'll try to
too.
bring him in here and show you guys.
Anyway. So I have another question, real quick. Oh, go ahead, Chris. Go ahead, finish your line. Oh, we lost Chris. Are you still there, Chris?
I think he was trying to subdue his dog. He was
okay,
the one
so
barking, yeah.
So let me add, did you, DCA Price Wolf, did you find any evidence in the MOU or the contract that states that they would be subject to Sunshine?
No. Let me say this. Okay. When I read the MOU, I did not see anything that openly subjected themselves to the Sunshine, like we sometimes see in contracts. Like I remember with SF Zoo and things like that. No, there's nothing like that that I saw.
Do you find that unusual?
It is what it is. I don't know. I don't have an opinion on whether it's normal or not.
Okay. Because yes, I'm hearkening back to the zoo case also regarding that. But you would think that similar to that, I mean, almost every contract that the city puts out actually does say now part of its boilerplate that they're subject to Sunshine for the work that they're performing.
Wonder if I could just run a quick question by everybody, which is that are we treating all three entities as respondents here, or just FAM? I wonder. I got a sense that it's just FAM that's here today in this proceeding, and so I'm wondering if that would mean that maybe talking about the other entities is a little bit outside the scope. Any ideas from anyone on that?
I'll go ahead. This is Fiona. This case has been for us for I don't know how. It's sort of like you can't talk about one entity without talking about the other. So that's why we're sort of we request memo, because had some issues with sort of wrapping our head around the intertwined interrelationships here at the committee level, so that's why we have been requesting this memo for a while.
Oh, go ahead. Sorry.
I'm done with that particular line. Go ahead.
Yeah, I mean, there's no question that they're interrelated and they're all relevant to what we're dealing with, to this whole situation. But they're relevant possibly, but only today if they're relevant to whether FAM violated something. I don't know if they're parties here today, and that's my concern, because I mean, I have some certain thoughts about whether FAM violated, et cetera, et cetera. In fact, there's already an order of determination on that. And yet, are we looking at, whether these two other entities should have done something in terms for today? I don't get that. I mean, I will footnote that with, I had an earlier question, which was, did FAM have an obligation to look at the other two entities and to possibly ask them if they had any documents that might be responsive to the request to FAM? And I actually think that there may be case law that we also saw in a different case, which is the Hooper case, which says that, yes, FAM, with entities that they have a close relationship with, they need to find out if those entities would possibly be in possession of public records. And so that's one of the reasons why I think these other entities might be relevant here today. But that's different than whether we're looking at what those entities, whether they violated some kind of obligation under the law.
Anybody else? Member Highland, are you still there? I kind of want to wrap this up. Do you have any other questions? You're in the middle. No? All right. Lower your hand, if you don't mind. Thank you. Okay, so where we're at here is to come to some conclusion as to what the relationship is between COFAM. FAMF is to FAMSF, the city department. We've come to agreement that anything that FAMSF does and has in possession of in relation to records is disclosable under Sunshine. Anything under COFAM and FAMF, we're being advised that is under 12L. 12L, if we the task force, now it's with the task force to determine which way this is going. Is it under the standard Sunshine, section 67, or under section 12L? If it's under 12L, it's pretty specific on what the role of the task force is, which is not necessarily the same as section 67. Yeah, Art, for here, if we're going to assume that it's 12L, then under 12L, we would not be providing an order of determination. We would be providing an advisory opinion about the request made to the contracting agency for its contractor. Thereafter, the review and any other consideration would be in the hands of the Board of Supervisors.
If I could quickly just bring up a note, and I thought this is kind of going back to what I talked about earlier and what Member Highland was discussing. But I did find in the memo that Mark Price Wolf wrote that he talks about the Good Government Guide, and that it notes that any records stored on the city's communication system would be considered retained by the city, and also in most, if not all, instances, also owned by the city. So I think we need to figure out if any of these records would potentially have been on that city's email system. Now, I don't know exactly how the servers work between all these, and I know we've had some discussions about that, but that may make FAMSF the responsive party for perhaps many of these documents that may have been sent by COFAM or FAMF using the city's email system.
Okay. That's a good, very good point. So this complaint was, well, the original request was made of FAMSF. So that's our focus on here. And then the question, based upon your statement, Vice Chair Yankee, if we are to agree with your statement, then we would call upon FAMSF to provide those documents as in the list of public records requested that they might have in possession with regards to if they exist on the city's servers at that point. And frankly, you can regard city servers, it could be a file cabinet. It could be a pile of paper on somebody's desk. You know, it could be in a binder. You know, it doesn't matter where it's stored. If it's in the possession of the city and in a city's resource, then it's disclosable. And then we don't have to necessarily deal with the 12L issue at that point. We only are dealing with the 12L issue because FAMSF has cited that they don't have to produce documents that COFAM or FAMF has. The question here is, does FAMSF have those documents because they exist on city property? Correct, Vice Chair Yankee?
That is what I am essentially suggesting, yes.
Okay. All right, folks. There you have it. So we left this item open so we can get through this investigation and then make a determination as to what, if any or all of the documents that were either unresponsive or withheld by FAMSF, they need to be ordered to produce.
Point of maybe unmuted. Yeah, point of clarification. So, what do we need to do today? Are we just determining the relationship today, or are we coming to some
No,
about the
no,
fact
no. We're this is the last part of this case.
Okay.
Was to determine the issue was that FAMSF had some objections to providing documents or records that COFAM or FAMF may have, because that would be in their possession. The question here is the original request and complaint was brought upon FAMSF, which is the city department. The elephant in the room was they were sharing resources, and if anything in the list of documents requested were on FAMSF's were on city property because of those shared resources, then they must be disclosed, and not by COFAM or FAMF, the foundation, but by FAMSF because they are on their servers or some other city server.
Got it. Okay.
That's the way where I'm going with this.
Could I clarify that it appears, are we going to hear from the parties today? Or is that not part of this?
We can, if you want clarification and the parties are here. Okay. You can, absolutely. We didn't request the parties to be present because we are continuing to take this up on our own. As far as, we've heard from the petitioner, Mr. Smith. He's not quite sure why we're continuing to go down this rabbit hole. Okay. We felt it was important because it was precedent setting, or could be precedent setting, based upon how contractors that having MOUs or other contracts get applied. I mean, we've already dealt with this with the zoo and with other cases regarding, like the Opera House. That was another case, and we just don't have a clear kind of precedent to be able to deal with these issues. So this is one of those lingering issues that could help define more easily for us and for future task force bodies to be able to come to conclusions easier and faster, make them more explainable.
Okay. Well, yeah, I agree that FAM is the party that we're looking at here. When we get to the point where we're talking about what to do, which I think we're at, in addition to whatever FAM had custody or control of, which I don't know if that's really disputed, those are public records. I did find the citation to the case, which I believe obligates FAM to seek out records that are outside of their possession and control, and to go to these entities with which they're fairly closely intertwined and ask them what type of documents they may have that would potentially be public records. And so I do think that there is California case law that supports that additional obligation. And so I think that the case against FAM would include that type of obligation. And that's a case that we talked about. It may have been in a committee hearing. It's Community Youth Athletic Center versus National City. It's a 2013 case, 220 Cal App 4th 1385. I'm just reading that into the record because I think that case, we definitely need to know about that case because we have a lot of those type of situations going on in the city with, agencies who are having a lot of their work sort of subcontracted to these private, semi-private entities, including the 12L companies.
So that sounds like it would basically trump 12L in this case.
I think it would add to 12L. I think 12L has a role here, but I don't think that they can necessarily cap it with 12L and say, well, we did everything that 12L requires, or we'll do everything that 12L requires. I think they can't just say, we only have to give you what we have. If they get a request and the circumstances indicate that there may be other parties who possess certain public records associated with the work that is done within that agency's AEGIS, AEGIS, sorry with the pronunciation, that they may have this extra obligation to go outside and contact those those other entities. And I think that I saw this with the Parks Alliance, that this may come into play with the Parks Alliance also. And I think it might come into play here. And so that's why I was wondering, if we're just looking at FAM, is that something that maybe, FAM didn't do here? And I don't think they did it because they said, we don't need to do that. We don't have to do that. And I asked the same question of, DCA Price Wolf, and I don't know if he's still on the call, but I wanted to just talk to him about this court opinion because it may apply here.
Can you repeat that court opinion?
Yeah, the citation is Community Youth Athletic Center v. National City. 2013, 220 Cal App 4th 1385. And it's not that it's not like it clearly lays out a specific obligation that you can just take from the opinion. But I think that I would feel comfortable relying on that case to say that in some of these situations, there is a certain obligation to go to closely interconnected entities and ask them for documents.
Okay. So then go ahead, DCA Wolf. Do you want to respond to that?
So I think that there is certainly, if the request is made on one agency and they think the document might be held within another agency, I think they're an obligation to say, hey, I think they might be in this other agency. You should go talk to them. Like if the Parks and Rec get a request about, I don't know, garbage cans on the police department's property, they can say, oh, we actually don't have that, but the police departments do. You should ask them. There's that. I also think that to the extent that a public entity actually controls the documents that another party might have, like I think you're right, the public entity has a obligation to get those documents and turn them over as public record. So for instance, I'll use the same example with like parks. If they, for whatever reason, store their documents in like Aunt Joe's garage, or have Aunt whoever control them. You can't, the parks can't just say, well, we don't have them. They need to go, and since they control them, they need to go and get those documents, or at least look through those documents and see if there's anything responsive. I think what you're saying is something a little bit different, which is if there's a close relationship with two entities, the public entity upon which a request is made needs to reach out to all of those other agencies and see if there's responsive records, to the extent they're responsible to do that. And I think that's a bridge too far. I don't read this case to say that. I can look at it a little bit more closely. I'm just sort of looking at it while you were talking, Member Smith. So
Sure.
Read,
Yeah.
But I sort of separate it into those three buckets. So I think I understand what you're saying.
Yeah. I mean, yeah, I think that when we're talking about possession, we're pretty clear. I think we all understand what possession is, but this case adds to possession, and it says that in these kind of situations, it can be possession, or it can be constructive possession. And I don't want to get too far into what that means, because that means a lot of things. But constructive possession it's sort of an add-on to possession. And I wonder if maybe here we're talking about the kind of circumstances where there's actually constructive possession, even when they're not in actual possession. That's so. I thank you for looking at the case, though, DCA.
Sure.
Okay, anything else, folks? Try to wrap this up. Okay, so thank you, DCA Wolf, for completing this task. Really appreciate it. I think we're pretty clear on the relationship between the two nonprofit entities and the city. I think we're pretty clear on if there are shared resources that are provided by the city, that are owned by the city, that anything on those resources is disclosable under sunshine, unless otherwise there's a citation for withholding. I think also, I believe in some of the responses, just is in context. Let's see, this was on page 5 of DCA Wolf's memo. It says FAMSF's response to set 5. I think set 5 is a set of records that were requested, that they have engaged COFAM and didn't find any records that were responsive. But I think the thrust of this exercise was to determine the relationship and determine what records are to be disclosable or not at this point. All right, any other comments or discussion before we open it up to public comment? And then we can decide how we want it to close this, either by a motion or to, we can make a motion to provide an affirmation on information that we've collected here today, so that it begins the process of creating a precedent or a kind of a general, kind of standing that the task force, or position the task force wants to take. I mean, those are just some suggestions.
I would consider perhaps making a motion, and then we could have public comment on that and see if we want to amend it or change it in any way, but just to get some type of something down.
Okay.
I would move that we find that FAMSF would need to disclose.
Wait a minute, FAMSF what?
FAMSF would need to disclose any records stored on the city's communication system. And I would say including anything from COFAM or FAMF that would meet that criteria.
Including anything?
Any record from COFAM or FAMF that would meet that criteria. So essentially what I'm saying is that FAMSF, which is the city body, would need to turn over anything stored on the city's email system, or like Chair Wolf said, if it's in their file cabinet or whatever else, if it's a hard copy. But if it's in the possession somehow electronically or physically of FAMSF, they need to turn it over, even if that document was initially created by COFAM or FAMF.
I will second that for the sake of being able to have discussion.
Okay, so moved by Vice Chair Yankee, second by Member Hensy. Repeating this, the motion is to require FAMSF, the city department, require them to disclose any records on city resources and or communication systems for any reference of COFAM or FAMF, even if COFAM or FAMF created that record. Does that sound right?
That sounds right.
Okay. Great. Okay, let's open it up to public comment.
Yes, please.
Cheryl, are you ready with the clock?
In a second. Sorry, I'm just taking a few minutes to set this up. Go ahead, sir.
Thank you. Hi, this is Anonymous. I think Vice Chair Yankee and Member Schmidt are right on the money in both of their comments throughout this case. I'm just reading through the case that Member Schmidt cited just now, and it does go beyond just having a requirement for the city to search through its own records, and it is based, and it's I don't have a paragraph number here, but it's the bottom of page 1428 in that citation. It is based on the contractual language between the city and the contractor. If you believe that the city has an quote ownership interest and a quote right to possess and control it, then that's enough. And so if in the dealings between the fine arts, the department, and these other nonprofits, this information about the museum or about the operations of the museum, which is the conduct of public business, if the city has a contractual right to possess and control it, even if it, as the court says in that case, did not enforce that right, it would still be in the constructive possession of the city and must be disclosed. I think there's also a very important part about these email servers because actually, I think you've been handling this case for quite some time. And I remember at the first meeting for this case, when I found out this was happening, I made a records request to the fine arts museums for the records of their computer systems, how they handle who uses what. And they wouldn't give me anything for the same reason. And if it is the case that any employee or officer of the city prepared, owned, used, or retained this information, that, according to the City of San Jose, is enough. Even one employee preparing, own, using, or retaining the information is enough, including, for example, the common trustees across the different public and private entities. So I think this motion is absolutely right, and I would strongly encourage you to vote in favor of it. Thank you.
Next speaker, please. Any other public comment on this on the motion? Please unmute yourself by pressing *6. Last call for public comment on the motion. Okay, hearing none, are we ready for a vote? Okay, let's call the roll, please.
Member Yankee?
Administrator
Aye.
Are we ready? Okay. Member Yankee?
Aye.
Member Yankee, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland?
Aye.
Member Highland, aye. Member Wolf? Chair Wolf, sorry.
Aye.
Chair Wolf, aye. The motion is to require FAM SF to disclose any records on any city resources and communication system, even if on COFAM or FAM. Is that correct?
It is to require FAM-SF to disclose any records on city resources and communication systems of any reference of COFAM or FAM-F, even if COFAM or FAM-F created that record.
Okay.
Member Wong, you have a question?
I just have a point of discussion, I think, based on DCA Price Wolf's memo. I would love to at some point discuss like how COFAM would fall under the Sunshine Ordinance related to like their board meetings, and just how we would handle that in the future. It definitely doesn't have to be now, but
Actually, if you read 12L, that will answer your question. 12L has a specific section requiring all contracted nonprofits to hold at least one meeting, public meeting per year. And there are requirements as to what they need to disclose during that meeting. As far as any other types of meetings, I don't, that's something deeper. If you want it to have the task force, do some work on that. Let's figure out what it should be, kind of come through a committee, or you can take it upon yourself to take it on as a project. We could, do it either way, that way too. And then provide a report back to the task force.
okay, sounds good. I can do a little bit of research.
Okay.
Or, Member Wong, if you want to follow up offline, I'm happy to have a discussion with you.
Great, thank you.
Okay, so I'll suppose that the motion is passed. So I'll tap the gavel. And so we're at 6 o'clock. I promised to take a break, but we also are required to have our public comment that would be at 5. So we're going to take public comment first, and then we'll take our recess. So Administrator Leger, if you would mind calling item number 3.
Item number 3, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
Any public comment? Please unmute yourself by pressing *6.
Mr. Chairman?
Yes.
Are you ready, sir? Do you have a comment?
Chairman,
Do you want to make public comment, or do you have a question?
I want to make public comment.
Okay. I'll begin the clock right now.
Thank
Go
you.
ahead, sir.
Mr. Chairman, members of the task force, my name is John Hooper. I just wanted to give you a quick update on the status of complaints 19061 and 19062, which you discussed at your December 2nd meeting and referred back to the complaints committee with instructions to petitioners and respondents. At that time, your instructions to me were to submit to the clerk an itemized list of information I have requested and not yet received. At that meeting, your instructions to respondents, OEWD and DPW, were to provide specific answers to each item on my list, at which time the Complaints Committee would have adequate information from both sides in front of them to aid in its deliberations. As instructed, I submitted my itemized list on December 17th, and the clerk sent it to both parties, OEWD and DPW, on December 18th. I have had no acknowledgement or response or information of any kind from either respondent since that time. Given the continued difficulty in obtaining the information I've been requesting for almost 2 years, and I know this is not an action item, I request that the SOTF again instruct OEWD and DPW to respond in detail to my itemized request. And I would also request that you, this time, place a deadline on their responses. That, I think, would help move this matter, which has bounced around the Sunshine Ordinance Task Force for almost 2 years, to a resolution. Thank you for your time this evening.
Thank you. Next speaker, please.
I wish to make a public comment.
So do I.
So do I. Can I make a public comment? Hello?
Just a moment.
Yes, you may.
Ready?
A moment. Yes, I'm set, sir.
Am I up for speaking? Hello?
Bruce, can he speak?
Yeah, go ahead.
Okay.
Oh, okay.
You ready?
Okay.
Let him know. So here's the hold on a second. Here's the process. I'll ask for public comment. Somebody will speak up. Administrator Leger will say, okay, I'll, hold on a minute. And she'll get the clock going, and then she'll say, okay, speaker, go ahead. It'd be good when you are asking to speak for public comment that you identify yourself in some way. If you want to identify yourself as anonymous, please do, and at least we'll be able to kind of keep things in order. I appreciate it. Thank you. Go ahead, speaker.
Clock is on.
Am I up? I'm speaking?
Yep. Go right ahead.
Okay. Get 2 minutes, right?
3.
3
minutes. Okay. This is anonymous. I have a standing gripe with the administrator. I've been using the task force for actually decades, and procedure that you've always followed is that if I make a public records request and I believe that the party to which I'm making the request does not give me the documents that I've requested under the Sunshine Ordinance, I have the right to file a complaint. And in my past experience, whenever I've done that, the administrator has, in a timely manner, assigned a file number to that complaint. The rest is largely, if not completely, out of my control. I recently tried to do that. I was denied records illegally under the Sunshine Ordinance by the SFMTA, and I phoned the administrator and asked. I also faxed her that complaint. I asked for a file number. She refused to do that, and I actually filed another complaint about that behavior with the clerk of the Board of Supervisors, her boss, I believe. So that is my standing gripe. In my experience, if I need to repeat myself, whenever I've okay, I don't think it's the job of the administrator to decide whether a complaint is a legitimate complaint, nor to deny a file number to a received complaint. In my experience, the body that decides whether a complaint is a legal, legitimate, actionable, or hearable complaint is the Complaints Committee of the task force. In my opinion, at this point, the administrator is denying me the standing, long-time procedures to follow that practice, which is very upsetting.
if not illegal. So good luck, and I hope you get it straight, because I wish to follow through with this complaint and get the documents I requested. I'm done. Thank you.
Thank you. I just want to respond to that public commenter. Our complaint procedure has some allowances for the administrator with regards to giving a file or entering in a complaint. We'll make sure that we review it on this end for the purposes of your issue, but I would also urge you to also read the complaint procedure to assure that what you're concerned about is either being covered or not. The complaint procedure could be found on our website. It's under the documents section. Thank you. Next speaker, please.
Hi, this is David Steinberg. I'd like to say something.
Go ahead, David.
Hi, I want to respond to what Mr. Hooper just said a couple minutes ago. First of all, I will say we have not responded to his most recent letter because we are conferring with the city attorney. We will respond to him shortly, but I will also point out that at the task force meeting on December 2nd, the task force requested that Mr. Hooper provide a bullet list of missing documents to both of our departments and that the matter be referred back to the complaint committee once the records have been identified. Instead of providing a list of allegedly missing documents, Mr. Hooper presented a laundry list of new items drawn presumably from an early contract with OEWD with no regard to whether or not we had already provided those comments. As an example, item 5 of this 21 bullets was for invoices and records of payment, as well as meeting minutes, notes, and sign sheets involving FFPA, et cetera, et cetera. We've released more than 800 documents, but in a very quick check of documents previously released to Mr. Hooper, I found 5 documents that are responsive to what he just asked for, which were meeting minutes. So he didn't provide what the task force asked him to provide, which was the missing document. He came up with a whole new laundry list of 21 different categories of things. And as I said, we're conferring with city attorney, and we'll respond to Mr. Hooper shortly, but I did want to make the task force aware of why he has not received any correspondence from us yet, because he did not follow the task force's instructions to him. Thank you.
Thank you. Just a response to that from the chair here. Where there are issues around existing cases that are open or cases that are being monitored by the task force, please refer that to the Compliance and Amendments Committee. You can do that through the administrator. If you have any concerns about that, the Compliance and Amendments Committee is specifically charged with reviewing and monitoring orders of determination as they are being asked to be monitored. If there's any action or additional issues, the chair can determine whether to put it on an agenda for further discussion and review or action at that point. Thank you. Next speaker. Any other public comment?
Yes. Yes. Anonymous here.
Go ahead, sir.
Thank you. So this is regarding some of those cases that someday will be heard at compliance. Hopefully, I know 19044 and 19047 are going to be heard in a few weeks regarding the 1+ year refusal of the mayor's office and the city attorney's office to comply with orders 19044 and 19047. But something more recently is your decisions in 19098, 19103, and 19112. These are decisions, all of them unanimously made by this task force, However, the mayor's office is refusing to comply because you haven't signed the OD after the decision. So I'd urge you, it's not just my case, I know there's a few others in the last few months that need to be published on the website after you guys finish putting the minutes into the OD and signing them. And I would just please ask that you do so at your earliest convenience, not just for my ODs, but for the other people whose rulings you've made since, I believe, August or September. Thank you very much.
Thank you. Any other public comment? Last call for public comment. This is general public comment for items that are not on the agenda today. Okay, public comment is closed. Let's recess for 10 minutes. It's 6:16 now. We'll return at 6:26. We are in recess.
I will ask that all the members and members of the public mute their microphone and turn off their cameras.
Okay, let's gather back, everybody. Please enter in the room. Yes, you good girl. You good girl. You good girl. No, we're not going out. Not yet. You're welcome. Yes, you are. You're welcome. Good girl. Okay, we all here? 1, 2, 3, 4, 5, 6, 7. Yes, we're all here. Okay, great. Let's call the meeting back to order. 6:27. And let's
Give us a
call
moment.
them.
Just want to make sure that Cheryl's actually back on with us.
Okay, great.
Cheryl, if you are there, you do need to unmute yourself.
Sorry, I heard that meeting back to order at 6:27 p.m.
Yes. All right. Is
We're all here?
everything? We're all here, and the recording is on?
Recording is on.
Okay, great. Okay, let's call the next item. I think this will be item number 6.
Correct. Item number 6, file number 19119, complaint filed by Anonymous against the Department of Technology, Linda Gorell, Michael Maxman, Arlene Lucinda Barker, for allegedly violating Administrative Code Section 6721B, 26, 27, by failing to respond to a public records request in a timely and or complete manner, failing to keep withholding to a minimum, and failing to cite legal justification for withholding. This was
Okay.
a rather large packet, so I had to divide it up into 6 parts.
Very good. Thank you. Madam Compliance and Amendments Chair, do you have anything to report on this? You're somehow muted or not. Can't
I
tell
am
if you're
muted.
Okay, there you go.
Yes, we found jurisdiction, and I would say something important to note with this case is that I know that the Department of Technology has been working with Anonymous to increase compliance with these kinds of requests, and I believe things have moved in a positive direction, but we still found it necessary to that we still found jurisdiction and merit to the case, and that's why we're hearing it today.
Okay, very good. Okay, Cheryl, you ready with the clock?
Just about. All right, petitioner's going first.
Yeah, well, let's make sure both parties are here. Are both parties here?
Petitioner is present.
Is the respondent present? Somebody from representing the Department of Technology. Give you a moment to unmute. *6 is how you unmute. Cheryl, did you get any response from the respondent, whether they would appear or not?
No.
Hello, this is Michael Maxman from the Department of
Okay,
Technology.
there we go.
Okay,
and
cool.
Linda Girl, the Director of Department of Technology, is also on. She might be trying to unmute, and I do believe that Arlene is also here.
Okay, great. So please.
This is Arlene Licadini.
Okay, great. Thank you for attending. When we call upon the respondent, please choose one person to make their the testimony, and then I'll call for any witnesses or other persons to provide any additional facts or evidence, and anybody else from the department can add additional information at that time. So we'll start with the petitioner first. Anonymous, you have 5 minutes.
Thank you very much. And I would like to remind that the complaint procedure does, I believe, require the total time for me and all of their parties to be the same. But we'll begin on page 82 of part 5 of item 5. That's the PDF number. And your chair of compliance is exactly right. Things have moved in a great direction here. So this request was made, 2 requests were made in October 2019 for the email and calendar data of the Chief Information Security Officer, Michael Maxman, and the Chief Information Officer, Linda Jarrell. They denied those requests on November 1 and November 11th. One with a legal citation and one without. In November 2019, I filed this complaint, which predates all COVID orders. In October 2020, which is 1 year later, they did the first partial production of that data. In December, it was mostly complete. As of December 28th, I don't think I've ever said this before, all parties, there was no further dispute between the parties. The Department of Technology has either produced all of the information or agreed in writing to produce all of the information. Just as a reminder for those of you who weren't here in the numerous public hearings we had about metadata, you conducted those hearings consulting with a number of different departments. You did your own research and came to the conclusion that there are no court cases and no rules that say that this information would be exempt. Therefore, it's not exempt, and it must be treated like every other part of a public record. And there's 6726 would require them to only exempt the minimal portion, the minimal types of metadata that are information security threats, but not other kinds of metadata. If you go to the next page, you'll see a history of metadata in San Francisco. So I believe Mr. Warfield commented in one of my cases recently, why is Anonymous still fighting for this? It's not new. This is certainly not a new thing that the SOTF has held. 14 years ago, in 2006, the Board of Supervisors unanimously passed a motion requiring the clerk to provide public access to records in the format requested by the requester due to SOTF complaints. I believe Mr. Warfield was at that hearing many, many years ago. And they changed this from a PDF-only production. And in 2019, in 3 different cases, you held that email header information, calendar data, and text message metadata had to be produced. And the chair openly invited the city to create a baseline of which metadata was and was not exempt, with some reasoning so we could actually think about these cases. And I believe the Department of Technology has now done this for email and calendar. All I'm going to ask you here, and I think we're going to keep this short because I don't think there's any dispute here, is I am asking you to dismiss the individual respondents in reflection of their substantial amount of work in improving the city's response here, and to dismiss 6726 and 6727, even though those were violations at the time I filed the complaint, and ask only for a 6721B for an untimely production of the records in this case, since it was a year later. And I would say, I think one of your members said you should note that, when departments do improve their policies and improve how they do things over time, even though at the time of the complaint it wasn't compliant. And I think that's useful because these respondents have been very helpful in improving the city's production of this information. There's a large appendix, and I can go through the entire legal argument about all this information if I have to, but I don't think I need to because they've disclosed the information and don't dispute it. So I'll just leave you with the League of California Cities told you that agencies that receive requests for metadata or requests for records that include metadata should treat the request the same way they treat all other requests for electronic information and disclose the non-exempt metadata. And San Diego, Los Angeles, West Sacramento, Sacramento County, Port of Oakland, Vallejo, City of Fort Bragg, City of Oakland, Placer County, Marin County, San Mateo, all of these agencies and cities that put records on next requests, they will give you this information. And that's even under the weaker CPRA. I'm actually not going to go through the whole legal argument because they've disclosed the information, so there's nothing to argue. But if you have questions, especially for those who weren't there for all of the
30 seconds.
we had on this before. all of the hearings we had on this before, I'm happy to point to the record, the other court cases I have, the quotations and everything. Finally, if you do give the respondents a total of 15 minutes, if they need 15 minutes for different parties, I would ask that you give me some time as well so that the total time is equal. Thank you very much.
Are there any persons or witnesses providing facts or evidence on behalf of the petitioner? Okay, hearing none. I just want to, before we move on, I just want to double check something on our procedures based on what the petitioner is citing. I'm sorry, just a moment, please. So I'm not finding in our, and I'm not aware in our procedures and just in general practice that if there are, anybody steps up to be party to provide any additional facts or evidence on behalf of a presenting party, that equal time must be provided to the other party. Whether somebody shows up to provide additional information or not during this testimony period is a matter of whoever shows up for that particular aspect. Now, if we want to include all three representatives of the respondent as part of the respondent's testimony, then I would say yes. Then we would extend the time for the other party. But if they choose, if the choice is to for them to step up as providing additional facts or evidence, then it would not apply. I'll take any, if there are any concerns about that from members. Otherwise, we'll move forward. Okay. Let's call upon the petitioner, whoever the representative is, provide their testimony. 5 minutes, please.
I think you mean the respondent.
I mean the respondent, yes.
Okay.
This is
Can
good.
you
Can you hear me?
barely?
Barely?
That's better.
Maybe there's other people on mute, so that would help. So this is Linda Durrell, and I'm the director of the Department of Technology. And thank you for allowing us to be here tonight. So there will be no need for others listed in the complaint to respond. I will respond on behalf of the department. And we have no additional facts to add to this conversation. So we believe that this matter is closed.
Does that conclude your testimony?
Ms. Gorell?
Yes?
Is that the end of your testimony, ma'am?
Yes, it is. Thank you.
All right, thank you.
Thank you. Are there any persons or witnesses providing facts or evidence on behalf of the respondent? Okay, hearing none. Members, questions and clarifications in this section?
having waited a while for anyone, this seems satisfying given that both parties have agreed. So I'll move to find the
No,
violation.
not yet, not yet. We have to go through rebuttals first.
Oh, sorry about that.
This is just our Q&A, our discovery section. All right. Anything? Last call for any questions, clarifications? Nope. Okay. Should we move to rebuttals? Okay,
3 minutes.
great. So 3-minute rebuttals. Start with the respondent, Ms. Grell.
We have no rebuttals. Thank you.
Thank you.
Oh.
Petitioner, anonymous.
The motion that I'm going to ask you for is to dismiss Linda Jarrell, Arlene Lucidine Baker, and Michael Maxman as respondents, dismiss 6726 and 6727, and find only a violation of 6721B for the untimely production of the records requested here by the Department of Technology. I'm also waiving the compliance thing that automatically happens after this OD. Thank you very much.
Okay, thank you. All right. Member Hensy.
I will move to find violation of 6721B. Do we need to say we're not finding violation for the other two sections? Do you want us to go?
Not required.
Okay. I will move to find violation of 6721.
Okay. Is there a second?
Sure, I'll second that.
Okay, moved by Member Hensy, second by Vice Chair Yankee. Any further discussion on the motion to find in violation, the Department of Technology in violation of 6721B on timeliness? Okay, hearing none, let's open it for public comment. If you have public comment on the motion to find in violation of 6721B on timeliness, please unmute yourself by pressing *6. Any public comment? Public comment. Any public comment? Okay, last call for public comment. Okay, no public comment. Are we ready for a vote? Okay, let's, Cheryl, can you please call the roll?
Okay. Member Hensy? Member Hensy?
Aye.
Member Hensy, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to find a violation of 6721B on timeliness passes. Would you like me to include in that motion the dismissal of 6726 and 27?
No, not necessary, because
Right.
we didn't necessarily take it up. It was a suggested suggestion of the petitioner that we find in violation for those. We are not finding a violation of those. It's been now repeated on the record a couple of times. I think we're good.
Sure. Well,
Yes.
before we move to the next file, I'd like to make a subsequent motion on this, and it would just be to recognize the significant work for the Department of Technology and request that they share their work on metadata with any other department who need guidance on metadata-related records requests.
Sure, I'll second that.
Okay. So that was moved by Vice Chair Yankee, second by Member Hensy. I'll just add, I think it would be good if there was some kind of fact sheet or some sort of something written up of regarding this that we could have, that we could also distribute.
That would be, so maybe I would amend it to ask the Department of Information Technology create a summary fact sheet to share with both the task force and any department needs guidance and or assistance with complying with metadata records requests.
Okay. Secondary that's
Okay, let me make sure I got this motion right. To suggest that the Department of Technology share with the task force what?
I would suggest that, number one, I'd like to recognize the significant work done by the Department of Technology in response to this issue, and request that they create a summary fact sheet of how to dispose of or deal with metadata related record requests that they could share with both the task force and with any other departments that need assistance or guidance in replying to records requests of this nature. That was probably wordier than it had to be, but I think you get it.
That's good. All right, so let's open this up for public comment. Sure.
How about our comment?
Oh, do you guys want to? I'm sorry. Go ahead.
I just want to give a strong endorsement. Member Yankee or Vice Chair Yankee, thank you for proposing that. I think it's a great idea.
Great.
Members, anybody else? Okay, let's go to public comment. Any public comment? Public comment. And last call for public comment. Okay, please call the roll.
Okay, hang on a second. I'm fitting in my paper. Member Yankee.
Aye.
Member Yankee, aye. Member Hensy.
Aye.
Member Hensy, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member Wong.
Aye.
Member Wong, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Highland.
Aye.
Member Highland, aye. Chair Wolf.
Aye.
Chair Wolf, aye. And the motion passes. So there's two motions on this particular item.
Yes.
Got it.
Okay. And all right, let's go on the next item.
All right. Item number 7, file number 191 sheet. Problem? Is there an echo? Okay. File number 19128, complaint filed by Anonymous against Chief William Scott, Sergeant Brian Rodriguez, Sergeant Michael Andriachek, and the Police Department for allegedly violating Administrative Code sections 6721, 25, 26, 27, and 29-7A by failing to respond to an immediate disclosure request in a timely and or complete manner, failing to comply with the California Public Records Act, failing to keep withholding to a minimum, failing to cite legal justification for withholding, and failing to preserve, maintain, and disclose all correspondence in a professional and businesslike manner.
Thank you. Member, I would say, Madam Complaint Committee Chair Hensy, do you have any report?
What is it? When did we hear this one? I'm trying to recall.
October 20th this year, last year.
I don't recall anything specific. Either members Yankee or Schmidt. Missing anything?
Sure, I'll jump in a little bit. if I recall, the case, at least part of the case, was regarding, I believe it's someone with the San Francisco Police Office, also having a separate email account through the FBI or some type of other law enforcement group, and there's type of maybe perhaps a city of San Jose type of issue involved here, in searching those subsequent or those other email addresses for the record. There may be more of it to it than that. I believe that's a quick high-level summary.
Right. Correct.
Okay, thank you. So let's start our procedure here. We'll hear from the petitioner first, then any witnesses, then we'll hear from the respondent, and then any witnesses. 5 minutes each. Administrator Leger, you ready?
Yes, I am.
Okay, Anonymous, are you ready? And is the respondent, let's make sure the respondent is present. Is there a representative for the respondent? Is Chief William Scott here? Or Sergeant Brian Rodriguez, or Sergeant Michael Andrzejczak?
Hello,
Or
Sergeant Andrzejczak here from SFPD.
Okay, great. Are you representing all the respondents?
Yes, I am.
Okay, great. Thank you very much. All right, Cheryl, start the clock.
Okay. Go ahead, sir.
Go ahead.
All right. Good evening once again. This is case 19128 versus Sergeant Brian Rodriguez and various other SFPD parties. We'll begin on PDF page 98 or footer page P814 of the item 6 attachment. So the issue here is I sent an immediate disclosure request to both Brian.Rodriguez at ssgov.org, which is a particular person, an employee of the city, and SFPD legal at ssgov.org, for a specific email that I know exists that Brian Rodriguez wrote using a different email address about the conduct of the city's public business. And I sent it to both of those. On December 4th, the request was rejected by Andrzejczak, as you can see there. For that reason, they told me you need to go to the DOJ or the FBI for that other email address, and that is not true. The Sunshine Ordinance binds the, quote, person having custody of any public record, end quote. And that person here is Sergeant Brian Rodriguez. You'll see here in the bottom excerpt, I have requested a particular thread from 3 different email addresses, and we'll go into why I know about this on the next page. What you're seeing here is a public record produced by SFPD in a completely different record request. It is a forward from Lieutenant Torres to Chief Moser, including the body of an email written by an SFPD sergeant. You can see it halfway down the page. B. Rodriguez at rcfl.gov. And if you go to the next page, you'll see that he signed this as a sergeant of the San Francisco Police Department and as the deputy director of some entity called Silicon Valley Regional Computer Forensics Library, which I'll get into. Next page. Rodriguez is an employee of CCSF, and the records that he prepares, owns, uses, or retains in the conduct of public business are public records of the city, of SFPD, and Rodriguez, no matter where they're stored. And City of San Jose, the Supreme Court makes it very clear. An individual officer and employee having possession or preparing, owning, using, retaining, etc., a record imputes to the overall local agency. And they broadened the definition of local agency to include individual officers and employees. It's not relevant whether or not the FBI also has access to this record. This was a record made by a city employee about city business. Next page. Now, you may wonder, what is SVRCFL? It is not a separate government entity. The MOU, which is in the record, the contract between the SFPD and the FBI, states specifically that it is not intended to and shall have no legal status separate from its constituent governmental entities. There is no entity called SVRCFL. It also specifically states that the employees assigned to this SVRCFL group are not employees of SVRCFL or the FBI. Rodriguez was a city employee. He has to produce this record. And you might wonder, what if B. Rodriguez at rcfl.gov is stored on an FBI computer? That's not relevant. The Supreme Court held that the document status doesn't depend on the physical location of a record. As long as a city employee or officer prepared, owned, used, or retained the record, and it is about the conduct of public business. In this case, it's about the forensic analysis of Brian Carmody's computer. That's it. That's all I have to prove. Last time they were here, if you go to the next page, you'll see if you don't rule that these are public records, you're incentivizing the SFPD to basically just hide their records on other agencies' computers. It doesn't matter whether the FBI could also produce this record. SFPD and Sergeant Brian Rodriguez have to produce it themselves. Now, last time, Sergeant Andrzejczyk, who is the person having custody of the record, told you that they had never asked Brian Rodriguez whether this record exists or to produce it or anything. And I don't know if that's changed by now. They refuse to respond to any of my emails about this request. But I think in the clear City of San Jose case, it doesn't matter that it's a different email address. The fact that a city employee wrote it, it's about city business, that's all I have to prove. And at this point, I think I'll only ask that you find a 6721B violation because it's not a complete response. You should order them to produce the record, have it go to compliance, and then they'll either agree or disagree, and then the rest of the stuff can be decided later. But right now, we don't even know if they have searched for this record and whether the record exists. I have a lot of evidence that the record exists because I can show you a forward of that email to someone else. But they have to search, and they have to give me a yes or no answer. Are there any public records? Are they disclosable? And if not, what citation to the CPRA allows them to exempt that record? Which they have done none of those things. Thank you very much.
Thank you. Are there any persons or witnesses to provide any facts or evidence on behalf of the petitioner? Hearing none. Respondent, Sergeant Andrzejczyk, you have 5 minutes.
Thank you.
Go ahead,
Just confirming that. Thank you. Confirming you can hear me.
Yes.
Great. Our response is as follows. We challenge that a request for emails is an immediate disclosure request or qualifies as an immediate disclosure request. Immediate disclosure requests are for something that is routine and readily available. Going through emails is not a task of something that is routine or readily available. Sergeant Rodriguez is a member of a task force. He works on cases for any number of law enforcement agencies in the state of California. And some of these are open investigations and matters that have sensitive topics and so forth. So therefore, we challenge that it was acceptable or that it should be accepted as an IDR. We also challenge that Anonymous would send his request directly to the sergeant, regardless of what email address he's referring to. Anonymous is an avid and routine requester. He's here before you folks at the SOTF on a regular basis. He understands the process. He uses the process very well. There is a process in place for public records requests to be sent to the custodian records just to ensure that things do get handled properly and in a timely fashion. If there was a delay, in this case, it was due to Anonymous not following the established protocol, which again, he's a very avid and routine requester. We contend that the San Jose decision does not apply. San Jose decision deals specifically with personal email accounts and persons doing official government business on personal email accounts. And again, this is not the case in this particular manner. Anonymous references a prior Public Record Act request in which documents, emails, responsive emails, if you will, were provided. We are prepared to provide Mr. Anonymous with those emails that have already been released in accordance with that other public record request. At this point, there's no way to know if he's the same Anonymous who requested those. He may already have them in his possession, but we're prepared to do so. However, this is an open investigation. There's still an open criminal investigation concerning this matter. There are additional records that we've identified, that Sergeant Rodriguez has identified, but we are exempting those records from release under 6254F of the government code, as there is an open criminal investigation. And thank you for your time, and appreciate you guys, and appreciate you hearing this case. I'm going to go back on mute till you need me.
Thank you. Are there any persons or witnesses to provide any facts or evidence on behalf of the respondent? Okay, hearing none. Our discovery time, any questions or for the parties, clarifications, what have you?
I have a question for the respondent. You just said, oh, sorry.
Go ahead.
You said that because it's an ongoing investigation that you have documents that you deem exempted. Do you deem the documents that are the subject of this situation, this case that we have here today, that those are also exempted?
I'm not sure that I understand your question. Anonymous is requesting emails that Sergeant Rodriguez provide emails from his end on the FBI task force server or email account, however it is you want to explain that. And the emails that he's asking for, yes, they do pertain to to an open criminal investigation. And we acknowledge that some emails were released before to another public records request. We did not recall those emails. So they are out there, they're in the public domain, and we are willing to provide those emails to Anonymous, but again, I think he already has this. I think that's what prompted him to file this new request.
Okay, but the Rodriguez communications that are at issue here today, are you saying that you've already made the claim that they're exempted?
We're saying they're exempted because they're part of an open criminal investigation.
Okay, and could you just tell us again which exemption that is?
Under 6254F of the government code for an open investigation.
Okay, and is that an exemption that you've put in writing to the petitioner, Mr. Anonymous?
I don't know. I don't believe that we have. I'm preparing an email for him this evening. Actually, I expect I'll be able to send him these other emails tomorrow with a more, with that explanation as part of that.
Okay.
But let me interject for a second.
Thank you, officer.
Let me interject for a second, Sergeant. At the time that the request was made and you withheld the records, was that investigation still open?
Yes, it was, but I don't recall citing that as an exemption. Oversight on my part, if that's the case.
And did you cite it as a exemption for responding to the complaint to the Sunshine Task Force, other than today?
Not to my recollection.
Okay. Thank you.
You're welcome.
Go ahead, Vice Chair Yankee.
Oh, I was just hoping that perhaps the respondent could speak a little bit more about Sergeant Rodriguez's affiliation with this additional task force. Just to clarify for the record, is that through his employment with the, police, San Francisco Police, or is that a totally separate second job, volunteer, whatever it is, on his own time type of thing?
It is through his employment with the police department. It is his current full-time assignment. He is a San Francisco police sergeant, and he is assigned to that task force.
Okay, so he's operating, as a city employee in that, assigned to that role. Just to clarify that, right?
I would say yes. He may have some federal. What is the word I'm looking for? He may have been sworn in as a federal officer of some sort or something like that, but he is still a San Francisco police sergeant. Yes.
Okay, and the reason I bring that up is because I have some concerns about somehow saying that because it's worked under the task force, the FBI or whatever, that it's not city work. It sounds very clear to me from this that he's obviously operating through his course of employment as a city employee and creating these records, these emails as a city employee, perhaps assigned to an outside task force, but still as a city employee. So thank you.
Sure. I mean, I can tell you he is still a member of the police department, and he's still a sergeant for the police department. Okay.
I do have one more question.
Membership.
Has Officer Rodriguez ever indicated to you that he would not be capable of accessing these requested communications?
Repeat the question. I'm sorry.
Yeah, I'll ask it. I'll ask it in a better way. Here's my second draft. The requested communications. I wonder if Mr. Officer Rodriguez has ever described any obstacles that he has encountered in trying to access copies of those communications.
Like physical obstacles?
Well, has he told anyone that anyone at this SVDIA prohibits him from accessing his email account?
I don't think anyone's told him that he's not allowed to access his email account. No.
Okay. So as far as you know, he has free access to the account.
Yes.
Do you think that he still does have that access?
That would be my understanding. Yes.
Okay. And nobody's ever told you that there's any kind of sort of written guidelines which would restrict him accessing those accounts, correct?
Yeah, I'm not aware of anything like that.
Okay. Thanks.
Thank you.
Chair Wolf, you're muted.
Sorry. I have a mechanical keyboard. It makes a lot of noise, so I'm muting. So this is a question for petitioner anonymous. You stated that this Silicon Valley Regional Computer Forensics Laboratory doesn't exist. Did I hear that correctly?
No, that's not what I stated. What I stated is it is not a separate legal entity apart from the SFPD, FBI, and whoever, and that's from the agreement that created this task force. I can give you page numbers if you need it.
I believe it's page number 104 of the PDF and page 820 of the record. Is that correct?
That's the entire MOU, but the citation with paragraph number is shown on page 102, page 818 on the bottom. That would be paragraph IV-B-1 and IX-A, which are quoted right there.
Oh, I see. Okay. Okay, so Sergeant Andrzejczyk, am I pronouncing your name correctly?
Andrzejczyk.
Andrzejczyk. Okay, great. So what of these particular statements that are contained in the MOU with regards to the relationship of SVR CFL to the city?
I don't follow your question. My apologies.
Okay, so in the MOU under section Roman numeral 4B1, between the San Francisco Police Department and the Federal Bureau of Investigation, it states, quote, the SVR CFL is not intended to and shall not be deemed to have or be represented to have any legal status separate and distinct from its constituent government entities. So the constituent government entities is City and County of San Francisco.
I just opened up the MOU. I'm not an attorney, obviously, so you're asking me to interpret a legal contract between the city and county and the FBI. So I don't know that I'm qualified to do so.
But your testimony was that it is separate. That it has nothing to do with the city and county.
Well, it's a separate entity. The sergeant is assigned. He's actually a deputy U.S. Marshal, deputized as a U.S. Marshal, I should say. He's still a sergeant in the police department.
Yeah.
Roman numeral
4B1, 4-B-1. I mean, if you're going to make that statement, then you kind of have to back it up with the evidence of that. What the petitioner is bringing forward is a counter. It runs conflict to what you're stating.
That the sergeant is still an employee of the police department and assigned to the task force? Sorry, I'm not.
Well, you have section Roman numeral 4-B1, which basically says the entity shall not be deemed to be separate from its constituent government entities. So it's not separate from the city and county, from the San Francisco Police Department. It is deemed to be an actual department or a division or some sort of attached entity of the city and county, San Francisco Police Department. What you're referring to is section Roman numeral 9 -A, which basically says it even more clearly that SVR CFL is not a separate legal entity capable of maintaining an employer-employee relationship. And as such, all employees assigned to it shall not be considered employees of SVR CFL or the FBI, unless, which means that they're still employees of San Francisco Police Department.
And that was my statement earlier. He's still a sergeant employed by the police department, but he's assigned to the task force.
So it's the premise that is being brought forward to us is that Sergeant Rodriguez is still, whether he's been assigned to this SVR CFL entity, he's still an employee of San Francisco Police Department, not an employee of SVR CFL or the FBI, unless there's some other, document that says that that it authorizes his status as something else. But by that token, the SVR CFL is not to be distinct or separated from the San Francisco Police Department.
I'm not challenging that he's, not a member of the police department. He's detailed to the crime lab, and he's got a deputy U.S. Marshal status as part of that. If we're looking at the MOU, section Roman numeral 16H talks about the release of information to the public. No assignee shall disseminate to the public at large any text, journal, treatise, or other material relating to the forensic examination or analysis of digital evidence that discusses or discloses any policy, practice, or procedure that has not been clearly authorized for public dissemination or has otherwise not been made public. Section J talks about records. The executive board shall vote by majority direct that one of the participating agencies be deemed the owner and custodian of such records of the SVR CFL. So there's some other significant aspects of this MOU if we're going to call those to your attention, then I direct you to those as well. All records determined by the FBI to constitute FBI records shall continue to be owned by the FBI and are subject to the FBI Record Management Division rules, regulations regarding the retention, disclosure, or destruction of records. Further, all records returned to the FBI as directed. So I think those should weigh into your consideration as well.
Okay, thank you.
Certainly.
Yeah, go ahead, Member Schmidt.
There is a course of action, of course, for Mr. Anonymous, and that is to file a FOIA request with the federal government. That's my understanding. The proper way to get the emails, if you're looking at the MOU and how it's laid out and so forth, it appears that the FBI is custodian the records, or at least as it says here, one of the participating agencies deemed owner and custodian of records, that the FOIA would be the proper way to go.
Am I allowed to speak to this part?
One moment. I just wanted, Member Schmidt, did you have a response? Did you raise your hand? You're on mute. You're on mute. Member Schmidt.
Thank you. Thank you. Sorry. This question is for Anonymous. You heard that Sergeant Andreychuk has offered to give you in writing confirmation that they are claiming that the communications that you're seeking here are exempted. Is that satisfactory to you? And if not, why not?
Sure. Hold on, let me give you the page number. 1 second. Trying to find the page number to give you a precise response to that. So on page 98, the bottom half, those are the 3 requests I made to them. And I understand that, as they have stated, they're now changing their response. Their earlier response was, go talk to the FBI, and they did not give me a legal justification. You can see that statement on the first square. That's the literal response they gave me. There was no legal justification. Now it sounds like what they're saying is, we do acknowledge that records exist that are responsive to this request, and all of them are exempt under Government Code 6254F, Open Police Investigation. I think in order for the task force to determine whether that is a compliant response or not, you need to ask them. So the CPRA requires under Government Code 6253C that they tell you for each of these requests whether they're a public record, and second, whether they're disclosable. This kind of broad response from Sergeant Andreychuk, I don't think complies. 1, because it's 1 year after I made the request, but 2, there are 3 separate requests here. So I invite the task force to instead ask Sergeant Andreychuk for request number 1, which is on brodriguez@rcfl.gov. 1, are there any records? 2, are all the records exempt under what you cited? And then ask the same thing for, you don't need to ask it for 2 because they already told you that request number 2 has no records whatsoever. But you need to ask them, are they specifically responding to my request number 1? And if they tell you, yes, records exist and all of them are exempt under 6254F, I would challenge that, to get to your second point, that I would challenge that because the CPRA has a section, and I'll go look it up, that once you disclose a record to someone, waive the disclosability of that information. And so because in public record request P8985, they gave responsive record 4, page 13, this copy in a different form of that email, at least that one record from brodriguez@rcfl.gov, I think would not be exempt under 6254F because they waived that by giving it to me by giving a copy of it in some other form to me in a different record request. And I can go look up the CPRA section that talks about waiver if you need that.
Now, the document you just said you've already received in another form, are you still trying to get that here today, that document?
Yes, because they didn't, to be clear, they did not give me that other request the specific record I've requested here, which is the email sent by Brian Rodriguez with the subject. What they gave me is an email sent by Lieutenant Torres to Chief Moser without Brian Rodriguez anywhere on there that includes a pasted copy or a forwarded copy of this other body of an email. But for example, I wouldn't be able to get from that attachments and stuff like that, right? But anyway, they would still have to produce this one email in this form, in this request, because they waived the exemption of that information, even if they say the replies and other things are 6254F.
Okay, thank you.
Any other questions, members?
One quick question.
Vice Chair Yankee.
And this goes back to about the part about making a records request in general. I just wanted to talk a little bit about, is it your contention that if an individual does not follow your prescribed process for submitting a records request, and for example, in this case, submits it directly to an individual, that you don't have to respond to it?
No, that's not what I'm saying at all. But you walk up to an officer on the street, drop a public records request on him, he's probably not going to know what you're talking about or have the resources, to immediately deal with it. The sergeant got the email. He wasn't sure what it was, what to do with it. He did forward it to me, and then I took immediate action in order to help try to address Mr. Anonymous's request. That's what we do here. You guys rarely see media relations there at the task force. That's something I try to avoid and something that I'm proud of. And Mr. Anonymous, we have disagreement, and we have made some improvements and room for improvement in how we do things. But we really do take it seriously, and we do try to respond appropriately and within the time required by the code.
Okay, and I do appreciate that, obviously the sergeant in this case, forwarded on to you and that there was a response. And I understand there's probably a process set up to, streamline these things, but I just want to make it, make sure we're all on the same page that, if someone doesn't follow that specific process you have, it doesn't necessarily mean that, it's not a valid request. We still have to, encourage, anyone to follow up with these requests. And so I see that done here in a roundabout way, but just as a point of clarification.
Yeah, absolutely. I would hope that if someone walked up to an officer on the street, that it wasn't in the middle of an emergency, of course, and that officer would ask, what am I supposed to do with this? Who do I call? In this case, that's what the sergeant did.
Okay, that's all I have. Thank you. Chair Wolf, you're muted.
Sorry, I'm doing it. Anybody else? Any other questions? Clarification and discovery. Are we ready for rebuttals? Okay, let's move to rebuttals. Sergeant Andrzejczyk, you have 3 minutes when the administrator tells you she's ready.
Go ahead, sir.
Well, thank you. Thank you for the time. Made my case, and I've learned that Mr. Anonymous is the same requestor who received those other emails. But if he's still open to us sort of re-providing, resending those emails to him, I will do so. But it sounds like he doesn't need them because he already has them. So I'd rather not go through the motion if I don't have to. And I think that's it. Thank you for your time.
Okay, thank you. And petitioner, Anonymous, you have 3 minutes of rebuttal.
Sure.
Go ahead.
So first of all, I want to point out something very important. No matter what happens, even if you think all these records are 6254F exempt, what they did is not legal. They can't just not respond and tell me whether the records existed and whether they searched for them in, the year ago when I requested them, refused to respond to any of my emails about this request that I have followed up quite some time until now, and then today come here and tell you, well, it's all 625-4F exempt. That's not legal, and that would be an incomplete response and a failure to justify withholding, 6727 as well. I still don't understand, and you should ask them. I don't know, you can just ask them. The CPRA requires them to give me a determination of whether the public records exist and whether they're disclosable. And I still don't know right now. So did they do the search and they did say that there is, one or more records on the B. Rodriguez at rcfl.gov account? That's my request number one. And they've determined, they've gone through them, they've reviewed them, and they say they're 100% 625-4F exempt. I still don't know that answer, and I don't think he's willing to give it to me. But you could ask him. You have that authority to ask. And if they argue that, I would say no. That one email, we have proof that the one email authored by Brian Rodriguez sent to this Lieutenant Torres and various other people, we know that record exemption, if any existed, which I don't concede does, was waived under the CPRA by disclosing it as part of a different record. He claims that I already have this record. That's not technically true. I have the body of this email in some other email. If after this thing, and you find in my favor that one email is disclosable, he should produce that one email and then send the proper written response that the rest of the records we have searched, they exist, and they are all exempt under 625-4F. But I can't get to that point until he has given me a response to my records request, apparently correcting it. At this moment, they are not compliant. So at the very least, you need to find a 6727 violation for not providing a written justification and a 6721B violation for not providing a complete response. And then when it goes to compliance, hopefully by then, hopefully tonight,
30 seconds.
I will get such a written justification. And if we needed to come back here for other records, we can do it at that time. But right now, until this moment, I never had a justification. I just had, who knows if the records exist or not. And that's a different response. So at the very least, 6727 for written justification and 6721B for incomplete response, and we can deal with the rest at compliance. Thank you very much.
Okay, thank you. Okay, deliberation time, members. So a lot on our plate here.
I if you don't mind, I'll get it started.
Go ahead.
Just because, I think Anonymous raises a very good point, and I'm kind of troubled, especially because this already went through the complaints committee, that now we're hearing about a 6254F exemption. That very well may, and I looked it up, and it looks like that there's, high potential that it might apply here. The problem is, here we are now, and how many months have gone by since these original records were requested, right? And it's now verbal, it hasn't been in writing or anything. So I think at a very bare minimum, I'm seeing a 6727 violation for the exemption not being, what is it? The withholding of information, it was not justified in writing. So like I said, at bare minimum, I'm seeing a 6727 violation here.
Yeah, I have to agree with you on that. I mean, we've had this happen many times before, where at the time of the request, the reason for withholding is not given, and then subsequently not given, and then at the time it comes in as a complaint, it's still not given until we are at the hearing, and then at the hearing, so miraculously, there is some sort of justification at that time. That it doesn't count after the complaint has been made. It has to count at the time that the request is made. That's the Sunshine Ordinance is about that. We are here to find if somebody was non-compliant with the process that is laid out between a requester and a respondent at the time of the request, not at the time that it's being adjudicated. So I absolutely agree with you that this is it's too late for a respondent to claim withholding, at the time of adjudication.
I agree with Member Yankee. The way you expressed it, you said at minimum a withholding of justification. And I would agree that there is a violation in the withholding of the justification, yes. Although if either of you gentlemen is saying that you're talking about adding something else in, I think that may be a different matter. But at least with what it sounds like you both are in agreement on, I'd be in agreement on that also.
Right. What I'm saying is when Anonymous made this initial, request, and if 67 or 6254 after the government code applied, and it very well may, then the police department should have responded back at that time and said these records are exempt under 6254F, right? That was months and months and months ago. And, he is entitled under the Sunshine Ordinance to receive in writing the justification for the withholding, right? And he didn't get that. Now, like I said, 6254F may very well be applicable. The problem is he was never given it until literally just minutes ago, right? So I guess, just to, get things rolling, I'll move to find a violation of 6727 for failure to justify the withholding of information in writing.
I want to request that you hold the motion.
Oh, sure.
Because there are other questions and aspects to this that I think need to be addressed that might be included. There'd be more violations that we might want to consider. I have a number of concerns, and I'd like to get through the deliberation first. So you can just notate that.
Sure. Yeah.
And when we come to that point, that would be great. So we can avoid multiple action items. I do have a question for us, and I think the petitioner brought it up. Is just a question of, are the records that he is requesting actual FBI records? According to the MOU, it kind of dives into that section. The question is whether the information. It's interesting, this MOU, and the way it's laid out, and the question is whether if anybody, there's nothing in here that actually necessarily discusses that it would supersede state law or supersede the local law that I can find. I didn't quite read this whole thing, word for word. But the question is whether the information that the petitioner is asking for I think that was 16. Was it 16G? No, 16F. No. Where was it? There's one, I think the section that the sergeant had pointed us to. I think he said it was 16. Records, yeah. So under 16, what is that titled? Equipment, vehicles, and office space. That's what it's titled. And under G8, so we got under H, release of FBI or CVR, CFL information to the public. Basically, let's see, shall not, except as authorized by the laboratory director or by any action or policy of the executive board, no assignee shall disseminate. And it's all this list of stuff. practice or procedure of the SVR CFL that has not clearly been identified as authorized for public dissemination or has otherwise not been made public. So then the question is of the information that now we don't have any jurisdiction over this MOU, but it speaks in the same language of 6727 by providing justification as to whether any items have been authorized for public dissemination or otherwise, already been made public. And then it also talks about the laboratory director shall ensure that any release of FBI information is consistent. Okay. And then you go to J under records. The executive board shall by majority vote direct that one of the participating agencies be deemed owner and custodian of such records. Okay. So that's an interesting question that I'm going to go back and ask Sergeant Andrzejczyk about that. In the MOU under section Roman numeral 16J records, it says the executive board shall majority vote direct that one of the participating agencies be deemed the owner and custodian of such records. Are you aware of that such a vote has been taken?
I am not, and if someone has been appointed, if you will, that responsibility, I don't know who that person would be. The sergeant called me a few minutes ago and told me that he was directed by FBI counsel not to release emails and to direct the request or to file a FOIA. So if that's possible, that
I understand that would be a standard answer from a federal agency, but we have our own laws here in the state and local, that may or may not apply independently. At the same time, it does provide an alternative. It says, in the absence of such a directive by the executive board, such records shall be deemed the property of the general treasurer agency. Do you know what that is?
I do not. Sorry.
Okay. Anonymous, do you know what general treasurer agency is?
I want to make sure I'm looking at the right line number. We are talking about P847, page 28 of the MOU, subsection 1 of paragraph J. Is that what you're talking about?
Yes.
I have no idea which agency is the general treasurer agency, but my point here is nothing in this MOU can override either City of San Jose or CPRA. It's a contract. Contract is lower than a law, but yeah.
Well, I mean, we don't. The other thing is reading on in this MOU. Well, it's true, it is lower than the law. But reading, there's a subsection 1 under J. It says all records determined by the FBI to constitute FBI records shall continue to be owned by the FBI. Sergeant Andrzejczyk, do you have any documentation or information that shows the records that petitioner is requesting are owned by the FBI?
I do not.
Okay. All right. Thank you. So that's something to consider, members. Another one. Go ahead.
I have a follow-up on that line of questioning.
Sure. Go ahead.
Before you move on.
Sure.
Yeah. Chair Wolf just asked a question of you, Sergeant Andrzejczyk, and you said that you just had a conversation with Officer Rodriguez. Is that just tonight?
Sergeant Rodriguez, and yes, that was.
Okay. So he told you that he was told by the FBI not to give up this documentation, correct?
Correct.
Okay. And did he say when that direction not to give it up was given to him? Was that back when he first obtained this request?
I can't answer that question. Okay.
Okay. You don't know when it happened, that he was instructed?
Correct, I don't.
Okay. And could you be as specific as you can about who it was at the FBI who told him don't give that information?
Someone on their legal counsel? I wouldn't be able to tell you who specifically.
But he said it was someone with legal, FBI legal, right?
Yeah.
Okay. Okay. Thank you.
You're welcome.
I've got a couple of more items here for us to consider. Okay, so I have a little problem. This is something that's come up before with not just the police department, but with other departments. They're making a requirement of how people are to make public records requests. That they want them to go through a very specific portal or a very specific place, and the ordinance does not require that, and neither does the CPRA. This is something that is internal of any department. I do understand that we have had situations where people go on vacation and they aren't getting, or they're taking a leave of absence or what have you, and they don't get it. Sometimes some departments set up a listserv, and so then there are multiple people that can see it, but then that sometimes doesn't get checked often enough, so people miss. There's a timeliness issue on responding there. And then we have the current new next request system that not everybody in the city uses yet, but that does offer a little better tracking. I believe the police department has their own system that is not next request. I can be corrected on that. And there has been some concerns and questions with regards to that that we've come across also. So, but the ordinance does not prohibit any person making a request to make a request of a custodian directly. The custodian can then say, I have a public information office that will handle this and transfer it to them, which is generally how things are now being done. But the actual request is by the ordinance is directly to the custodian, and the custodian is the one who's responsible for the response. So even though the CP, this is about the uniqueness and the enhancement that the state law allows for creating a local sunshine ordinance. The CPRA is focused on agencies. So request comes into anyone, it's the agency that responds. If there's a violation of CPRA, it's a violation of the agency, not necessarily the person. The Sunshine Ordinance has created enhancement of that. The voters created this to make it that the custodian itself is the responsible party, and that any non-compliance is on the responsibility of the custodian. So that said, just want to give context because we hear this, that people didn't go through the right process or the right procedure for submitting requests, and it's something. There's nothing written in law that says it has to be done that way. But sure, their request may not be found in time or what have you, and there is sometimes resistance to want to find a middle ground somewhere. Another item is in the beginning of Sergeant Andrzejczyk's testimony, he stated that this IDR was not like regular. It's, you know, as under 6725. And we have heard this countless times that if it's not a regular request or simple or routine, you know, that the custodian automatically converts it into a regular request. Well, we have held that depending upon it, because there's no description of what simple or routine or otherwise readily answerable request is, that is not allowed. We have held that it's a precedent of ours. That people don't really understand necessarily what 6725 means or how it is to be implemented. It is a response with or without the record by the end of the following business day, or the end of the following, is it business day? Following day of the, close of business on the following day of the request, okay? If the record cannot be gotten, it's just respond within that period of time. Yes, we have that record. No, we don't have that record, or we need more time and invoking an extension to be able to get that record because maybe it exists, you know, in some other office across town or what have you. Or because of now we're dealing with COVID, you know, it may not be readily available electronically or what have you. That is a big mistake that a lot of folks make. And this assertion that they can summarily just convert an IDR into a standard routine request is just not correct. The next point I have is, and I think as Vice Chair Yankee had put it, that that not only did they not provide a justification at the beginning of this request, but subsequent interactions or subsequent inquiries by the requester for, you know, following up and figuring out why it has yet not gotten requests was not even met then with the same justification that was presented to us for the first time here today. So it didn't happen at the beginning for the 6254F, and it didn't happen for all since 2019 all the way till today. So, you know, it's one thing if it didn't happen in the beginning and then they said it, you know, after maybe the third, you know, inquiry for status. So I wanted to make that point. Then I just have a quick question for Anonymous. The email that was either in the body or as an attachment to the email that you had gotten, communication you'd gotten from you know, Sergeant Torres, is that the only document that you're looking to get with regards to what we're dealing with right here?
Sure. No, if you look at my original request, the request asks for that original email sent by Sergeant Rodriguez and every reply and forward, basically the thread. And it seems like they're claiming everything, they're claiming that does exist, it is 6254F withheld. And my argument is that that email, that at least that very specific original email, is not a quote FBI information or FBI record, because he's not an FBI employee. That's my point, right? That one email I should get, even if they now argue that the rest of them are 6254F exempt. At least that one email I should be able to get. Yeah.
Okay. Okay, thank you. And the last item I have is, I'm not convinced, and this is no slight against Sergeant Andrzejczyk, I'm not convinced that the police department has sent a representative that is knowledgeable enough to be able to answer all our questions. And I'm concerned about that because we deal with that a lot. Representatives come, they're part of a general public information office, and they don't do enough investigation to have all the answers. And then when they don't have the answers, and then we request to get the answers, and we continue not to get the answers, we then request that the custodian come and compel them to come and ask the questions, answer the questions, and then we end up in this big negative feedback loop all the time. So we have found many times that when we can't close a case because of representatives that are being sent that are either are not knowledgeable because they weren't given enough information or didn't make it their business to be prepared for the hearing here, then I think that should also be considered in our actions. So that's it. That's the end of my list. Okay, now, Vice Chair Yankee, you can start with your motion if you have one.
I'll go back to my motion, and I will move to find a violation of 6727 for, how did I phrase it? For failing to justify the withholding of information in writing.
Okay.
I will second that motion.
Can we do this before you make the motion? Because I just wanted to see if we can formulate this with some of the items that I brought up too, and see if there's some agree. We can just kind of.
I'm considering making that motion.
Okay. So we have 6727. I would say that there would be a violation of 6726 for responsiveness, not responding. What's the word?
Addressing?
Not respond. Sorry?
I said addressing.
Well, no, just not responsive. It just was not.
Well, I think they responded fairly quickly. It was just
yeah, but no documents.
Right.
And and then subsequent to that, no justification for withholding.
Right.
6727. And then
6721E.
What is it? It's stated.
Failure to send a representative knowledgeable. We can tack that on.
Yeah, that's right. Okay. Okay, and then the last one is to that, and this is a matter of deliberation that I was checked in with the petitioner about, is shall we order that one email that was that Anonymous had received from, or that is known to exist from Sergeant Torres be disclosed with the document, the email that was contained in it by Sergeant Rodriguez.
Chair Wolf, could you be a little more clear about that last one? What is it that you would want to order disclosed?
So the let me find it. It's on. trying to find the page so I can show you. No, it's not there. What page was that on?
I know what the emails are, but what is it that you want? You want what already was given to him to be given to him again?
No,
is that what you're saying?
So on page 8, on page P815, PDF page number 99. This is the email from I don't know whether it's Sergeant or not, but Pilar Torres that has Sergeant Rodriguez's email that's in the thread of it. And the petitioner anonymous is stating that this email is not part and parcel of the entity that Sergeant Rodriguez is attached to. That the original email is just a San Francisco Police Department email, and that is subject to Sunshine, to be released from Sunshine. And this is not a Smith versus San Jose issue. This is, within the confines of the city's communication systems.
So you're saying but he got it. Are you saying that you wanted him to get this and more of it?
The original email from, so if you look on page 815, you look on page 15, and you look at where that dotted arrow is down, going down, right? That is an email that Officer, we'll call it Officer Pilar Torres had received. He CC'd in that email from Sergeant Rodriguez. Okay, so the request is not to Sergeant Rodriguez. As far as the petitioner is concerned, he didn't even know that Sergeant Rodriguez at the time he made the request is even part of any of this. He gets this email as either, I don't know how it was produced, but he has possession of this email from that has Sergeant Torres in it, and it has contained in it an email that was already emailed to him. He wants that email from Sergeant Torres, not from from Sergeant Rodriguez. He wants it. He wants that original email that is contained in this thread, and all the entire thread from Officer Torres. You follow me?
The entire thread. Okay. So you're talking about the entire thread that should be, you're saying that's the subject of what you want to add in here, that there be a compelling the entire thread that's indicated by this segment of the thread.
Right. And forgive me, I'm sorry, I just see it now. It's Lieutenant Torres. So just want to make that correction for the record. Yes, he wants all the emails that Lieutenant Torres has, the original emails, emails as they were sent, so that they have the metadata in it. And of course, as we heard in our just previous case earlier with the Department of Technology, there is now a process for redacting metadata. But he wants he doesn't want it, he wants the original email, not how it's produced here as part of the body of the message, as being part of a forward message, right?
Sure, I get it now. Yeah.
Okay, great. Does everybody understand what I'm asking for here? Okay. So I'm suggesting that we order that that the emails that are part of this thread be produced and delivered to the requester in their entirety with the metadata.
Well, I could say that I'm not real. I would lean against the whether he's a representative most, with knowledge. I think he is, but that's not a huge deal to me. But and on the last part, I agree with you that this whole thing with this Silicon Valley thing, that doesn't constitute any basis for me to prevent Anonymous from getting the documentation. That I agree with. But it looks to me like we're talking about an exempt document. And so I would not want to vote, and I don't think I could vote, to compel that exempt document as part of a motion.
Which exempt document?
The one that's, they're claiming an exemption to the document that is the Rodriguez document that they've said that these are, exempt because they're ongoing investigation documents. And so that's what I think still would apply. And it works for all those attachments that they say they're exempt.
That's fine. If they want to exempt them, they can redact those or withhold them, and the requester can, come back to the task force and, and make additional inquiries about that. What I'm just talking about is these emails. These emails are part. It doesn't matter that it's from this RCFL or division, which he's already claimed, and I think it's clear from what we can see in the MOU that it's a division and part and parcel to the San Francisco Police Department. But what we're talking about here is this email from Lieutenant Torres, which is, it doesn't matter whether it has Sergeant Rodriguez in it or not, doesn't matter. The requester is asking for this email that is public record from Lieutenant Torres. Now, if they're going to claim this under 6754F, that it's part and parcel to an investigation, it's kind of hard, because they also claim that they didn't necessarily pull back any documents that were already released. So, okay, if they didn't pull them back, then they can't pull back this one. This one's now already public. And the requester is saying, at least give me this one, because this one has been already made public. So he wants this email from Lieutenant Torres, and he wants all the other emails that Lieutenant Torres has received.
Well, you can't say that he's both made it public and not made it public in the same breath. That's not right. The Anonymous is looking for documents that, as far as I can tell, have not been made public. And so those are the ones that are being kept not public, and because of an exemption. This document is in the public, but those aren't. So,
I get
yeah,
that. I'm not concerned about those other documents. I'm only concerned about the email. He's just that was basic. That's why I asked him that question. Are you concerned about getting any of the other documents, or is it because we don't know what they are? There's no listing of them. There's no real log of them or anything like that. We don't know if they exist, okay, or if they're allowable to be disclosed. I mean, we saw the MOU. It talks a lot about, the records cannot be disclosed for this or that. I don't want to necessarily get into the weeds of Anonymous's claim that the MOU is subordinate to state law and all of that. I think I'm not prepared to go down that road. I absolutely would need some legal advice on that. I think we all would. But at least on this, it doesn't matter whether it's Sergeant Rodriguez or somebody else. He just knows that this email exists. He could just even blindly ask for all emails from Lieutenant Torres regarding the subject line. And he may or may not get any response. The fact that this exists, that it's in our record here, and we can see it, I'm suggesting that at least this particular email and all the emails in this thread that Lieutenant Torres has received, that Lieutenant Torres is party to, be released, be disclosed in their. Not in an email thread, one email with a thread of discussion, but all the individual emails that are in Lieutenant Torres's possession.
Okay. At this point, I think we're maybe ships passing on the night on this one, so I'll just agree to disagree on it.
Okay. So, all right. So then I'm going to start the motion. Okay, to find a violation of 6726 for not being responsive not being responsive to the records, delivery of the records only. 6726 for failing to justify the withholding. 6721E for not sending a knowledgeable representative, and to order the production of all the emails in that discussion thread from Lieutenant Torres under the subject line of 1901491521 / Carmody, it's spelled CARMODY / acronym S Sierra, V Victor, R Romeo, C Charlie, F Foxtrot, L Lima, lab, # or number sign, and then acronym Sierra Victor -19 -0033.
Okay, I'm going to need you to repeat that because I'm trying to do this whole thing, and I want to make sure that it comes out correctly.
Okay, what do you want me to repeat?
Well, let's just review the motion. You said 6726 for not responding responding to the delivery of records, but I don't think that's correct. 6726 for failing to justify withholding. Why do
you think it's not correct?
No, because you said it twice, but you said two different things. You said 6726 for not responding to the delivery of records, and then you said 6726 failing to justify withholding and order production of all emails. So you said it twice, but I'm not sure.
No, I did not. I said 6726 for not responsive to the delivery of any documents, and then 6727 for failing to justify withholding.
Yeah, that's what you did. Yeah, I thought that was what you meant. Okay.
Okay.
And order
then
production. Okay.
6721E for not sending knowledgeable representative. Tell me when you're ready.
And order production of all emails that discuss the thread under the subject line. This is what I want to make sure I have right. 1901491521 / Carmody, CARMADY, MODY/SVRCFL lab hashtag SV-19033. Is that correct?
Correct. Correct. That's my motion.
Okay. Who wants to second that?
There's a second.
I will second that motion.
Okay, it's moved by myself, Chair Wolf, second by Member Wong. Okay. Members, discussion.
I'll go. I heard what Member Schmidt was talking about earlier, and I think I tend to agree with him, but I'm not particularly sure that I agree with the 6721E about a knowledgeable person coming. Maybe if we want to separate that out. Obviously, I agree with the violation of 6727 and all that we talked about. But I'm not sure I'm quite there on the 6721E part.
Okay. Yeah, Member Wong.
Yeah, I guess in response to that, I would say like the main issue I take with the knowledge is that there's no real details on SVR CFL, and also the MOU related to that, and that's something that I would have liked to know more about, and perhaps that would have been the case if we, for example, had Sergeant Rodriguez here instead. Maybe he would have had more information on that.
I understand that, although the main defense I'm hearing now is that he's claiming that there's a 6254F exemption, which, be it what it may, obviously wasn't made until just now, right? And so he seems to be knowledgeable enough to discuss that exemption and how it may apply. Obviously, I don't believe that it was, properly invoked at this point in the process. I think there's certainly a major concern about the timeliness of it, and as we talked about, the back and forth between anonymous and just going to complaint and everything, and now we're just hearing about 6254F. And I think that's mainly the crux of the current claim of why certain things might be exempt, which I do believe the respondent is probably, familiar enough to discuss with us. So I guess for me, I just don't see the 6721E on this.
Except, I ran a line of questioning with regards to the MOU and regards to the public records disclosure section of the MOU, and he was unable to answer any of those questions. Cannot tell us if any of the documents that he's claiming under 6754, under 6254F, it has any, if they're FBI records or not. I mean, it's just a blanket statement that because this is open under investigation, but not necessarily claiming which parts. It just saying all parts of it. We don't even know what parts, based on the requester's original request for information, which parts are not. There are parts that have already been made public, and the respondent's testimony is that they didn't pull them back. So that's what leaves a lot of question to me, and not being able to answer whether the records, according to the MOU, if we're going to give any credence to the MOU, that they're, whether they any of the executive board, or the executive director, or even what this the caveat of this treasurer of some sort, that is the main default. There's no answer to that either. So unless Sergeant Rodriguez has that information, or the responsible governing body parties of this division of the San Francisco Police Department appears before us and tells us, or provides it in writing, I'm not convinced that we have a person here who can answer enough of the questions in order for us to be able to determine whether all these records are being withheld properly or not.
I'm not sure. Yeah.
Schmidt, you talked about this a little bit. What's your feeling?
I think that the questions about the MOU, it's pretty hard to find witnesses who can really do contract interpretation. It seems like it's like putting a contract in front of someone and asking them to match up the terms of the contract with things. With most witnesses, you can't do that. I know that. And I don't know if we should put that on him to be able to do that as the representative of the department.
But he invoked it.
Yeah. I don't know.
Member Schmidt, he invoked it. He was the one that brought it up. We didn't bring it up. He brought it up. He used that as his defense. If he cannot defend it by answering the questions that are in it in writing that state what the conditions are, no court will accept that as being a credible witness.
Well, he's invoking it as a part. He's invoking on behalf of the police department. But then he can take a position, but that doesn't mean that he can give credible evidence, admissible evidence in terms of interpreting provisions of an MOU. They have a right to take a position without having the obligation that they have that witness be able to interpret that contract.
I'm calling whether the claims that they are putting forward for withholding are credible. And if they're going to invoke this MOU under section Roman numeral 16J and can't answer any of the questions as to what it says in black and white, this is their defense. They brought the defense forward. They have to defend it. They have to show that this is credible. If they cannot answer the questions that I'm reading from the MOU itself, and they're invoking this, that is not credible. That is somebody. I would just say, is there somebody else who can answer this question? Do you know that the executive board has made this vote? No. Do you know who the general treasurer is? No. Do you know if any of these records are to be deemed by the FBI to be FBI records? The answer was no. They didn't know. I don't know. I don't know. I don't know. I don't know how else to describe not being knowledgeable as an answer of I don't know.
Are you saying that they have to send all witnesses to any possible questions that we would ask them?
If they are going to invoke withholding based upon, as they put forward their defense of this MOU, okay, and they can't answer any of the questions based upon the question of withholding, then there's no credibility. It can't be.
Does the MOU then, can they not use the MOU? I mean, the MOU speaks for itself.
I understand that, but then you go, that's the area that I don't want to go down. If you don't want to claim the MOU, then you have to then say state law trumps, okay? Then we get back to the 6254F question, and the question there is, it's a blanket answer. The whole everything is just, everything is now not disclosable. Well, tell us which parts are and which parts aren't. They already claimed in testimony that there are certain records from this case that have been released publicly, and they're not pulling them back. So, you can't have it both ways. So that's why I'm putting in there not sending a knowledgeable representative. if you want to separate it out, I'm happy to separate it out. We can vote on it separately. If it sounds like we can move forward with the rest of it.
Speaking for me, I'd feel more comfortable if we separated it out, just so we could at least get behind.
I think I'm with Member Yankee on that.
Okay, I'm happy to do that, just to move this along. Member Wong, are you here?
I think she ran to the restroom real fast.
Okay, just wait a moment.
Okay, I think she's back.
Okay. Member Wong? Okay. So there's been a request to have the 6721E for not sending a knowledgeable representative being pulled and from the motion, and to have it be considered independently. Are you okay with that?
Yes.
Okay, great. So Administrator Leger, the motion is to find a violation of 6726, 6727, and to produce the emails.
Emails and discussion. Yeah. Okay, let me cut that out.
Okay.
Okay, so this second motion, is that being made by Matthew?
It would not. Wait. Hold on. We got to finish the first one. We'll get that other one on the floor after we're done with this one. So now we'll call for public comment.
Hold on, Chair. We're trying to still figure out if we've got this right. I think there were a couple of us with questions, and I know I have a question.
Okay.
As to whether Member Yankee meant to just separate out that one provision. Is that what you wanted?
Yeah, I was just asking to separate out the 6721E. But it's still Chair Wolf and motion. It's still his motion. I'm not making a motion. I'm just asking if you would amend it to separate it out. Right.
So we vote. The maker and the second has agreed to pull that one item. We'll make a second motion after we're done with this one. So okay. So any other discussion on these three action items? These three items. Okay. No. Let's go to public comment. This is public comment for members of the public, not parties and not witnesses. Is there any public comment? You want to make public comment, please unmute yourself by pressing *6. Okay, last call for public comment. Okay, seeing no public comment, are we ready for a vote? Please call the roll.
Chair Wolf?
Aye.
Chair Wolf, aye. Member Wong?
Aye.
Member Wong, aye. Member Schmidt?
Nay.
No. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
You're on mute.
You're on mute.
It won't unmute.
There you are. Now we can hear you.
Sorry,
Aye.
it got stuck. Aye.
Aye. And your vote is?
Aye.
Aye, okay. Member Hinsey?
Aye.
Member Hinsey, aye. Member Highland?
Aye.
Member Highland, aye. The motion passes.
Okay, thank you.
Okay, shall I repeat the motion? To find a violation of 6726 for not responding to the delivery of any documents, 6727?
No, we already did that. We're done with that. We've already mentioned what the motion was.
Okay, I was just reading it back, that's all.
We don't need to. The next motion is to find a violation of 6721E for not sending a knowledgeable representative. So I make that motion. Is there a second?
I'll second.
Second by Member Highland. Okay, discussion.
I have a question. I know that the respondent was not able to answer some of the questions in full, but this has happened in other cases and we haven't made this kind of separate sanction. Can you explain why you think this one meets some higher standard that hasn't happened in other cases?
Yeah, I'll repeat what my concern about this is. It's one thing when a respondent or representative for the respondent appears and absolutely has zero knowledge about a question or about information that is being asked of them. It's another thing when a respondent invokes a citation of law or creates a defense that they're unable to defend and have no knowledge based upon any inquiries about that defense. They were the ones that brought it up. We didn't bring it up. They invoked it. So if you're going to bring something up in the course of a proceeding as your defense and you have no ability to defend it, then there's no credibility. So there's no knowledge and no credibility for bringing that up, and to this, through all the hour or so that we've been through this, there still hasn't been any ability to answer that. And there are 3 sections in that particular area of the MOU. If we want to give credence to the MOU, now the petitioner says the MOU is subordinate to state law, and it could be even subordinate to the city charter, okay, with regards to, for that matter. So if we then take the MOU off the table, then the only thing left is the defense of 6254F. And if we wanted to claim 6254F as a ready defense, they provided no evidence of which parts of this of the records that are being requested are disclosable or not, and in addition, they've already testified that that there are records that have already been made public, and they didn't pull them back. So, either you open up the whole investigation at that point, it's not really protected under 6254F, or give us a reason as to which part of 6254F and which records apply and don't apply. So either hold some and not others, but you can't have it both ways. And you can't just make a blanket statement. And we've been through this many times before. And so if they can actually, and this is some of the parts where we have asked to be able to see records in camera so that we can make that determination ourselves. And here's a different situation where already parts of that case have been released publicly. And again, they testified not that they were not pulling those records back. So that's my premise, my proposal for finding a violation of 6721E for not sending a knowledgeable representative. I didn't say he's not totally not knowledgeable. He did a great job, providing the information and providing, the defense that he has. But with regards to making a case for the disclosure of these records, it's leaving me wanting more. Any other discussion? Okay, let's go to public comment. This is for public comment other than the parties. And if you have public comment, please unmute yourself by pressing *6. Any public comment? And last call for public comment. Okay, hearing no more public comment is closed. Please get ready for a vote. Please call the roll.
Chair Wolf.
Aye.
Chair Wolf, aye. Member Highland.
Aye.
Member Highland, aye. Member Schmidt.
Nay.
Member
No.
Schmidt, no. Yeah, I got you. Member Wong.
Aye.
Member Wong, aye. Member Yankee.
No.
Member Yankee, no. Member LaHood.
Aye.
Member LaHood, aye. Member Hinsey.
No.
Is that a no or yes?
No.
No. Okay, the motion does not pass.
Motion fails. Okay, thank you very much. Let's move to the next item. Thank you, parties.
Thank you.
Thank you, everybody. Good night.
Good night.
Item number 8, file number 19097, complaint filed by Anonymous against Muhammad Nuru, Jeremy Spitz, and Public Works for allegedly violating Administrative Code Section 6721, 26, and 27 by failing to respond to a public records request in a timely and/or complete manner, failing to keep withholding to a minimum, failing to keep redactions by footnote or other clear reference to justification, and failing to cite legal justification for withholding.
Okay, complaint committee.
I'm not recalling anything on this particular item. Was this one from last month, sure?
I didn't hear that. What?
Was this an item from last month that we had probably
October.
October.
No, then I don't remember this one. I don't know if any of my fellow members followed it. But so
There seemed to be pretty much a similar metadata case to other metadata cases. That seems to be the one significant issue in the case, metadata.
Okay. Anybody else have anything to add? No. Okay, I will just note for the record that despite director or former director Muhammad Nuru is no longer in the employ of the city, the request and the issue happened prior to that time. So we will proceed based upon when the violation happened, and not it doesn't matter that we're hearing this today. Okay, so let's get the clock ready. Are both parties here?
Anonymous
Yeah.
is here.
Yeah, public works.
And okay, great. Okay, so let's hear from the petitioner, Anonymous. You have 5 minutes.
Question: were you going to take a 10-minute break every 2 hours? I remember you saying that, or do you want me to begin?
Yes, we do. Does people want to do that? Or do you want to forge ahead? Forge ahead. Okay, let's take a
All
break
right.
afterwards. We'll forge ahead.
Okay.
Okay. Go ahead, Anonymous.
Thank you very much. This is case 19097 versus the respondents mentioned. We're in item 7 PDF, page 184, footer page 1118. This request was made in August 2019, almost a year and a half ago, for the 10 sent and 10 received emails of various DPW senior management, specifically with metadata. They gave responses from September 3rd through the 5th. There was no justifications whatsoever for redactions or withholding. On September 6th, I filed a complaint. On September 13th, One of the custodians happened to be on vacation, I believe, and that's the representative, which is Mr. Steinberg. He then produced his City of San Jose record. I'm ignoring all the things I brought up earlier on where, they hadn't timely responded. Apparently it's because he was on vacation. So let's not care about that stuff. Let's just talk about the withholding. I don't care about those other issues right now. On September 19th, then they responded to you and gave justifications in some cases. And in October of this year, yes, that's October 2020, they did begin to produce the email headers in a rolling fashion via the advice of the Department of Technology. And then they halted this. On December 9th, they halted responses to this request. They won't respond in any way. It's unclear why. They claim that until Dennis Herrera makes more decisions, they don't have to give me stuff. That's absolutely not the case. The Department of Public Works is responsible for their response, not Dennis Herrera and whatever he's doing to muck around with metadata still. I followed up many times. They refused to give me anything, and we are now over 494 days. It's not just metadata data in this request, though. This goes back to the copy of a record issue at the bottom of this page, which is hyperlinks, images, the date you send an email. This information that's in, that you can give wasn't given in this request. And I believe they told you at committee that was just a failure of what they did in this particular request, and they have now corrected that procedure to do so. I'm sure they'll tell you if that's true. You can't do that. You have to give me the whole email. The next page, email headers are disclosable. There's nothing that exempts this information. They even started giving me the information. Something happened, and then they stopped giving me the information. The Chief Information Security Officer just gave the information earlier today. And now multiple agencies have been giving us information. It's unclear why DPW halted this request. So I'm going to ask for an incomplete and untimely response. We're 1 year later here, and this is long pre-COVID. 6726 for failing to key each redaction by a footnote or other clear reference to a justification. 6726 for non-minimally withholding the record, namely by withholding the email headers, hyperlink URLs, images, sent dates to, from, CC, and BCC for non-personal email addresses. You've discussed this many times. Government email addresses are not a private information that's exempt under 6254C for personal information. And 6727 for withholding without written justification. Of course, when your OD issues, 6721E would require that they produce the information that they haven't yet produced. Next page. Here you can see, it's just a small example. These are two redactions that they did not footnote, but I want to be very clear. They didn't footnote any redactions. It's not just they redact two. Again, I'm happy to spend hours discussing all the metadata issues. I don't know why we would. They've already started producing it, and they stopped producing it, and we've had the same decision in many other cases. But if I am needed to do that, we can spend the time and go through all the cases and the law and all that stuff, and it's in the appendix here. Let me see. Yeah, so I think that's
30 seconds.
They didn't justify. Yeah, they didn't justify these this at the very beginning. They didn't footnote the redactions, and then they left out this information, images, hyperlinks, headers, etc. And you can't do that. That's it. Thank you very much. I'm done. Can you guys still hear me? I'm
Yeah, I know. I heard you, but with some people, I think.
Oh, I'm sorry. I was on mute. Sorry, I was on mute. Any persons or witnesses on behalf of the provide any facts or evidence on behalf of the petitioner? Okay, hearing none. Respondent, you have 5 minutes.
Cheryl, if you want to give me a...
Go ahead.
Thank you. And can you give me 30 seconds, please? Yeah. Hi, Chair Wolf and members of the task force. My name is David Steinberg. I'm custodian of record for San Francisco Public Works. In his December 22nd, 2020 letter to the task force, Anonymous again mischaracterizes our response to his request. The department responded to his request, which was received August 26, 2019, to the best of our ability, and closed the request on September 5th, 2019. At the time of the request, I was out of the country. And so upon my return, we released the additional responsive records from my personal email account on September 13th. Anonymous says we're only allowed 24 days by the CPRA to fulfill his request, and we did so given the technical limits that existed at the time. As we have said for more than a year, Anonymous's request for specific emails was in a format that at the time was clearly not available or easy to generate under 6721L. We did not have the ability to redact the metadata to prevent security risks. Quite simply, we didn't know how to do it, and our IT group was unable to provide us with a method. In an October 1st, 2019 letter to Anonymous, the supervisor of records agreed and found that Public Works did not improperly hold records. You can see that at pages P1143 to P1145 of your packet. It was more than a year before we were given access to technology that would allow us to view and redact email metadata to address security concerns that Anonymous has acknowledged exist. We reopened the request and immediately began to redact and release records to Anonymous, but he said he would challenge some of the fields that we had redacted on the advice of the city's Department of Technology. In a November 10th email, I wrote to Anonymous, quote, "As I've said before, I'm not an IT expert, so I've been relying on my own IT team as well as DT for support in responding to your request. I redacted information for the documents released to you based on guidance from DT, which provided me with a list of metadata fields that could be released without harming the security of the city's systems. The fields you note below are not on the green listed items identified by DT, and as such, I will follow the advice of DT as well as the city attorney's office and continue to redact them." He responded that same day saying, quote, "I mean, I can't stop you from doing that, but I've argued to DT and will also argue before SOTF those specific items are not exempt under 625419, and if SOTF agrees, you'll have to reproduce the documents a third time." Those two emails are found on pages 1175 and 1174 of your packet. Downloading and redacting metadata is a time-consuming process, so rather than wasting an inordinate amount of time releasing records that Anonymous said he would challenge, we suspended our release of records until DT and the city attorney's office could provide us with a final green list of metadata fields that were safe to release. We have not refused to give Anonymous the documents, and we have not closed out his request. The fact that we aren't producing the records as fast as Anonymous would like does not constitute a violation of the Sunshine Ordinance at this time. Anonymous has asked you to find a violation of 6221B for a timeliness violation, but that provision was suspended under the mayor's 5th supplemental proclamation, see page P1153 of your packet, meaning no violation can exist. According to the analysis provided to the task force by the city attorney's office, city departments must instead comply with the applicable requirements of the CPRA. Specifically, the city attorney writes that for all pending and future public requests during the emergency, a city must notify a requester whether responsive records exist, the basis for the agency's determination, and a date when the agency estimates it will be able to produce the records. You can see that on page P1157 and P1158 of your packet. We've complied with all of those requirements. For these reasons, we ask that you find no violation. Thank you.
Thank you. Are there any persons or witnesses providing any facts or evidence on behalf of the respondent? Okay, seeing none, members. This is a discovery, question and answer, clarification.
Respondent Dean Schmidt here. What's the status of that green list you were referring to?
That's a very good question. I have repeatedly asked DT when it's going to be done. They gave me a draft one and said I could, rely on it to produce a couple records, which I did, as Anonymous noted. I will also note that he wrote to me and said, I disagree with some of these specifically, and he listed several that he said should be released. And I went back to DT and I asked them about it, and they responded, and they added a couple fields to the green list, but maintained that at least one of the items that he said he wanted released was a security risk. And I told him that, and that's when he sent me the note saying, do you really want to do it 3 times? And I completely agree with him. It's a waste of time, because when I started doing this, it took about 20 minutes to produce and redact one email file with metadata. I got it down to about 10 minutes with practice, but it still takes an awful lot of time. So I really don't want to. I do agree with them. It's a waste of time. So I'm waiting for them to tell me that this list is final. Given the fact that DT just produced, earlier today said that they produced things, I would think that they're pretty close. But with the holidays and everything else, I haven't heard back from them that it's good to go. I have continued to ask. And as I said, we haven't closed the request. I'm perfectly happy to do it. Once someone told me how to do it, I started doing it immediately. But until such time as I know what we're supposed to do, I
take it that
wait.
The green list is categories, right?
Yeah, they produced a sheet that listed the different metadata fields that are okay to use, like sender, date, whatever, and if it's not on that list, they say it constitutes a security risk. And again, I'm not the IT expert, so I'm just following their advice.
Okay, so you go to the list, and anyone that's on the list is supposedly, quote, green, and then if it's not on the list, it's at least not yet green.
Right, I redacted it, and to Anonymous's previous points before the task force, he said that even if the information is a potential security risk, the name of the field, what you are redacting is not, and so that's the way we've done it. I've left in the name of that particular field, but I've redacted the information, and you can see that in his presentation that he sent.
Okay, and so the green list is if you take everything that's not on the green list, are you saying that basically it's not on the green list as far as you know because it's a security risk?
That is what DT told me, yes.
Okay. And we're just talking about metadata here, right? We're not talking about anything else about a document.
Correct.
Okay. And do you know, can you just give me a rough number of what's the number of these green listed categories that you're allowed to produce at this point?
Give me half a second and I will find it.
Just an estimate.
Let's see, green list. Okay, it looks like there are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, probably 30, 40.
Okay, thank you. That's all I need from you right now. And I'm going to ask Anonymous, if that number corresponds, the 30 or 40 that are green listed, and tell me if it doesn't, but how many categories at this time? And, I know it's been a long time, and I'm not asking you about the time that's passed, but at this time, how many other categories do you believe should be opened up to you and put on the green list?
It depends on when he got that draft. So I have written agreement with Linda Jarrell, the Chief Information Officer, the head of DT, that got everything I wanted added to that list. That was the earlier complaint you heard. So that was like 2 or 3 items. It's not a huge difference. So I'm not. That's why I'm confused why they can't produce the rest of it. You know what I mean? It's not like I'm asking them to rewrite that list.
Okay, so you're thinking that the agreement you have with technology would also pretty much satisfy you if it were put into place and used by the people at this department, correct?
I can't say that without looking at the record. And the reason I want to say this is the same reason they will say the same thing. In a particular record, it is possible that they will have to exempt more, right? Or that I will argue that in a particular record, something more is disclosable. So I think neither of us can really say that. It's not a blanket thing. We have to look at the records, right?
Okay. And the only reason that you're hearing that these categories might not be allowed or else they haven't been allowed is, quote, security risk, right?
There is a specific legal exemption that they cited not at the time they responded to my request, but now, which is Government Code 6254.19, which is that if a particular piece of information constitutes something that would provide a vulnerability about the city's infrastructure or an avenue of attack, I've forgotten what it is, that is an exemption to the CPRA. I completely agree with it. I was the one who told them that some of this information was exempt under that.
Okay.
It's just so they're not making it up. That's a real exemption. There's a real exemption for that.
So you accept that it may apply in certain situations.
That's correct. The
exemption.
Some fields are exempt under that. Yes.
Got it.
And if I could follow up on that.
Well, I'll allow it. Go ahead.
To his point, we did provide that justification on September 5th, 2019, when Jeremy Spitz closed the request. And I don't know that we have it in the. Actually, it is in the packet, but I didn't look it up. It reads, this responsive information is provided in a PDF format for its ease and transferability and accessibility consistent with California Government Code.
Okay, I've seen that.
9A1. Metadata from any needed format has not been blah, blah, blah. See California Government Code 6253.9 F and 6254.19. So we did give the justification.
Got it.
Despite what he said.
Okay, great. Thank you. And I have one last question, but this one's for Anonymous, which is, are we talking about any issues which are parts of the email which are outside of what you call metadata, other aspects of the email?
Absolutely. It's in the presentation.
The
images. Yeah.
So everything here, well, I know there's a term of art metadata, but there are certain things that are interesting about an email that are not actually by definition metadata, but there are other things that are interesting. You're
absolutely right.
Okay, that's all I'm asking you when you're calling everything metadata here, are you sort of using a broad categorization that you're including those other things?
No, not at all. And I thought my complaint was pretty clear about that. And I'm sorry if I haven't communicated that. There's two separate issues. There's the email headers. That's the technical term, email headers. And, that includes everything from the subject line to the from line, but also the timestamp you received an email, for example. That's the issue we've been discussing 90% of the today.
Yes.
But there's the other issue, which is like images in emails. And when you write like a hyperlink to a news article, what happens right now, or at least at the time they were responding to this request, and I think they told you at committee they've now changed this procedure, but at the time they were responding to this request, when they would produce a PDF, and there's nothing wrong with that. You can produce a PDF. PDFs can actually retain the headers if you want them to, but you can produce a PDF and it has a normal email, and someone says, hey, make sure to check out this article at SF Chronicle, and the words SF Chronicle are hyperlinked by the author, and there's a URL. And that information, that link that I would click on is a part of the public record. And that is the information that was not justified. So I apologize if I haven't said that clearly. That information was not justified. They told you about it in their written response. What happened? So I apologize if I made a mistake there.
Thank you very much. That's it. That's all I needed at this time. No more questions right now.
Anybody else? So I have a question, Mr. Steinberg. I mean, you cited the mayor's executive order as per in alignment with the governor's executive orders regarding public disclosure, but we're talking about disclosure here pre-pandemic. And I think
Yeah.
that that's really at the heart here. So invoking that now, I can understand that if you were if you were claiming still at the pre-pandemic that the information is not going to be disclosable, and based upon the timeline that the petitioner here has provided, it's obvious it didn't get much of a response until after the pandemic started. So I'm not sure that I don't know, you have a response to that?
Well, yeah, I mean, as I said, I'm just reading what the city attorney's office prepared for you. Their analysis said that for all pending and future public records requests, that those deadlines do not apply. It's pretty plain language, which means there can't be a violation for timeliness until the pandemic's over. As I said, we reopened the case once we had the ability to actually redact the metadata.
But what about
this is something?
But what about not being responsive at all until the pandemic began?
Well, we were responsive. We gave him everything that he asked for to the degree that we were able. We did not have the ability, period, at that time to produce and redact metadata. I've been saying it for a year, and it wasn't until after the October complaint hearing that where they asked him, can you two work together, and he can Anonymous, can you help explain to him how to do it? And instead, he just sent me an email saying, talk to DT, because again, I was relying on our IT folks. Member Schmidt asked us about this at the complaint hearing. I'm not an IT guy. I asked, how do I do it? And they said, we don't know anyway. Let's research it. And they came back and said, nope, don't know how to do it. So, but you
have a whole Department of Technology that represents and provides services for the entire city. Why weren't they engaged at the time?
As someone from DT told me today when I called up because I couldn't get access to a form, they are not allowed to deal with other departments because we're not under their rubric. We have to go through our IT department, and if there's something that they can't figure out, they go to DT, and sometimes they'll put us together. But I literally today was told by someone at DT they're not allowed to respond to requests from outside departments, except if they had, I don't know what the rubric is, but that's how, and I asked our IT folks and they said, nope, don't know how to do it. There've been other cases now that we've gotten through some of these, like getting Teams messages. I've gotten requests for some of which I've provided to Anonymous. They didn't know how to do that either. But they went to DT and they went through the whole process, and because DT maintains the Teams database and that function, and they found out how to do it, and they got me information, and then went back and forth, and I got it. But I have to rely on our IT department. That's all I can do.
Oh, okay, but that's the point I'm trying to make is if your IT department says that they don't know, you have an entire Department of Technology that serves the entire city that does have those answers. Why didn't they just call them at that time?
My understanding was that they did, but I don't. I mean, that's what they're supposed to do. I don't know.
Right.
I can't tell you for sure, but yeah.
Okay. Any other questions at this time, folks? Yeah.
Real quick question. I know we're coming up in our 30 minutes here. Mr. Steinberg, are you withholding anything at this point that's not metadata related? And I'm asking for things like hyperlinks, images, to, from. Is all that at this point been turned over? Or are you claiming that any of that needs to be withheld?
No, Well, unfortunately, because it's been so long, as Anonymous noted, we previously used Adobe PDF Maker or whatever, and when you redact something, it does remove the hyperlinks, or did remove the hyperlinks. So we're sort of going to catch 22 because he's insisting that he wants the original forms of the emails, but if we put it through, when we put it through the redaction tool, it took it out. So we now use Next Request. They have a better system. It separates out all the images it puts them in a component. So instead of giving you one PDF as an email, it gives you a text file with the text, and it gives you like 5 image files, which are all our logo, and then it gives you a doc file that is, the agenda of the meeting and stuff like that. So it breaks them all out. Has
that been done all of them at this point?
No, unfortunately, I don't have the ability to do it, and it's a technical thing, and maybe Chair would understand. But when I went back, because I have the original PST files, they're not. I can't get to them anymore because I can't get the original emails essentially. So all I have are the versions that are stripped of the hyperlinks. I mean, the other things that he said, for example, were like, what did he say? Oh, yeah. So for like the email addresses were stripped from the emails. Actually, they weren't stripped. When an email address is in someone's address book, Outlook doesn't show the address; it displays the name. I'm sure you guys are used to seeing that. It'll say, mom. It won't say mom123@gmail. That's how the document appears. We didn't strip it, and we're under no obligation to create a new version of the document to show the address. The metadata, when we do release it, will include that information. Will give that. I mean,
okay, I get that. Quick question: do you guys use Outlook for your mail? Do you use Outlook?
Yes.
Okay, there's actually an option you could turn that on and off. So work with your IT. You could actually turn on whether or not to show the email address itself along with the name. Like for me, I have my work email, it says Matt Yankee. But if I turn on the option, I could also show then my, Matt Yankee at whatever, blah, blah, blah.com, right? You could turn that on. So you might want to talk to your IT folks about that so that's
okay.
not.
I don't know whether that would be fine for mine, but I don't know if the PSTs that I get from a different account would have that. I don't know if I can adjust that for a file, someone else's file that I get, but I can find out. But as I said, we will be producing the.
Right. My point.
We will be producing the email addresses when he'll get them when we get the metadata.
Okay. But all right, I'm done for now.
I have a question for Anonymous. On page 1118, PDF 184.
Yes.
I just want to go through your chronology here. August 23rd, 2019, and then the number 2, number 3, number 4, number 5, is that all from 2019?
That's correct. And I do want to correct something. They did give me a response. I don't want them to get, I don't want, whatever you find, I want it to be correct. They did respond, like I said here, on September 3rd through 5th. So they did respond. Yeah.
Okay. All right. So
and that is 2019. Yeah.
Okay, because the question that I have for you then is regards to your statement at the bottom of this particular box, where it says there's no legal citation for DPW to indefinitely hold this request based upon the city attorney says so. Okay. When did you receive that statement?
The statement that they were holding, and he has put it in the record, was received December 9th, 2020. And it is somewhere in the record. He has entered it into the record. And
that,
what I think I want to be very clear that the 24 days is the CPRA requirement, that they have 24 days to consult about what is or isn't disclosable from the date of your request, right? 10 days plus 14-day extension. What they're arguing here is, I guess because of the COVID rules, they can now just kind of take as long as they want. I guess that's their argument, that's the suspension. But what I'm arguing here is that timeliness was violated, as 24 days after August 23rd, when they hadn't given me everything, which is long before the date that the order went into place. They're arguing, well, now that the order is in place, timeliness is just not allowed to be found as a violation. I think that's what they're arguing. What I'm arguing is they had 24 days from August 23rd to determine what their response was, and now saying they need more advice, I don't think is allows them to continue to hold for just however long they say. Like they could tell you right now, right? Okay, we'll give it to him. It's gonna be hard, so we'll do it, a few emails a week or something like that. And they could tell you something like that, but they're not telling you because they think the COVID order doesn't require them to have any time limit to when they give me this.
So I'm a little confused. And both of you guys are saying that they have a maximum of 24 days, okay? And that's with regards to the CPRA. But the Sunshine Ordinance has the enhancement of providing it to be shorter, to provide more expediency, and we only allow up to 10 days. And for
is that a
for
question to me? I can tell you why I think it's 24, but okay. I think that, again, if I win, I want to win on what is a very firm basis. And I think that the CPRA and the Sunshine Ordinance said after 10 days, you're still allowed a 14-day extension if you need advice from other agencies. And I don't think the Sunshine Ordinance abrogates that requirement of Government Code 6253C.
By virtue of the ordinance being able to provide more expediency, that is what 6721B is about. It's within to provide, they must provide, well, that's justification. They must provide as soon as possible within 10 days following receipt of the request, the record, and comply with such request.
Well, we did that.
Yeah, okay, but I'm just questioning why the 24 days keeps coming up. 24 days is not part of the Sunshine. If we didn't have a Sunshine Ordinance and the CPRA applies, then okay, fine. But the Sunshine Ordinance did away with that additional 14 days to create more expediency as allowed by the CPRA.
My response to that is the CPRA, however, has not been abrogated by the purported order by the mayor. So the 24-day requirement still applies, if that makes any sense.
Are you talking about under the COVID rules or pre-pandemic?
Exactly. So what I'm saying is that they're citing, they have these COVID rules that allows them to just kind of take however long they want. But what they do have to decide within 24 days, even under CPRA, is whether the information is disclosable or not. But as you saw in that thread, they aren't really determining that because they still have some advice they need to get from another agency. So if they told me right now, then that would be within the 24 days, if that makes any sense.
Now, here's my concern, sir. The Sunshine Task Force, and frankly, the entire city, under Sunshine and in its training and understanding going back to 2005 is that under 6721B, a custodian must provide the records within 10 days following a request, period. That is what we hold to be true. Okay. For the 14 days additional that is provided for under the CPRA, because the CPRA trumps the Sunshine Ordinance only in certain respects, that the Sunshine Ordinance does not provide additional efficiency and expediency, more transparency. That it's kind of like a reverse law. The Sunshine Ordinance can have more power to provide more expediency and more transparency than what the CPRA offers. So that's what the ordinance has done by removing that additional 14 days to create more expediency. So as far as I'm concerned, pre-pandemic, okay, because even under the pandemic rules, if they're going to do away with the timeliness part, then that's a non-issue. We're talking about a case that goes back to 2019. Okay, now we're talking about receiving information on a rolling basis that now has rolled into the pandemic. So now we're under a different set of rules during the pandemic. We have to make a determination based upon which part. Are we making a determination based upon what happened in 2019 when the request was made and the records were not produced? Or are we making determination based upon what's happening in 2020 inside of the pandemic? It's a question for you.
To which of us is that the question?
To you, I'm sorry, petition.
My position is that up until the day that the mayor made that order, if they hadn't given me the full, complete response by that day, that was an incomplete and untimely response, even if now, under 6721B, even if now, and I don't concede it, but if they argue and you agree that the mayor has this right to do whatever she wants, then still the CPRA 24-day requirement would apply. Am I making my position clear? And you should probably ask them, because their position may now not be what I'm saying here. That's my position.
No. It's actually the onus is on you because you filed the complaint. Okay. So we want to know, based upon your complaint, are you filing a complaint based upon issues pre-pandemic or during pandemic?
Absolutely pre-pandemic. As of the date I filed the complaint, that is when the issues are. Yes.
Okay, we have to know what scope the complaint is based upon. Okay, now if we make a determination and we are going to ask them to do this, that, or the other thing, and we're in the middle of the pandemic, there's a different set of rules. We're providing that information. We're trying to adjudicate this, from the point of where the violation happened. Not what's happening today, per se. I mean, even if they were invoking a rolling basis, and you're receiving records all the way through March, and then now we have the emergency orders in place as of March, and then the rules change on how they get delivered. Well, that's just the rules. The rules have changed. Okay. But by the same token, violations or compliance is changed during that time. So thank you for clarifying that. For the members here, the complaint is wholly scoped pre-pandemic, going back to when the original complaint was made and moving forward to that time of that time. Okay, so just so we're clear, what we're being asked to review is when the violation had happened, if they're alleged violation. Okay, all right. Thank you for clarifying that. Okay, any other questions? Okay, should we move to rebuttals? Okay, let's do rebuttals. Okay, Mr. Steinberg, you have 3 minutes for rebuttal.
Thank you. Cheryl, if you give me 30 seconds. So the timeliness issue, I think Anonymous, if I'm hearing him right, I think he will agree that we did respond to his request in the time that was allowed. He alleges that we didn't give him all the, that we withheld stuff that we should have, but I believe he would agree that in terms of our response, we actually did do it within that time. So again, just a few things. One, on justifications, he is wrong in the fact that we did provide justifications for all of the redactions. Justifications were included in the communications September 5th to anonymous closing the request. Since long before I assumed my position, the department's practice was to list the redaction reason or reasons in a note releasing the record. You can see pages P979 and 980 where it cites personal privacy exemption. No BCCs. He said, I reviewed the emails and none of them had BCCs, so nothing was withheld. He said there's no metadata for the sent messages. He disputes at page P1171 in a November 12, 2020 email, which is provided to anonymous through another public records request. DT says, quote, for messages that are sent to an outside email system, there is no metadata in that sent copy. We can do a message trace and provide those results. However, a message trace will confirm that a message was sent from our email system and went out to the internet. However, it can't provide any details once the message leaves our system, meaning it can confirm that the recipient received the message, wasn't blocked, didn't bounce back in error, etc. So we did not withhold any metadata in sent emails. What else? Other departments have released them, but again, as Anonymous himself said in his presentation, he still believes that some redactions are illegal and is disputing them. He asserted the same thing to me. Again, you can look at page P1171 and 1176. And again, it didn't make sense for me to go through the time-consuming process of creating files with metadata and redacting information, only to have to do it again if some withholding is deemed invalid.
30 seconds.
Thank you. Because the deadlines of the Sunshine Ordinance are suspended during an emergency, I decided it made more sense to get a final determination and then produce the documents. I think one of the issues here, as I said, I'm not an IT person. I try to figure it out. Part of the problem, quite honestly, is that there's no comprehensive instruction given on how to be a custodian of records. We learn much of what we know over time. That's one of the reasons I helped organize the Custodians of Record Working Group soon after I assumed this position. I posed the question, what one thing do you wish someone had told you when you first started that job? And so, we're doing the best we can. Thank you.
Please let me know when I may begin. Oh, sorry.
Okay.
Hang on. Go ahead, Anonymous.
Thank you. I think the chair made the point better than I did because I was muddying up the issue. The question is, at the time of the complaint, what had they produced, right? That's what matters. And you're right. Now, even once you issue an order or whatever happens, they may still take 5 years to give it to me if you do, if they give me anything at all. But at the time of the complaint, they had not given me the information that I have stated in the presentation. Their response later on to this task force does give some of that information, like hyperlinks and images, and they explain that. I also want to make a point. This is not about David Steinberg personally, how great he is of a custodian record or not. This is about he's not even a respondent, because the person who responded was a different person, Jeremy Spitz. And the fact that they have now corrected that doesn't change that at the time of the complaint, in the time of the response, they had withheld information that they shouldn't have, and they accepted that they shouldn't have. I do want to make one final point. They argued that because the tool didn't exist in whenever I made the request, that information was therefore not disclosable. That's not what you have ever held, not just in metadata cases, but even like video cases. Just because you don't have a tool that makes it possible to do it doesn't make the information non-disclosable. You will rule that it's disclosable, and then they'll go get the tool. But I also my final point about the format, they have never given me the original format, so then they're right, whatever. If they don't want to give me that format under 61021L, they're not going to. It's about the information in the record. The record, as has been from Sierra Club versus Orange County, it's the computer database itself is the public record. And like in that case, Orange County gave just PDF copies and said, well, that's all we have to give. And the rest of it is not really a public record. But that's not acceptable. the database, the thing that's retained by the government, is the public record. I can go back through all of this over and over again. So I'm just going to ask, fine, they don't want timeliness because of COVID, whatever. 6726 for non-minimal withholding and
What happened?
We lose.
Did we lose him? Yeah. Did he hang up on himself?
Or he didn't himself.
Hold, you're going to have to repeat that. Please stop the clock.
I did.
Okay.
still here? This is the complainant. Is anyone still here?
Yes,
Yeah,
we're
what
here.
happened to you?
We thought we lost you.
I'll just repeat my last two sentences then. I'll just ask for 6726 for non-minimal withholding. If they don't want the timeliness, that's fine. But they do need to give me the information at some point. Thank you.
Thank you. Just a clarification, Anonymous. We lost you during the whole section where you were on the what you were requesting for finding a violation.
Okay, I'll start back there. I will ask for a 6726 violation for non-minimal withholding. And if they're arguing now 21B is invalid, let's not even consider it. I'd rather stick with the thing I care about, which is getting the information that they do have to produce it, in a rolling fashion, and that I'll get the information at some point. So 6726 non-minimal withholding is all I'm asking for. Thank you.
Okay, thank you. Okay, members, time to deliberate, create a motion, if there is one.
Sure, I'll start the conversation. I kind of see this case as being almost two issues. I see the metadata issue, and then I see the other stuff, right? The other stuff being things like the hyperlinks, the images, all that's not metadata, and I think any of us could pretty much figure out how to get from an email, right? I don't see an excuse for why that wasn't given months and months ago, pre-COVID, right? I think there is a 6726 violation for that stuff. I just think we should have figured out a way. I think Anonymous stated it just because someone didn't know how to do it doesn't excuse it. It's still disclosable, right? The metadata issue I know has been a more ongoing type of thing. I think obviously we heard a case, earlier tonight, talking about where they've been going back and forth with the Department of Technology to figure out what is and is not a security risk and everything. So, where I'm starting to come from on this is I do think there's a violation on the non-metadata portions that weren't disclosed months ago. And then I would probably like to see some type of order that they collaborate with Department of Technology to finalize and turn over the metadata portion within X amount of days. That's kind of where I'm thinking this is, but interested to hear everyone else thinks.
For the items that are not metadata, are you finding a violation with regards to those? Is that still under 6726?
That's where I think the for sure violation is. I do think that there's definitely a violation for things like withholding hyperlink URLs, withholding images, right? Those are things that, I know Mr. Steinberg talked about that they didn't convert well over. Well, in my opinion, really, they should have found a better way to turn those over, right? The fact that an image didn't convert well through some type of thing isn't an excuse to not turn it over for a year, right? That should have happened. So are
you finding a violation for that?
So yes, I do believe there's a violation for that. The metadata thing, it's unfortunate it's taken this long, but I know that it's been an ongoing back and forth with Department of Technology about what is and is not a security risk. And it sounds, in fact, that's part of why I made that motion earlier tonight for Department of Technology to finally give a fact sheet for us to use and for other departments to use so they have this guidance, right? So I'm not sure it's unfortunate, but I'm not sure I find, the Department of Public Works necessarily responsible for the fact for turning the metadata over, because obviously it sounds like just until maybe the last few weeks, the Department of Technology really come up with a solid list of what is and is not a security risk. And so I'd like to see that. I would say I'd like to see, future compliance quickly based on that list of things. But at the same time, I just need to find a violation of 6726.
Okay, so I'm asking for those items that are not metadata. Are you claiming that there be a violation under 6726 or some other section?
6726 minimum withholding, because they should not have been withheld at the time.
Okay, yes. Gotcha. Okay, just want to get clarity on that.
Yes.
Okay. I want to say that I was a little kind of, I'm not disturbed by this, but this is an issue that comes up that city staff is not necessarily aware of. Lots of times, there is retention policies regarding emails per se, and that information is being asked for with regards to emails may not exist anymore, or what have you. The task force has been brought to task some years back in a case of Wooding versus San Francisco Rec and Park Department with regards to emails that were deleted. And in that case, they were deleted on purpose to hide a paper trail. And we had ordered that the Department of Technology produce backups. Backups exist. They always exist because there are requirements under federal law to maintain sometimes what they call journaling or archiving. And sometimes the retention periods are different for various different things. But we have done that before. If it was so egregious, this was a pretty egregious case. Because there was so much alternative evidence that was found. I mean, hate to say it, but there were kind of real smoking guns there. I'm not saying that this is that kind of issue. But when I do hear staff saying, it's so long ago, I don't have those records. If there is interest, those backups may exist if there is interest in going to what we used to call Iron Mountain, which used to be a big storage space that the city used to store hard copy. They want to go down that road. So I just wanted to mention that for everybody's advocation. Okay, any other deliberation? Are we ready for a motion? Okay, is there a motion?
Okay, I'll go. I will move to find a violation of 6726 for with minimum withholding, and I would also order the Department of Public Works to collaborate with Department of Technology to turn over the remainder of metadata issues within the next, I don't know what would be a good amount of time for this, 60 days perhaps, and to then make sure that compliance and amendments make sure that occurs.
You said 60 days?
Yeah, but I'm open if anyone thinks that a better time period would work. I'm just throwing it out there. It sounds like they should, because we heard about that.
Okay. Is there a second?
I'll second.
So moved by Member Yankee, second by Member LaHood. Discussion on the motion, members? No. Okay. Let's open up public comment. Any public comment other than the parties? Please unmute yourself by pressing *6. Calling for public comment. Last call for public comment. Okay, hearing no public comment, are we ready for a vote?
This is, Mr. Chair, I know I'm a party to this, so I'm not making a public comment, but can I raise an issue for your point of information?
We don't usually allow it at this juncture. you know, it's if it's meant to change to change the motion, we won't allow it. I mean, if you feel that, let me just say it this way. If you don't agree with the decision that we make, we have a reconsideration process, like an appeals process that you can invoke.
Yeah, no, I understand that. I would not be making a comment to disagree with the decision, but to inform you about how long it will actually take to get done.
Wait. Before you say that, if you're going to make that, then I have to give the other party equal time, and I'm not inclined to do that.
Okay.
Okay. Here's the thing, Ms. Steinberg. What's going to happen here is that after this, whatever happens with this motion, if it gets approved, it will go to the Compliance and Amendments Committee. Okay. That would be, they will monitor it based upon that time. If you are having difficulty or there are issues related to keeping with that time frame, you can do it in that venue, and then they can bring it back to the task force or make recommendations at that time.
Thank you for that clarification. I appreciate that.
Okay, great. Okay, are we ready for a vote?
So there's no public comment? Public comment closed?
I already called public comment.
Okay, so we have none.
Please call the roll.
Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member Hensy?
Aye.
Member Hensy, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to find a violation for 6726 and order DPW to coordinate with DT and turn over the remainder of the records within 60 days and report back to the Compliance and Amendments Committee.
What's the verdict?
Pass.
Thank you. Okay, let's please quickly take, can we take a 5-minute break? I got nature calls. Nine 44. Thank you. Please mute and Actually, I think I gave the wrong time. I said 5 minutes, but I gave 10. It's all right. Uh, Anybody hear any new news? Any reports about what happened in DC? Anything more? It's amazing.
Crazy day.
Ugh. You know, just burn the place down, scorch earth.
I think they're on Pennsylvania now.
Oh, right, that's right. I thought they moved it to Maryland and Virginia, the government offices there.
I think they're back in the Capitol. I think they're on talking about the votes on Pennsylvania.
They're trying to overturn Pennsylvania. That's what he
They
means.
go alphabetically, so they made their way alphabetically. Now they're on Pennsylvania.
Got it.
So that's why the objection started with Arizona. Now it makes sense.
Yep. They did Alabama, Alaska. That's why they stopped at Arizona.
Do you want a fun party trick? I can say all 50 states in alphabetical order in under 25 seconds. But I won't waste our time. It's for another day.
Sorry, I said 5 minutes, but I said to return at 9:44, which is 10 minutes. And sorry, I don't mind you watching me eat, unless you're offended.
So I was going to ask you, Bruce, you had your cat in your lap for a while there in the beginning?
Yeah.
Was that your cat?
That's my cat. That's fruit bat.
Fruit bat.
Yeah, we call him that because he likes mango.
I love mango too.
Gotta watch out if you have mango, like frozen mango on a stick. He'll come right over and bogart. That's an old term. Okay, let's go. Back on the record. Everybody here? Okay, great. Thank you. Thank you, everybody. Okay. Last item number 9. Yeah.
Okay, ready for the last item?
Let's go.
All right. Item number 9, file number 19120. Complaint filed by Anonymous against the Office of the City Attorney for allegedly violating Administrative Code, Section 6721BC, 26, 27, by failing to respond to a public records request in a timely or complete manner, failing to keep withholding to a minimum, failing to keep redactions by footnote or other clear reference to justification, failing to cite legal justification for withholding, and failing to provide a written statement of nature, form, existence, and quantity of records.
Okay. Complaint committee. This was heard on September 15th.
I don't think I was complaint committee chair back then. Was I? I might have been. Yeah. I don't remember back to September, unfortunately.
Anybody else? Is there anything to report? We'll just jump right into it, if not. Okay, let's just jump right into it. All right, so we'll give 5 minutes for the petitioner and the respondent. Let's start with the petitioner. Are both parties here?
Anonymous is present.
John Cote with the City Attorney's Office is present.
Okay, thank you for sticking with us here, Mr. Cote and Anonymous. Okay, Anonymous, you ready? Cheryl?
I'm ready to go.
All right.
All right.
Go ahead, sir.
Thank you all for sticking around as well. And I can tell you my quality of argument is not going to be that great 5.5 hours in. This is item 8, page 87 of the PDF, footer page P1311. There were a number of issues at the beginning of this complaint. I'm narrowing it down to 3 remaining issues. 2 of them I think are super simple. I don't know why they're up for debate. The third one may be legally complex. I would urge you, if you cannot come to a conclusion on the third one, make a decision on the first 2 and maybe continue if you need legal advice or whatnot, if you don't want to stick around here for a long time. So the first question is, do they have to key every redaction to a specific legal justification and minimize withholding like every other agency? Absolutely they do. Do they have to provide a written justification for all of the withholding when they respond to the request, not to the SOTF after the complaint? Yes. And then the final question that's more complicated is, 6721C requires this statement, and I'll get into it later. What about when the records are attorney-client privilege? And I don't have to prove bad faith or willfulness. They had something about that in their response. Here's the timeline. September 20th of last year, a request was made. 26th, the request was acknowledged. They asked me to narrow it. I narrowed some term, added some other term, et cetera, et cetera. They gave me a statement, which I argue is not compliant. I don't care about the timeliness of the statement. Let's not discuss that. They gave me an extension on October 17th and October 22nd. They gave me the records. I explicitly asked them whether they were done, right? Because if they want to roll the response, they can do that. They told me they were done, and I filed a complaint. So next page, written justification. So before the complaint was filed, they justified this, I believe, as personal privacy, attorney-client privilege, and attorney-work product privilege. Those were the written justifications. There was no indication which redactions were to which justification. That's the 6726 issue. But a 6727 issue is after I started challenging these redactions, because, of course, they hadn't told me which redactions are which justification, they created more justifications. Official information privilege, confidential informant privilege, 2 medical privileges, and at this point, as of the day I filed this presentation, and of course at the original day of the complaint, there was no key for the redactions. I've asked them, they won't give me. There's also an interesting thing under Evidence Code 1040. There are 2 different exemptions, and you held this in Stephen Malloy versus Department of Human Resources. They have to tell which exemption, like if there's 2 exemptions, which one applies, unless they're claiming both apply. And one of those is a balancing test. The DCA memo is very clear that they did not state all of the legal basis for withholding along with their production, but then they asserted in the submission of task force. And their argument is it's a large production, so they shouldn't be held to the letter of the law. But you have never held something like that. I mean, the Fine Arts Museum produced multiple tens of thousands of pages. They produced spreadsheets of every single redaction. The right of the respondent is to produce rolling responses and give me what they can. What they can't do is just not justify redactions or not justify the withholding. And if you remember back to the police commission case, why does it matter that they have to go through and justify while they're redacting? Because if they don't do that, we don't really know whether they really had a legal reason to justify it, to redact that information. Next page. You can see the redactions that aren't keyed. But the interesting thing is the statement of nature, quantity, form of records. The question is, 6721C requires you to provide this statement whether or not the contents of those records are exempt. They argue that when the content is exempt, it is under attorney-client privilege, it's privileged the number of privileged records there are. And my argument is no, and their cases don't say that the number of privileged records is itself privileged. I believe that in normal court cases, you would produce a privilege log. And I'm not saying they have to produce a privilege log here. But the notion that a privilege log is not itself privileged is analogous to what I'm asking here, right? One of the court cases they cite, St. Croix, actually tells you how many privileged records there were. If that information was privileged, why would we know that number? And I think this is pretty important because it is a big difference between their withholding 300 records and 1 record. And I don't think that merely because the content of a record is privileged, that the number of privileged records is itself privileged. And I don't believe either of the court cases they cite will tell you that. Also, they gave me 2,100 pages, of which I think 1,500 pages is just copies of Board of Supervisors agendas over and over and over again. There's election pamphlets in there.
Your time's up, sir.
The records they gave me, 300 are actually relevant.
Thank you. Are there any persons or witnesses writing any facts or evidence on behalf of the petitioner?
Before we continue, can I ask everyone on the call to mute, please?
Thank you. And you can call for a appointed personal privilege for that, to be correct. It's called appointed personal privilege. If there's a problem in the room that causes a disruption, you can do that. Okay. Hearing none for persons or witness write facts or evidence on behalf of the petitioner, we'll move to testimony from the respondent, Mr. Cote.
Good evening, task force. Thank you. Thanks, Cheryl. Good evening, task force members. John Cote with the City Attorney's Office. I'm pleased that Anonymous has acknowledged that timeliness is not an issue in this complaint. That being said, I think a little context is warranted in this situation. So this particular request involved asking 16 different employees across the office to produce records containing any of 4 keywords that this requester provided regarding the recently deceased public defender, Jeff Adachi, and the request had 30 different subparts, including things like evidence inventories, post-it notes, court orders, subpoenas, invoices, beyond other materials that are often seen in public records requests. So with that background, we produced over 2,000 pages of documents, as he has acknowledged. Once we produced those documents, we heard nothing further regarding our response until we received this complaint. So, there are kind of a number of issues that he points out in this complaint. I'm going to start first with the Section 6721C statement argument. The law is clear on this, and while, of course, the literal text of Section 6721C states that a response should encompass records whether or not the contents of those records are exempt from disclosure, but the Sunshine Ordinance does not, and it cannot, abrogate the attorney-client privilege or the attorney work product privilege. This is clear from the St. Croix decision, and I'm happy to give you citation if you would like. I know members of this task force are very familiar with it. So the attorney-client privilege covers not just the specific substantive content of our advice, but also the circumstances of when and how frequently a client department requests or seeks our advice, and when and how frequently we actually provide that advice. There's an additional case that is on point here, a California Supreme case. It's Los Angeles County Board of Supervisors versus the Superior Court. It's a 2016 case. And in that case, the Supreme Court reaffirmed that the attorney-client privilege attaches to information in billing records that inform the client of the nature or the amount of work occurring in connection with a pending legal issue. So documents that cover the nature or the amount of work or that would reflect that information are covered under the attorney-client privilege. Now, the complainant here references the St. Croix case and says that, that it mentioned that there were 24 privileged records. In that case, mentioned that decision, but what he doesn't tell you is that that case did not involve a 67.21C request, and that the reference to 24 privileged records was provided as background. And that decision does not actually hold that the quantity of documents concerning a particular topic are not privileged. So there was no violation here of 6721C. We provided that statement. It was appropriate. To the issue of redactions. Now, as I had indicated, there were over 2,000 records produced here. They were complex in nature, and as you will see from the response that we provided in writing to this task force back on, sorry, I'm trying to get the date for you. It was November 26th of 2019. It is page 1635 of your packet. We provided detailed responses explaining why the redactions were warranted. Now, if Anonymous had asked for clarification, prior to filing a complaint in this issue, we would have gladly provided this information to him.
Your time
He
is
did
up,
not.
sir.
All right.
Okay, thank you. Are there any persons or witnesses for any facts or evidence on behalf of the respondent? Okay, seeking none, members. Item is with you for Q&A discovery. I have a question for both parties. First to Anonymous. With regards to the redactions, were they keyed?
They were not keyed in the response, or even to this day, they are not. What he told you, he gave you the key for the specific one that I challenged, but they didn't give you the key for all the redactions, which is what 6726 requires.
It's not whether they provided it to us, they provide it to you.
That's actually a great point, and I think I said this somewhere. No, they provided it to you, and they apologized to you that they did not give me this information to me. As far as I know, and if I'm wrong, Mr. Cote can tell me, but I don't have any email from them that says, here's the key for all of their actions, or even the ones they told this task force about, yeah.
Okay, Mr. Cote, the reason why I asked that question of him first, and now to you, is your statement in saying that you provide an explanation of redactions, which is not what the ordinance requires. Can you expand on that?
Sure. I would just point to our November 26, 2019 response to this task force, where we go through, this is page 1635 of your packet, where we go through point by point and explain the redactions. It continues on to page 1636 and 1637.
Okay, but that's not. The question is did you? It's the question I posed to the petitioner. Did you provide a key of the redactions when you made them? It's not whether you provided it to us. That's not the issue here. The issue is whether you provided it, whether you complied with the ordinance to the requester. Has nothing to do with whether you're complying with the ordinance for defense to us. That's of no consequence.
I would point out that information that was provided to task force was also provided to the requester, and that when you look at the substance of the issues, as far as what the redactions that the requester is complaining about, that any sort of deficiencies in the redactions were not substantive, and that they were minor when viewed in the context of the entire 2,000 plus page production. For example, we took issue with on page 3, the redacted information was Mr. Carmody's private email account. The body of the email directly below that redaction begins with the words, "Dear Mr. Carmody." So, it's pretty apparent what it is from the context. Similarly, we redacted information thinking in one instance, this is also on page 3, that it was a private phone number. Then upon further review, we determined that the number wasn't private, that we provided that phone number here in our response. And we also noted that the identical email appears without redactions on page 92 of the production. And I think there's something that's important to consider here, beyond the demands of this specific production, was that, at the time, we were inundated with requests from this particular requester. It was by design, it was his plan. And when you have limited resources, you can only do so much in the amount of time that is required. And that's the situation that happened here. That being said, none of these deficiencies were substantive. at all.
Okay,
And
but
we
that's
responded in good faith. And we complied with our obligation. That's the point.
yeah, but Mr. Cote, you know, that's not the point. The point is not whether they're substantive or not. If you make a redaction, as you're making the redaction, you key a note. It's as simple as that. Why then later provide explanations that are, you know, somewhat general in nature, and not provide them at the time as the law requires for it to be keyed on the document itself.
Now, our position is that we responded in good faith to this request, and we responded to the best of our ability at the time, given the realities we were facing.
Okay, thank you very much. Any
You're
other
welcome.
questions? Thank you. Any other questions, folks? Member Mr. Schmidt?
Yeah, Anonymous, you, in your presentation, you told us you had three issues, sort of general issues. Did you get to the third one? Was that the end, or did you get cut off before you got to that because you had a 5-minute limit? You said you had two that you could, you wanted to give to us, but a third one where you said maybe, you would want to look into other issues around this. You may want to decide this later in some way. Were you able to get to that third?
Yeah, it's on page, it's the top half of P1311, which is PDF page 87. Those are the three issues. The third one, which is, I think, the more complex one, is whether or not the number of privileged records is privileged. You'll see the three issues right there.
Okay, so it's the number is that third issue, the number of pages.
That's correct.
Thank you. That's all I was trying to get clarification on.
Anybody else? Okay. I don't have any other items. Let's see.
I do want to ask one more, if I may.
Sure.
Just looking at 1311, to the question of Anonymous, do you have any kind of legal authority that you may have located with regard to this page number issue and whether those would be protected by privilege?
My argument is actually the cases they cite. That those cases, I think they are over broadly reading those cases, right? Those cases, and I believe they're in the record here, and I have quotations from them there. They exempt. It says the first case you cited, St. Croix. St. Croix, as you know, is a case about, I believe, the Ethics Commission doing something with the SOTF. They held, and he's correct, and I agree with him, the Sunshine Ordinance cannot abrogate the attorney-client privilege, and the content of those records are exempt. That's St. Croix. I agree with him. I did not ever say, and if I did, I'm wrong, but I don't believe in this presentation. It says, and it even says the distinction he made, that you'll see that distinction on page, you'll see it right there on page P1314, header page 90. What he said is exactly, I agree with him. St. Croix did not consider 6721C. It says 6724B1 cannot abrogate the attorney-client privilege, so the contents of attorney-client privilege remains privileged. Totally agree with him. And he's exactly right. They did not consider 6721C, and they did not say 6721C is invalid. The other case he cited is right above that. And there, read the holding, right? The first holding is invoices are not categorically shielded, and the invoices for work, but in invoices and work intending and active legal matters are privileged. I'm not disputing what the court said. I'm not disputing even what he said. The question for you to resolve is whether the number of privileged records is itself privileged. And I think that statement is as easy as 15 emails and 3 Word documents, right? I think you mentioned, Member Schmidt, in the last, this was a Stephen Malloy case, the DHR just blanked out all information about privileged records. And you said that, no, you can give some information that still wouldn't implicate the privilege. And I think the same thing applies here. Thank you.
Okay, thank you.
I have a couple of questions for the petitioner. Anonymous, on page 1315, which is PDF page 91.
Yes.
At the top, you say this written response lacked official information privilege, confidential information, informant identity privilege, and civil code sections, all of which they cite now after filing a complaint. Can you expand on that?
Certainly. So they provided this response right here that you can see. That was the extent of their justification. There was no keying back and forth. And the problem was, the 6727 problem here is that they some of the records they had redacted or withheld are not actually exempt under what they responded into their response to my request, right? Their response to my request says 6254C, 6254K, 67.1G. These are things about personal privacy, attorney-client privilege, and attorney work product. But they didn't. There were additional records that they had withheld and they had redacted, and those they later told the task force that those were withheld under EC 1040, EC 1041, which is the official information privilege and the confidential informant identity privilege. And that is the 6720 and these other two more civil codes. That's the problem under 6727. Does that clarify what that slide is about?
Yeah, I think so. So basically, it's they didn't cite it at the time of the request and withheld it, but then cited it later. When
they cited
after you filed.
Yeah.
Let me finish. After you submitted the complaint.
That's exactly right. They gave me this response. I filed a complaint, and then they sent a letter to you telling you that they apologize for not citing these other reasons for withholding information.
Okay. And the second question I have. No, that's it. That's all I got. Thank you. All right, members, anything else for Q&A, discovery at all? Okay, great. Should we move to rebuttals? Okay, let's do that. So respondent, Mr. Cote, you have 3 minutes for rebuttal.
Thank you, Chair Wolf. Specifically to Member Schmidt's question, I would point you to the case that I cited earlier, which is the Los Angeles County Board of Supervisors versus the Superior Court, when we're talking about the issue of the number of, whether the revealing the number of documents. And in that case, the Supreme Court reaffirmed that the attorney-client privilege attaches to information in billing records that, and I'm quoting from the ruling here, that, quote, informs the client of the nature or amount of work occurring in connection with a pending legal issue, okay? So disclosing the number of privileged records, giving a number, reflects the nature or amount of work in the same way that a billing record would. So if you just follow this to its logical conclusion that, clients would be reluctant to contact us if they or we had to report how many times they had asked questions concerning specific keywords, which is what was being requested here. So our office would have to censor itself from sending, quote unquote, too many emails to client departments, or from writing, quote unquote, too many legal memoranda, for fear that the document count could convey an impression to the public that we perceive there to be a legal risk. So clearly, under established case law, the attorney-client privilege extends to the number of documents, and that is not required to be disclosed. I would just kind of go on to point out that, like, it's unfortunate that we're kind of here to begin with, and if Anonymous, and let's just take a step back. Like, what's happening here is Anonymous is just weaponizing the process and trying to drag the Sunshine Ordinance Task Force into it. He could have simply asked us for questions and clarifications about the redactions on the production that we produced after he was inundating our office with requests for records. And if you want specifics on all of those requests, I am happy to provide them. But instead he didn't. What he did was then just file a complaint, and and here we are. So I'll leave it at that.
Okay, thank you. And Petitioner Anonymous, you have 3 minutes.
Thank you very much. So I'll begin with the 6721C issue. Let's say you take Mr. Cote's argument and you agree with it. Remember the quote. It is about the amount of work in pending and active legal matters. So then they would still have to disclose the amount of work in non-active matters. Something should be disclosed here, right? And they could say, okay, we have 50 emails from legal issues that are no longer pending and active, and and then we can't tell you the other ones. But this is important. I think it is important that you decide, and you may rule against me on this. It's a pretty close question, whether or not whether or not you're allowed to know how many records they're withholding. And I'd urge you to consider that with some thought. I want to get back to this weaponizing issue. I've been very clear to the city that my goal is to bring the city up to snuff every single department. And other departments, when I bring these kinds of complaints, they change their procedures, they change their training, and then the next complaint, the next thing I say, hey, yeah, they do start redacting their giving keys for redactions. But for whatever reason, the city attorney office doesn't give keys for redactions. And this was just one of the complaints that came, that I was able to bring here. I would like to just remind you on page 1313, which is P89. There is no way for me to know why the word after now Nevada is redacted. I don't have to guess, and you've held this many times. It's not about what I do. The law requires the person supervising the redaction process to do this as part of the exemption process. It's in 6726. That's my problem. That's why I bring these complaints. I want the city attorney's office to follow the full requirements of the Sunshine Ordinance. They have every right to give me a rolling response and say, hey, we can only produce 100 pages to you. They're properly produced with redaction keys and everything, and the next week we'll give you another 100 pages. They are totally fine with that. I did not even complain about the timeliness of that. That was never complained. It was about the statement. It's about the fact that they don't provide these keys. And you heard the other complaints. The other departments have begun doing this. The city attorney's office has to do this. They have to tell you when they respond to you, and as part of the process of doing redactions, which redactions are justifiable to which justifications. And they have to do that to every response, to every public records request, because that's a part of the Sunshine Ordinance. And so that 6726 thing, even if you don't agree with me on the 6721C issue about the quantity of privileged records, this is really important. And you heard this in many other cases, that they just don't think they have to do this until after after I file a complaint or ask them. That's not it. You've even heard this against city attorney. I don't have to ask questions. It's their obligation to just do the keying so they know what to tell me when they respond to my request. Thank you very much.
Okay, members, deliberate, and if there's something to take action on, make a motion.
Let me just start with a statement which I feel like, since I'm the one pending attorney member, I do have a thought on the last of those issues. But basically, my my leaning on this case is that I pretty much, with one exception, I pretty much agree with the position of the complainant. And I certainly don't buy the idea that he somehow did anything that he shouldn't do in this situation. So that would indicate my leanings in this case, with the one exception that I'm sympathetic, and I probably would tend to rule in this way, in that I think that the amount of communications, the page numbers, etc., I would feel like if I knew which cases my opposing attorneys were spending a lot of time on and which ones they weren't spending a lot of time on, would be of immense strategic advantage. And I could interpret a lot out of that knowledge. And so I do think that it's pretty hard for me to think that amount of communication between attorney and client is not something that is outside the privilege. So there's my thought on the case.
Any other discussion?
I'll say I'm kind of where Member Schmidt is.
Okay. Member Lloyd?
Yeah, I have a comment about what was, I think, sort of a tacked on comment, but I just want to say this on behalf of the task force. And, you know, I think we try to be dispassionate about upholding the Sunshine Ordinance. We don't care why people are making requests or filing complaints. We're here to make sure that the ordinance is applied fairly on behalf of members of the public. At the same time, I think, of course, we can be sympathetic to city employees about how much work this creates for them. We get it. And we support their efforts to reduce the amount of work by cooperating with people who make requests and even seeking assistance from the task force. But I think it's important to remember that when people are asking for information, we're not saying, why are you asking, or is this a worthy request? And in that sense, I don't think it's fair to, I think we need to recognize that all members of the public have a right to ask for this information. And I just think it's important to say that.
Okay. Anything else? Or got any thoughts about forming a motion or not?
Want to give it a shot, Member Schmidt?
Yeah, sure. I think that as you can see, that I would make the motion based on the first two grounds, which are that we find violations in terms of the untimely response and the failure to specify the various grounds for withholding.
So 6727 or 6726?
Yeah, that sounds good to me. Those numbers sound good to me. I'd just go based on, pretty much down the line with the way that the request was made by Anonymous on those two aspects, not the aspect that I would not include in the motion, which is the time records or the page numbers records.
And the keyed redactions.
So it looks like the first two is 6726 and 6727.
Yes, 26 and 27, exactly. Those, both of those.
Sure, I'll second that.
Okay, so, but it'd be good to give a little narrative as to why 26 and why 27, just for it, so it's in the order of determination.
Sure. I'll suggest some.
Go ahead.
Right. We'll do this jointly.
Sure. Okay, I would say 6726 for not keying every redaction, and 6727 for not providing a complete list of written justification to the complainant in the initial response.
Okay.
Precisely.
Okay, so Member Schmidt, you move that?
Yes.
And Vice Chair Yankee, you're seconding this?
Sure, yes.
Okay, great. Okay, so the motion on the floor is to find a violation of 6726 for not keying redactions, and 6727 for not providing justification for those, correct?
I think you meant a complete list of justifications, because I thought that was part of the argument that some of them were provided.
They weren't provided in the initial response.
Right, initial response.
Folks, the discussion is with us, please. If you have concerns about that, then let's have the conversation. It's between us, so please. So 6726 for non-minimal withholding based upon not keying for not keying the reactions, and 6727 for not providing written justification. Is that correct?
That's correct.
Okay. Okay. Members, any other discussion? Okay, let's go to public comment. This is a public comment for members of the public other than the parties or the witnesses. Please unmute yourself. It's *6 if you want to provide public comment on the motion.
Public comment?
Go ahead.
Actually, I'm just trying to figure out where you are. You're still on item 9?
We are on item, we had a little adjustment. It's, this is item, on the agenda it says item 8, but we had some switching around, so it's considered item 9. It's file number 19120.
Okay, and you're still going to handle items 10, 11, and 12?
Yes.
Great. That's what I'm looking forward to. Thank you.
Okay, great. Okay, any, seeing no public comment for the motion, are we ready for a vote? Please call the roll.
Member Schmidt?
Aye.
Member Schmidt, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Wong?
Aye.
Member 1, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to find a violation of 6726 for not keying redactions and 6727 for not providing written justifications has passed.
Sure.
Okay, thank you.
Member Highland here. After you read the next item, can you try muting? Because I think it's your channel that's providing all this feedback or the static.
All right.
Yeah, it's really bad right now.
Okay.
Okay, please call the next item, and thank you parties for hanging in there so late. Let's call the next item.
Item number 10, recommendation from the Complaint Committee regarding existing new complaint form and a revised complaint form submitted by SOTF Administrator and another by petitioner. I attached not only both forms, as both of them had revised them since the complaint committee met, but I also included the forms that we currently use so that everybody has a point of reference.
Mr. Chair, would you like me to?
It's all yours.
So, as a little bit of background, I'll keep this very brief. We had Anonymous submit a first draft complaint form a few months ago, I think.
Fiona, can you hold on a minute? Cheryl, can you mute yourself, please?
I am.
Thank you.
Yeah.
Okay, go ahead.
So Anonymous submitted a first draft of a complaint form that he devised they devised rather, in October and November. The complaint committee looked at it. We thought it was good for a first draft. Our administrators thought that it might be too intimidating for some people that may file, that are first timers and might not know the ordinance. So we had our administrators and Anonymous prepare a second draft, which we looked at at our December meeting. We looked at that and we decided to recommend to you that we adopt Anonymous's second version. And Cheryl, has Anonymous done another version since then, or is that the one we looked at in September or December?
Last month, yeah, it's the one we looked at last month. What I did do was eliminate the first paragraph as requested by the complaint committee underneath the first title. So I eliminated that, and then I just, fixed some formatting and things like that.
Right. So what we have for you is our recommendation. We're happy to take any questions, and I'll close by thanking Anonymous for their yeoman's work on it. We think it will be a very valuable resource for the public. The one thing I will say is we wanted to make clear that they didn't necessarily have to use this form. It was more of like an optional thing. So that's our sort of high-level summary of things. I'll turn it back over to you.
Chair Wolf, may I say a few words on what I did with the form? Mute.
Sure, but before you start, can you tell us what page we're supposed to be looking at for which version? Is it PDF page 6?
I believe it is page number. It's after page number 2062.
It's not.
Right.
It's not printed at the bottom of these pages.
It was a late edition after I made my adjustments.
I'm not sure that we have that, but I'm looking at the one
page 2062, and then the complaint form is immediately after that page number.
I see, 2062. Okay, got it. Thank you. I got it.
Page 5.
Go ahead.
PDF.
Yeah.
So I didn't actually touch the instructions yet, but on the form itself, I deleted some information that was not needed. There's a request for 2 different names of a department, the name of the department and name of the custodian. I tried to simplify it. So it's just identify the city department and or employee. And I believe there's another version somewhere. But I also deleted the question regarding, do you want to have a hearing or not? Because we have hearings on everything at this point in time. And then I also noted under the contact information, I just put in a note that says communications are normally provided via email. just so we try to push people to provide us an email address for our contact purposes. And then in the body, going along with the point that we don't have to use the additional forms, I put in under the please indicate the alleged violation of the Sunshine Ordinance. I put in see page number for descriptions of common allegations, so that they can go to the checklist and look at the common issues. Also note that I don't have anything for public meetings. All we have is the checklist for public records. And then we get into the next page right after the complaint form is Anonymous's form that he provided. I did a strike through of items that I thought would be too confusing for members of the general public as being a little bit too nuanced or something that they may not understand. And I left them in there, but I did a strike through of items that I thought would be a little bit too complex for the everyday person to understand. And then instead of using custodian of records, I use department representative. I believe that's the majority of what I changed on these forms.
So Victor, this is Chris. So all the strike-throughs, are those yours or is that the committee's?
This is the form provided by Anonymous, and the strike-throughs are things I thought could be struck through and still be usable.
What's the version?
The one? Yeah,
that's what I want to know.
yeah, the version from the committee.
Where is that? Is that at the bottom?
I think the original version is like at the top, the first one. Is that it? I believe that's the committee's version without the strike-throughs.
Yeah, the strike-throughs are Victor's.
Yeah, so page 2060.
Okay. All right. So I'm having a reaction to department representative because it's not the department. Department representative is akin to if somebody's making a request to a department, an office, a whole commission, an agency, an entity. The Sunshine Ordinance is specific to custodians. In addition to that, it provides that additional feature of being able to request information directly from a custodian. By using the word department representative, that is akin to presentation in a hearing. And here we're talking about filling out this form based upon what happened before the hearing. So there is no necessarily representative per se. If a department's process is city staffer, if you receive a request for information, request for records, a Sunshine request directly to you, send it over to our PIO department, and somebody from the PIO department will contact that person. That's one way to do it, or they have a direct responsibility to respond to the requester directly. So I think the custodian is the custodian is the custodian. If it's assigned to somebody else to provide the documentation, whoever is being asked of in the request, it's still the named custodian. And I think that needs to apply. Sorry, long answer.
I believe that would be okay, but we would need to put in a description of what a custodian is. It's just, if you just put in the custodian, the person who has not dealt with this before would not know what that means.
Victor,
we need to put in some kind of description of what the custodian is.
Could I ask another question? in Victor, in your knowledge, when a information request comes in, sometimes any member of the department may pick it up and run with it, or do they all turn it over to the custodian? What's the percentage?
My general practice is, the individual's employees can respond, but we will always notify the custodian so that they can keep track of everything.
So you see. Okay.
I think that's a wrong way to think about it, Member Highland. I think it's not a matter of what the general practice is. It's what the ordinance requires. That's right. What this is. We need to maintain some fidelity of what the ordinance requires. If you don't like custodian and I don't like departmental representative, then just say, did the person or the department provide you with the records? Just use who the actual nouns or pronouns.
Why I asked that question, Chair Wolf. It's because, if we make it, if you put the word custodian in and say all requests must go to custodian, that's fine if that's what the ordinance requires. But I'm just trying to see in practice, allow anyone to help someone asking for a records request. I don't want to break that down by putting that on the form. That's the balancing act I was trying to find out about. That's all.
So let's take it from an education perspective. We have an obligation to educate the public about how the law is written. So having even a definition of what custodian is, maybe that is an important factor, and maybe even stating it. It's just one sentence from 6721A. You just just make it like, is that just part of it, whatever the definition is?
Yeah.
I think that's important.
Yeah,
people to know what the nomenclature is.
Right. Every department has custodian records. That's the appropriate person to request information from. Make sure you have that person's email, contact info before you file this form. That's not unreasonable.
Every person who possesses a public record is a custodian. Every person. Well, it's not an assigned person in a department. That's been the practice, and that's what we're kind of have to go beyond. And it's kind of a new practice in the past 5 or so years that people have been departments have been directing and funneling all those requests to an individual department or person. So requests can be made of any person in the city that possesses that record. So that's the custodian, whether it is a person, an entity, a body. So I would just say be explicit about what this is. That's my suggestion. I would offer that as an edit. Let's move on to some of the other points here. So the second line, first line in the first box on PDF page 7. Did they give you access to records in the way that you asked? So, Victor, why did you strike those 2 sentences?
My feeling was this is getting into too much detail that will not apply to the majority of the people. I was trying to keep this simple and to the point, and not overly complex.
But the context of that first line, did they give you access to the records in the way that you asked? If you asked for, it's kind of like what we've been dealing with. If you, for sake of a better example, if you asked for an email with all the metadata and it didn't come with that,
My feeling is that they did not respond in the correct fashion or a timely manner. It's just one more detail that.
But where else then this question must be placed somewhere else in the document. Because if you asked for records in its original format and didn't come to you that way, I think that's, if you can answer it by yes or no without having to give a complicated narrative answer.
That's your discretion on this one. It's just,
okay.
My feeling was it's a matter of did they provide the document or not? And we would get into details under the description.
Okay. Members, what do you think about that? You want it in or out?
I mean, I would say that most of our petitioners, they just want the document, right? They just want whatever. Although format could be a thing for some people, but I guess they could elaborate on it somewhere else in the forum, possibly. I don't know.
Well, here's the thing. The way you look at this form is they don't really have to check off or answer any of these questions in any of these boxes. Because if you look at the first column, the column says check here if this right was violated. So if they can't answer any of the more detailed questions, just put a check in the first column box. And then we'll get it clarified later at the complaint committee. Okay, I mean, I think this is kind of like the first column is kind of macro and the second column is micro. And if they may not understand every single question, but by the same token, we have a lot of people that do understand the ordinance pretty well. And these questions at the same time, I think, will help narrow things down. So when it gets to the complaint committee, it's a lot easier to kind of pinpoint what's going on. Just my sense.
I also wanted to point out the title of this that I changed. I changed the title of the checklist to worksheet and common allegations. Sorry, worksheet, common alleged violations. I changed the title of the document so it's not a requirement, and it's just kind of a checklist. I would like to get your opinion on my wording in that first paragraph.
I kind of like that, Victor.
Yeah, I kind of like calling it a worksheet. I think it's a good word.
Yeah, I agree with Fiona.
Yeah.
I see it as kind of a way to help someone through it, but obviously it makes clear that it's not necessarily a requirement. So I like that.
Yeah.
Yeah, it's fine. I'm okay with that. All right. So 1, 2, 3, 4. The fifth row down. Department rep, blah blah blah. Can redact relevant information. Oh, I'm sorry. Member Yuang?
No, this is Lila.
Lila. Okay. Go ahead, Lila. And then Member Wong.
Yeah, I have a comment on that one. I think we need some preceding text because right now, when you say can only redact relevant information, relevant to whom? I think we need to say the Sunshine Ordinance allows certain kinds of information to be redacted. Or something like that. Otherwise, it's relevant information, meaning they're allowed to hide whatever they want because it's relevant, or is it relevant to the requester? So I think we need to specify that the Sunshine Ordinance allows certain kinds of information to be redacted.
Okay. Good note. Member Wong, sorry, go ahead.
I was just going to agree with your earlier statements regarding having as much information as possible given to complainants. I think they can either check it off or they don't have to. And then if they don't know what it is, they can hopefully learn from this form as well. And then I also agree with Member LaHood's statement of clarification.
Okay. Anybody else? We'll move on. Then we'll go to the 7th row. Custodian cannot charge you for any fees for the personnel costs of your records, such as for searching or redacting records. Did the custodian demand or charge any fees other than the cost of copying? Victor?
I've just never had this issue come up before myself, and we can leave it in. That's no issue to me, but I just never seen this complaint come up before, and I don't consider it common.
Yeah, the last time I remember something like that was when it was either the assessor or the planning department was charging for the maps. They wanted to recoup their costs for creating, these, the parcel maps. And we found that to be in violation because the ordinance only allows you to, they weren't creating a new document. It was something that they already created. They just paid lots and lots and lots of money to have it created, but they could only really charge for the medium that they were copying it to, which was a CD or a DVD at the time. And since nobody really uses those anymore, I don't think we've had a case like that since. So, yeah, it can stay or go. It's of no consequence for me at least.
I guess if these are common allegations and this one's not common, I would vote for taking it out.
Okay. Does that seem consensus with everybody? Okay, so we'll leave that. We'll leave that. We'll take your edit.
Take it out.
We'll take it out. The next one is 8, 9, 10. Certain city officials must retain, not destroy certain records. Title of the official whose records were not retained. Attach copies of retention policies, if any, and proof that they did not retain the record. Explanation, Victor?
It's pretty much on the same line. Generally, all our records are maintained according to our retentions policy. And it says city official, which is more of elected officials. I just don't see this coming up that often again. And I can go either way on this one. It just didn't seem very common to me.
So we have had a couple of cases, not recently though, where there was some questions about retention because there are different retention schedules allowed for different, either different public officials, elected officials, and actual departments. And there are retention schedules set, I think, at the state level, but that can be overridden at the local level. I think there's just a lot of different there's a variety, and I don't know if there's a one-size-fits-all for retention at this point.
Yeah,
and for different kinds of documents, right? Something like that.
Yeah. I was gonna say we have had retention in the last couple years, so I would leave it in.
Okay. Anybody else?
I think to be helpful to the, let's say a first-time requester, maybe just a blanket statement like, most records need to be kept for at least 2 years. You feel a record was not available to you within that time, something like that, pointing in that direction rather than, just a general statement about retention. Something more constructive. And
Well,
the next,
again, it depends upon which record.
it does. That's why, I don't know if we can make a blanket statement like, or just say, records must be maintained for a certain amount of years. Did you request a recent record that you feel should be there that's not, just to see whether it's that kind of a violation? I mean, just kind of. And even the next one is not very user friendly. These are more sort of experienced requester, I think.
But that's why this is a worksheet and not a requirement.
Then these can be less common allegations or more complex allegations. It's just that we're moving into more, as Victor, I agree with Victor. These are more complex and may just not help and in fact scare off a requester. That's all. I think less is more in this first piece. That's just me.
Well, I mean, we have folks that really get into weeds of this stuff. If it makes it easier for us, for them not to have to get so detailed in an answer, and we can provide them with a yes or no question, it makes it easier for us to narrow in on exactly what their issue is. I mean, I know we spend a lot of time sometimes figuring out what a person is really trying to sometimes trying to find a violation of, or they think there's a violation of, and we spend a lot of time trying to figure that out. I think any ability to be able to kind of it's not so much anticipate, but anticipate a question that helps us get to the core point of what they might be asking for, where they might think there was a violation of, I think would be helpful. I mean,
like above, the section there on certain officials must record and provide a daily property calendar. That's beautifully written, very clear. Checkboxes are all relevant. That would help me as a first-time requester. But to read something like the custodian is required to disclose that, and then tells me to go review SF admin code, you've lost me already. That's way too detailed. I just don't like any of that verbiage. I see the point they're trying to get across, but that needs to be more simple, more checkboxy, if you like. I think. I don't know.
So in the third from last one, I agree. The verbiage of that is a little convoluted. I would say, for something like that, I think it's an important point to be made. It's like if you received a reason that if the custodian said, something like the custodian said that the record is exempt under CPRA, and you believe that it's not under Sunshine, please check here.
Yeah,
something like that.
Or
I think it's an important question.
Yeah, or for instance, city officials are required to maintain records. Were you told that a record was no longer maintained? Check here. I mean, could be as simple as that.
Yeah. And the last one is custodian must comply at minimum with statewide public records law. So, again, Victor, did you just find that to be too in the weeds, that one?
Yes, I did myself. If we're going to leave that in, there's no way we can cover everything, and we don't really have a description of CPRA. If we're going to list those, we need to give them a description of why those are exemptions. And
Okay. Right. So I guess, you know, part of this also, like, you know, Smith versus San Jose and the San Jose versus, you know, the San Jose versus Superior Court, that kind of thing. You know, those are now, you know, kind of the law of the land. And the ordinance has not been, you know, quote unquote, amended or updated to include those. So they kind of exist outside of the written ordinance, but we use it. It's applicable because it's now state law. So I think there, you know, if somebody, you know, files a complaint and says, I asked for, you know, these text messages and I didn't get them, well, where is there somewhere on this worksheet that I can fill that out and then click it, you know, have a checkbox for that particular kind of complaint or alleged violation. Something like that.
I believe the context needs to be clarified. We're listing code sections and types without giving a clear explanation.
Right. Enough context. Yeah, I'm not sure that this is fully ready for prime time. Plus, there's no section for the public meetings. Go ahead, number one.
Maybe we should just stick with public records to start, because public meetings is not a prevalent issue, or public records are the big things we deal with. Okay. Public meetings is a smaller percentage.
Member Wong?
I was just going to ask and also say, like, once we have this form and once it's up on the website, will we have like links off to parts of the Sunshine Ordinance or parts of CPRA? I think that would be helpful for providing.
If we create it as a PDF, you can always add in active links. It's just we will need to check them occasionally because all these other agencies keep changing their websites. And that is a problem recently where they changed their website and we don't know about it.
Okay. How about this, folks, before we take public comment? I'm just feeling that this is not, with some of the points that Victor made, and I totally appreciate that, and the reasons. I think now that it's in front of us, let's all take a look at this, and then we'll bring it up in the February meeting. And actually, we can also bring it up at the if we get new appointments by the end of the month, we can also bring it up at the orientation. We can get that scheduled before the February meeting, and we can have a little more time to muscle through it. But I mean, there's not a whole lot here. I think we can do a pretty good job in a month to kind of review it, put your thoughts in it, and bring it back to the table. Sound good?
We will go ahead and try to get a PDF or a Word version to everyone so that you can play around with it.
Okay, great. All right, let's take some public comment. I think we have some folks that want to contribute.
Public comment on item 10?
Absolutely, Speaker.
David Pilpel. Is it still Wednesday night? Sorry. Yeah. Good discussion. Couple of thoughts. I think the revisions to the form that Victor ran through, I think that's helpful. I wouldn't say on the form whether the form itself is required or not. I think it's kind of informative and a good cover sheet. I think the instruction page is still helpful. I thought there was a second set of instructions somewhere, so I would hope that. Sorry?
At the bottom.
Sorry, which? Too many pages. Which bottom?
Hold on. Page 10 of 15. It says.
Got it. Okay, so that's the filing a complaint page with the complaint procedures summary, right? Then
Yes.
the form itself has some information, and then there's a separate page. Let me see if I can find that in the packet here. Page 5 that has kind of a different spin on the role of the task force, and if you have a problem, I would try to merge the two narrative pieces so that you have one document that's like, here's what the task. This general thing is like general about the task force. I think the how to file a complaint should be its own document. The form is a good one-page form, and then this new checklist thing, I would make very clear at the top that that is entirely optional. It's totally helpful for those people who choose to use it, but it should not be required because it can be entirely intimidating, and it suggests all kinds of things that people may not have considered. Maybe they should, maybe they shouldn't, but and it's not always relevant. It's really like a detailed analysis thing. So I would again make very clear that that's optional. Also, for me, significantly, the first checkbox there where it says check here if this right was violated. We don't know that the right was violated. Maybe check here if you believe this right was violated, right? Or if you're alleging this right was violated. I would start with those things. I would make some of the changes that you suggested and go through another version. I think this is a good effort. I'm not sure if this is too much, too little about right. I want to think about that some more as well. Again, it may depend on the requester and the nature of the situation. Let me leave it at that for the moment and keep thinking. Thanks very much.
Any other public comment?
Yes, please.
Go ahead.
Hi, this is Anonymous. Excuse me. The person who wrote the first draft of this form. So just to remind you, the motivation for writing this was that members of the public came to this task force a few months ago and said that, one, they weren't clear what, some of them weren't clear what the rights and responsibilities were under the ordinance. There was a discussion that you don't get memos anymore, and so someone has to provide the structured information so that you can make an analysis. And so my thought was, why not have the complainant do that and also have the complainant learn something in that process? I very much agree with the previous commenter. These forms absolutely should not be required, and that's because no form is required. A person can make a complaint in any form, and they should not be limited in any way by the structure of the form. I just wanted to point out something on page 9, which is 9 of the PDF. So I don't know if there's any comment about this. This was added due to feedback by, I believe it's member Highland, about that, you'd want this kind of timeline. So I don't know if anyone commented about this, but if this is something you guys want to change, I just don't think this section was ever looked at. So please do consider whether this is something you want there or you'd like it to be modified as well. Thank you.
Any other public comment? Okay, thank you very much. Yeah, I like the timeline of events. I think that is always really important because when people are testifying, sometimes they tend to bounce around because of the way the dynamics of the case is moving for them. in their experience. So for us, we want to have that pretty definitive. So that really helps a lot, I find.
I agree.
Okay, so why don't we do that? Why don't we sleep on it a little bit more? If you think of some other things, some of the items in the checklist, if you think that they're too arcane, or they need to be, have easier narrative, or easier, a more understandable questions. I mean, we do have to, as most government documents require, to be written at a grade 8 level. So you might want to use that as a litmus or baseline. And then we'll bring it back in February, or the orientation. Okay. Great. Let's move. No action on this item. Let's move to the next item. Administrator Leger. Cheryl.
I forgot to turn off the
Mute.
Yes. Item number 11, report from Vice Chair Yankee on the letter sent relating to file numbers 19048 and 19092.
Okay, take it away.
Okay, I'll try to be real brief on this. I think if you look, you can see as part of the attachment the letter I drafted and we sent to the zoo, and we received a response back from, looks like Ed Poole, who's with Zoological Society, and long story short, it doesn't look like they intend to comply with our order to turn over these records to, I believe Mr. Barker was the petitioner in this. So I believe our last motion talked about sending this on to ethics if we didn't receive a response. Obviously, we received a response here. I don't know if ethics is still where we want to send this, if we want to send it to the DA, or if there's any other ideas that perhaps maybe compliance amendments wants to talk about. But that's kind of where we are with it. So I'll leave with that and see what everyone thinks about how we should proceed.
Public comment when you're ready.
Bruce, you're muted.
The December 14th letter, that's the response?
That's the response to it, correct.
Okay. All right, and you're content? Are you still making a recommendation and contending that they're still in violation of our order?
Yes. I mean, I believe that there's, I don't think anything's changed. I don't think that his response changes anything that we've already heard up until this point. So I think at this point, we need to decide what additional enforcement actions we're going to take. Actually.
Okay. So I would urge folks to look at 6721F. I think this is a good case for that. What do you think? I don't know if anybody had ever noticed this one before.
You're on, I'm sorry, 6724.
6721
21.
F. 21F is in Foxtrot.
I think did we discuss this section at a recent meeting, or was it a recent compliance and amendments meeting? I don't recall.
Compliance and amendments. And then we brought a recommendation at the last meeting to the task force.
I mean, I think this would be perhaps a good place to try this. I don't know if, the task force can be the one to initiate the turning it over to the Superior Court, but I'm not sure if the Ethics Commission would really have much jurisdiction over the Zoological Society, so I'm not sure that would really get us anywhere. I'm not sure if the DA's office is going to pick this up. So I think I think at this point that makes a lot of sense, because there's a lease agreement out there. It's signed. It has a clause talking about the Sunshine Ordinance. I mean, I think we've all decided that extends to the zoo. Obviously, they don't agree on that, so this, to a certain extent, almost strikes me as a contract dispute, and I think the Superior Court is probably a very, good place to have that go to have it resolved. So I guess my question would be, what role, if any, do we play in moving it to that venue?
Well, that's the point. I mean, there is no specific kind of directive or guideline as to who does that. It's just a statement that the Superior Court shall have jurisdiction to order compliance. So, in the same way that we make referrals to either the DA, the AG, or the Ethics Commission, we just make the referral. And then, however, it's up to them to dispense with it in the enforcement authority that they have, either given to them by authority of their office, or by authority of what the law provides them, either in the CPRA or the Sunshine Ordinance. Member Schmidt?
I can say that it would just end up in their garbage can. The court has no interest in doing something that they wouldn't even know what it is. It's like, why are you giving this to us? They take, lawsuits. That's what they do. They do lawsuits. They don't take administrative referrals and do anything with them. So I mean, even if someone said, well, there's this local ordinance that says that they can, that you have jurisdiction, they're not going to do anything. It would just be kind of like it really wouldn't end up being anything other than paper that goes in a garbage can.
Member Schmidt, could the task force potentially then file suit? I don't know if that's something we could do. I mean, to go through the more formal process, like you said, since that's what they look at.
Well, my answer is yes and no. I mean, technically, just about anyone can file a lawsuit, but I don't think that just as an initial impression, if that would be the task force as a plaintiff, that's one thing. And I think that's the only way that would happen. I mean, they can't file it on behalf of someone else. And the task force, I don't know if the task force is in the business of being plaintiffs. And I don't know if it's a proper plaintiff, because I think the only proper plaintiff here, and I'm not giving you like what the city attorney made research version of things, but I think the only entity that really can be a party to litigation is the city itself. That's just kind of my off chance guess at it. And I really can't imagine the idea that the task force would somehow try to enforce something at the Superior Court through some mechanism. That just, I can't even fathom how that would happen, what that would look like.
So, for me, I'm not so concerned about what the court may or may not do. I'm more interested in what the task force, what avenues the task force has. Now, we already know that we have the ability to send it to the DA. We've done that. I've had meetings with the DA, and I keep getting the same response. There's no criminal infraction or violation here. We don't take on administrative actions, which is actually not true. And state law directs the DA to take action in the CPRA, or provides authority to adjudicate CPRA issues. But you know what I mean?
Was that a question, or are you still going?
No, it was part. If you can respond to it, I was making a statement.
Oh, okay. I know there's the idea of referral to the DA, and I mean that's a different issue. But I mean, look how well that goes. They don't do jack, and so it's not like the Superior Court is gonna feel sorry for the task force and say, well, since the DA won't do anything, the AG won't do anything, we'll do something for you. Superior Court's not going to take any interest in something like that just because of the fact that their name appears in a local ordinance.
But by the same token, if a member of the public were to take our order of determination to court, the first question out of the court is, did you exercise the local process? And for them, the answer would be yes. Here's their order of determination. And if the answer is no, they're gonna say, come back when you do. So here
I think we've talked about that issue before, and I don't see that as being. I don't think there's an exhaustion of remedies issue with regard to anything that happens in the task force. And so I think anybody who would try to enforce their rights under the Sunshine Ordinance could do it in court if they wanted to. The only reason that they go to the task force is it costs many thousands of dollars less than going to court. It's free. And it's supposed to take a much shorter time to go to the task force, and it probably does, than to go to court. But you don't have to go to court and say, well, I already went to the local agency in this situation. I just don't think that's an exhaustion of remedies situation like, for example, in discrimination cases where you always had to get a right to sue letter from the agency before you bring your case.
Okay. So let's go back to how should we dispense with this?
I think that we're at 11:20 tonight. I think there's a complicated, matter about exactly how we want to, assert a enforcement mechanism. I think it probably deserves either, just that topic in general of enforcement. What other options do we have available? Either probably deserves further discussion at CAC, or maybe as an orientation issue. This being, perhaps the first test case that we do, but. I think it's a pretty complicated issue, and I'm not sure we'll make a lot of progress on it at this point. So I guess I'm thinking perhaps we agendize some type of further discussion on enforcement for a future meeting and use this as the, example case for to lead that discussion.
Okay, before I open it up to public comment, I'll just suggest that you maybe take a look at section 6730 C, the fourth sentence. The task force shall report to the Board of Supervisors at least once annually any practical or policy problem that in other cases where there are egregious issues, come budget time, the Board of Supervisors uses the power of the pen to make their case, because they cannot give directive directly to administrative departments. They can at least, use the carrot and stick of the budget to do that. So let me open up public comment so we can get out of here. Go ahead.
Public comment?
Yeah.
David Pilpel. Okay, so aside from the question of the Superior Court and jurisdiction and referrals and blah, 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 let me go back to the zoo for a second. And I did not hear this original case, but let me assure you, this is not a new issue. This issue precedes the first meeting of the task force, and the 1993 Zoo Lease and Management Agreement was being put together at exactly the same time as the ordinance was being written. I think the December 2nd letter authored by Member or Vice Chair Yankee is right on. I think the December 14th response from Edward Poole is off the mark. The Joint Zoo Committee was created for a separate purpose. The Zoo Society is required to provide operating records related to the zoo in the same manner as if the zoo were still being operated directly by the city. That's very clear from 16.2 of the agreement, not a new issue. If you haven't yet gotten a response from Phil Ginsburg or Rec Park, I think that would be useful to try to obtain, whether from him or through the city attorney. It may be useful to ask the city attorney to weigh in. I don't know if the petitioner sought a supervisor of records determination. That might be instructive / entertaining. I might also suggest pursuing Tanya Peterson, who I believe is still the executive director of the zoo and the Zoological Society. I believe she's a lawyer and either does or should have familiarity with the agreement and what it means. And for a potentially helpful and slightly off the wall suggestion, I would perhaps go to Jim Lazarus, of all people. He was, I believe, the executive director of the zoo at the time and was very much in the middle of all of this and may well recall what the understanding was of this particular section. So those are my suggestions. I think the task force is on the right track here. And I don't know what records were being sought, but so long as they were operating records that weren't going to how the Zoo Society operates and proprietary this and that and fundraising and da-da-da, but we're actually operating records relative to the zoo, then they should be disclosed in the same manner as if the city were still running it directly. I hope that helps. Thanks very much.
Thank you. Appreciate your historical knowledge.
I apologize for that.
Okay. All right, members. How should we dispense of this? Should we refer it back to committee? You want to refer it to committee or what? Member Hood?
I feel like we have gone around in circles with this so many times, and we did try to get Rec and Park to respond. I think, as Vice Chair Yankee suggested, maybe this is a good thing for us to discuss at the orientation and figure out a clear course of action, not after we've been in a meeting for 7.5 hours.
Okay.
Yeah, I agree with Member LaHood. I think I think we need to have a broader enforcement discussion that's not after 11 o'clock.
Okay.
I think it's very important. I think it's a very important case. I think we need to give it that background that really puts us on a good path forward.
Okay. So we'll continue this at the call of the chair. Does that work?
Perfect.
Okay. All right. Thank you. All right. I'm going to skip. Let's skip 12. I have nothing else really to report. That's also needs to be a longer. Can't have discussion this hour for that. Cheryl, let's call number 13, but just the highlights, please.
Cheryl, you're on mute.
Thank you, Matthew. Item number 13, Administrator's Report, Complaints, and Communications. So I have my report. It was rather extensive. We got several communications. Let's start at the beginning. There is the list of hearings that we're going to have January, February, March that are already scheduled. We did get several new cases in December. Pending committee complaints, there was an increase because of the number of cases that came in this month, or last month rather. We received 4 communications from Anonymous, all dated in chronological order. I included the minutes from the complaint committee December 2nd and December 15 meetings. And the number of requests that came in were almost 300 emails between November 23rd and December 24th. So that's brief. So I have attachments for all this stuff. So if you want to look at it, you're more than welcome to.
Great. Thank you. Any questions or comments for our administrator or anything about those reports? Okay, seeing none, any public comments?
Chair Wolf?
Yes.
I just wanted to bring up the next Rules Committee meeting, which we will most likely be considering Sunshine Orange Task Force member appointments on this coming Monday, January the 11th. And if we hear those on the 11th, they will go to the Board of Supervisors on the 19th and become effective hopefully the day after.
Okay, great. And also...
That's January 20th, is that what you're saying, Victor?
Yes. Of course,
okay.
Pending oath of office and all the other paperwork.
And I just want to, well, we'll do it in the next one. Okay. Anything else on this item, members? Anything? Okay, great. Any public comment on that last comment? No. Okay, great. Let's move. No action. Let's move to the next item.
Item number 14, announcements, comments, questions. Ooh. Can you hear me? Oh, good.
I just want to start out by saying gratitude for our member and chair of the Rules and Complaint Committee, Fiona Hinsey, for her amazing work and representation here for the disability community. She was successfully approved and confirmed to the San Francisco Metropolitan Transportation Agency. She is now a full director on the board there, and I know that's going to be a lot of heavy-duty work. I've known a bunch of people that have been in her position on that board, and so she will be staying with us until we assure that we have a person with a disability But as soon as that happens, pretty much this is like her official last meeting. So we want to wish her well and wish you well, and thank you.
Thanks, everyone. Yeah, I think that's saying, we should the disability thing out. But it's been a pleasure serving with all of you, and I wish everyone well in the future. So.
Congratulations.
Thank you for everything. Thank you for everything you've done, Fiona. You've been great to work with.
You're welcome. Thank you.
Congratulations.
Administrator Victor.
Wow.
Well done, Fiona.
We'll miss you.
Well done.
Okay. Thank you again.
Congrats,
Any other announcements or comments, questions?
Public comment.
Yeah, go ahead.
David Pilpel. Absolutely agree about Fiona. She's fantastic. She's not going anywhere. She's, still going to be her, and that's great. Touching back to the previous item I just looked up, there is no scheduled full Board of Soups meeting on January 19th because of the MLK holiday. So if something does come out of the committee on Monday the 11th, unless it's listed as a committee report, then it would go to the full board for the meeting on the 26th.
Good to know.
We're here to help.
Thank you. Appreciate it. Victor or Cheryl, let's forward that information to Supervisor Ronan's office. Okay. Seeing nothing else, item number 15.
Hang on a second.
Finally.
Item number 15, adjournment. I have 11:34.
A motion to adjourn, please.
I think Fiona should make the motion.
So moved.
Is there a second?
Second.
Moved by Member Hensy, second by Member Highland. All those in favor?
Aye.
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 Opposed?
Bye.
We are adjourned. Thank you, everybody.
Good night.
Good night.
Thank you, everybody. Good night. Let's go read the news.
Yeah.
Exactly.
Well, let's
Hey,
not.
David, can you stay on the line for a second?
Oops. Sure.
You're still there.
Yeah.
Victor, is this something I should listen to too?
You can stay online. It's no problem. Can you stop the recording?
Yes, I'm going to do that right now.
If we're going to do this, is there a way to ensure that any
Nobody
other
else is
members
here.
of the